Martin?
Yes.
Good morning.
Good morning. Living man will make it clear. Living man, Eric Martin, a defendant, corporate entity.
Call case 23S00425, People State of Michigan versus Eric Martin. Allegations are that on July 11, 2023, Ypsilanti Township, Washington County, State of Michigan, on I-94 at or near Michigan Avenue, you did operate a motor vehicle at a time your driver's license was suspended or revoked. A misdemeanor carrying a maximum penalty of convicted of up to 93 days in jail, a $500 fine plus court costs, or both. Do you understand that?
Well, I do not understand, in the sense that I do not stand under the charges.
Yep. Count 2 alleges that on the same date, time, location, you did operate a motor vehicle at a time you did not have in full force in effect. Insurance is required by state law. Again, a misdemeanor carrying a maximum penalty of convicted of up to 1 year in jail, a $500 fine plus court costs, or both. And the third count alleges that on the same date, time, location, did operate an unregistered motor vehicle. A misdemeanor carrying a maximum penalty of convicted of up to 90 days in jail, a $500 fine plus court costs, or both. These are misdemeanor charges. You have certain basic rights. You have the right to remain silent and say on the record can would be using against you at trial. You have the right to trial by jury, the right to the assistance of an attorney. If you cannot afford an attorney, one will represent you at public expense. Should there be a trial in this matter, you'd have the following trial rights. You may call witnesses to speak on your behalf. You have the right to see, hear, and question any witness against you. You may act as a witness for yourself, or should you choose not to testify, the prosecutor may not comment on your refusal to testify. You are presumed innocent unless proven guilty beyond a reasonable doubt. Court's entered not guilty pleas as all counts. The public defender will address bond in these matters.
Assistant Public Defender, let me stop appearing with and on behalf of Mr. Martin, requesting a PR bond this morning, Your Honor.
Thank you.
Yeah.
I object to any representation by any attorney, as I invoke my right to a Republican form of government and Republican laws under Article 4, Section 4 of the U.S. Constitution. Meaning
my phone just kicked on to where I can hear.
Hey, hang on, Mr. May. I'll be with you in a minute. Okay. Court's noted the objection. The public defender is excused from proceeding further.
And that's just, yeah, not make it clear, not just as to them, nothing with them, you know, just them specifically. I'm saying any and all attorneys, because I do not give up my right to be sovereign as one of the people, as the U.S. Supreme Court said I have as one of the people, the right to a Republican form of government and to be sovereign. So that's why I say that.
Thank you.
Yep.
All right, Mr. Martin, we will set a pretrial hearing September the 14th at 9 a.m. via Zoom.
Is it so fast? Let me write. September 14th is September 14th. What time?
9 a.m.
9 a.m. And that's what's the title of that proceeding?
That'll be a pretrial hearing.
All right.
Prosecutor will be present for that hearing. We have any future filings you make with court, make sure you copy the prosecutor on. We have forwarded these for you as a courtesy, but if you make any future filings with court, including the ones you've already filed here, or in addition to the ones you've already filed, make sure you send a copy to the prosecuting attorney's office. Their address will be on the notice we'll send you, okay?
Okay, I have another objection here. I also object to a challenge of jurisdiction in this case against me as a living man.
You can make that motion in writing. Again, any motions made in writing be filed with the court and served on the prosecuting attorney's office, okay?
Okay.
All right. Did you receive a text message to remind you about today's court date?
Did I receive a text message for what?
To remind you of today's court date.
Of today's court date? Yes, I did.
Okay. Just want to make sure you're receiving those so you're getting that notice. We'll mail them to your address on record here too as well, okay?
Okay, yeah.
All right. You're all set for today, Mr. Martin. Again, September 14th, 9 a.m. Failure to appear for a court date could result in a bench warrant for the individual's arrest. You understand that?
All right. Well, I don't understand in the sense I do not stand under it, and I object to that because that violate my right against sovereignty and Article 4, Section 4, Republican form of government, and
All right, your objections noted.
And there's many other reasons too why I objected, because, you know, there's no jurisdiction here, under many other reasons.
Well,
Yeah.
as courts operate, you will need to file any objections in writing. I've instructed you on how to do that. So if you want to, submit those objections, just write it up and make sure you send a copy to the court and to the prosecuting attorney's office so they're prepared to address that at the next court date. Okay.
Yeah, so, okay. Well, one objection I kind of have with the prosecutor in the sense of, I will if I must under threat and duress. Oh, that's another thing I was going to mention. Now, I'm appearing here by special appearance, not a general appearance. And this is through threat and duress of, the arrest and all that, the normal procedure that courts follow. So I just want to make that clear. I'm not really consenting to, appearing here today. I'm not consenting, for future references to be held under the jurisdiction of the court and all that. And it's one of the legal authorities I use for this is the Michigan Constitution and the U.S. Constitution under the 13th Amendment right against slavery and to not be subject to involuntary servitude. That's one of the legal authorities I rely on to be subject to any arrest for the bench warrant, like you mentioned, or anything else that's, against my will. And just want to mention that.
You've made your record on that point.
Okay. Now, what was I say about the copies of the prosecutor? Now, I will if I must under threat and duress, but see, that costs money. And I shouldn't have to spend no money for my access to the court, such as by making copies. That just costs more money for me to, make the copies. So in that sense, I'm going to ask that that the court clerk make a copy and send it to them, so I don't have to spend money to make the copies, which I think violates my right of access to the courts. And as the U.S. Supreme Court said, was it Murdoch versus Pennsylvania? I think that was one of the cases I cite dealing with my other arguments. We don't have to spend money for the exercise of a right.
But you do. You would have to. Can I address that for you, Ms. Martin? If I may, I'll address that for you. Okay.
Go ahead.
Okay. So, if there's a finding of indigency and you need to fill out a form indicating that you're indigent, so you can find that form on our website. If you file that form and there's a finding of indigency, that's easy enough for me to say, then we consider that at that point in time. Okay.
Well, I'm saying in addition, not just, I know the normal indigency is normally a thing, but I'm saying regardless of the aspect, just simply because it's a right of access to the courts, it's not just limited to indigency. It's just period. I shouldn't, don't have to pay money for the exercise of right, period, regardless whether I'm indigent or not,
I hear you, but that's a process that we have under the court rules
Right.
currently. If you want to challenge the court rules as they are, there's a process for that, but we have to operate with what we have to operate with right now. Okay.
Well, the court rules is, like I said, just once again, and that's the final thing to say about it is under Murdoch versus Pennsylvania, U.S. Supreme Court, and I got the volume and page and recited to you already in one of the papers, in general, just the right of access to, to pay money for the right, to exercise our constitutional right, no matter what constitutional right it is, you can't be charged a fee, period. So,
you made a record on that point. Like I said,
right.
there's a process for it right now that exists. If you want to challenge the processes, you'd have to, to do that otherwise. But so again, your next court date will be September the 14th, and we're all set for today, Mr. Martin. You have a good day. Thank you for coming in today.
Yeah, you too. Yeah,
We'll call the case of the state of Michigan versus Eric Martin, case number 23-00425.
Assistant Public Defender Chinazi Kiriakin ruling on behalf of Mr. Eric Martin. Mr. Martin, could you state your name for the record, please? You're muted, sir.
I am first of all, I'm a living man that has a name similar to the defendant, but I am not the legal fiction corporate entity defendant with the all capital letters name. My name is spelled capital E, lowercase R-I-C, capital M, A-R-T-I-N. Yeah, so anyways, now this is a special appearance. This is not a general jurisdictional granting appearance. I challenge jurisdiction of this court as I did at the arraignment. I didn't mention a special appearance. I meant to. I forgot to do that, but I want to make it clear that I want to do that for the arraignment too. I'm speaking for that arraignment too. Just like no special appearance. And I am not aware of any contracts that I have knowingly, willingly, and voluntarily entered into
Mr. Martin,
any jurisdictional.
Mr. Martin, Mr.
Yeah.
Martin, do you hear me calling your name?
Huh?
You hear me calling your name?
I just heard yes.
Okay. I'm not certain what you're doing, but this is a pretrial and this does not go this way. So, first of all, my first issue is it looks like you refuse to have the public defender represent you. Is that what you're indicating, sir?
Yes, if any attorneys think they're representing me, they're fired. I will not take no attorneys because that would be giving up my right to be sovereign and to be a living human.
Mr. Martin, I heard you. I'm going to advise you of your rights and what you're giving up today. And then once you decide what you're going to do after I do that, we'll go from there. Clear?
Yep.
All right. So you have a right to have an attorney in this case. And in fact, this is a charge that involves a misdemeanor. It involves 1, 2, 3 misdemeanors at this point in time. Those 3 misdemeanors do carry jail terms, which is what you could get if you are found and convicted of these particular offenses. And I'm going to read those to you to make sure you fully understand that by giving up an attorney, you will subject yourself to the potential of those penalties and that it is not in your best interest to do so, but that is your right to do so. So I have to make sure that this record is clear. As far as driving while license suspended is concerned, that is a misdemeanor, carries a maximum penalty of 93 days and up to $500 fine. As to the other 2, those are a maximum of 90 days and up to $100 fine. If you are found guilty, you, the person, the entity, or any of you will potentially go to jail. Do you understand that?
Well, I do not understand it, and I do not stand under the charges.
Okay, well, you are charged, and you can say you don't understand it. If you don't understand it, then I'll refer you for competency.
Oh, I comprehend it, but I don't understand it, and I do not stand under the charges. I don't need no competency. I've been doing law 28 years. I know.
All right, well, you are under the jurisdiction of this court, and that is what we're going to do. So what else would you like to say today? What are you requesting with respect to this? Your options are, first of all, do you want to have an attorney or not?
No, I will not accept no attorney because that would be accepting jurisdiction court.
All right, you have refused to counsel in this particular case. I'm going to appoint the PD as standby. Secondly, do you wish to have this case set for a trial, or what would you like to do?
The case should be dismissed, as I pointed out in my.
Not be dismissed, sir.
I sent to you before. You should have it on your desk.
I'm asking you right now, do you want a trial, or what do you want to do?
The case should be dismissed, as I pointed out, because I was traveling by right. I'm the crime victim here. The cops should be charged in my case. I was traveling by right in my private property, my motorcycle.
Mr. Martin, I would just advise that you don't discuss the underlying case. You're scheduled for a pretrial. So in case you do want to set it for trial, you don't want to discuss any issues on the case.
Who's that speaking?
The judge appointed me as standby counsel.
Right. Well, like I said, any lawyers that think they're representing me, they're fired. I don't accept no attorneys. I'm
You have to decide whether I appoint standby counsel, sir.
Huh?
You do not get to decide whether I appoint standby counsel.
Well, you can point who you want. I'm just saying that, but in fact is, I fire any attorneys who think they're representing me. I have the right to speak for myself, to argue for myself, and that's what I'm doing. I'm not accepting no lawyer who's gonna then was going to be fraudulently assumed that I'm a defendant now under the jurisdiction of the court. I have the right not. That's why I'm not accepting that.
All
I
right,
am,
I'm going to set this matter for a jury trial since he is not making any determinations. Sir, this jury trial will be scheduled on October 26th,
Wait, hold on.
2020 for a final settlement conference.
hold on, let me write that down here.
And then jury
October-
selection will be November 3rd,
hold on,
2023 at 9 a.m.
hold on, I didn't hear you. You said October 26th is the trial date, right?
Final settlement conference is what I said.
Final settlement conference on when again?
October the 26th at 11 a.m.
Is that going to be Zoom?
Yes, it is.
Okay, now, now I have a question about, I had, sent a petition in for a hearing for,
Petitions are not recognized in this court and they've been rejected and you receive notice for that.
well, that's not, that denies due process of right, that denies access to the court.
Okay, thank you. Jury selection in this case will be on November 3rd at 9 a.m., sir. You need to be here in person and ready to go. Bond is continued. Next case.
I am the living man. It's been, I'm not a, I'm a living man known by the name of that.
Sure. So listen, for purposes of communicating with you, I'm going to call you Mr. Martin. I can clearly see that you are a living man because you're talking. Most dead men don't talk. So,
There's a, you know, there's,
Mr. Martin, this is case 231510OT, people of the city of Taylor versus Eric Martin. Today's the date and time set for your motion for return of moped and also a motion to dismiss the cases. This is your motion, sir. Go ahead.
what, have you read the motion already?
Yeah, I've read the motion. I'm just asking if you, are you standing on, are you just going to stand on the motion that you filed, which is fine, you can do that. I was giving you the opportunity to make oral argument if you wanted to.
Right. Well, just, first I want to say on the so-called charge against me, I am entering a special appearance. Okay, that is in no way a general jurisdictional granting appearance. I challenge the jurisdiction of this court. The contract that I have knowingly, willingly, and voluntarily entered into with this court that grants any jurisdictional authority over me as a living man. If there's any such contract with the court, I demand the court present it. I also want to say I'm here by threat and duress. I'm not here willingly. You know, like I said, threat and duress, the normal. If you don't show up, arrest warrant, etc. Now in response to what to say about the motion. Well, as again, as a recap, okay, my motions are all based on my yeah, and the reason, first I want to point out the reason I don't like using the word motion, because I know that tradition, you know, I use the word demand, because it's based on the Constitution, right? You know, my human rights. So how I've been taught in the law, these are the words I like to use. If I use the word request motion, you know, that's not right, because you request privileges, you know what I mean? You demand rights. That's how I've been taught. So that's how I learned. So I just want to say that, you know, so, you know, I don't want you to take it personal or nothing like that. Hopefully, you know, it just demanded my rights. But I want you thinking, you know, hey, I'm the judge here, you know, who are you to demand? But it's demanded rights. But anyway, so again, it's based on my right to private property, my due process, which is in the due process of the Michigan Constitution. No state law that they are trying to use, have wrote up about it, justified my Constitution. And to do is try to use state statutes, unconstitutional state statute law, but that doesn't justify my private property. It didn't justify depriving me of it then, and not continuing to deprive me of it now. I do not need to pay no money for it back from the towing place. But again, that's based on my constitutional and human and God-given rights to enjoy my private property. You know, and there's no injured party now in the case. I want to mention that too. So the plaintiff has no standing against these so-called criminal charges. There's no standing because there's no injured party. And I have a U.S. Supreme Court case on that, so I'll move to dismiss the case on that. In addition, which also supports why it should be given it back. They have no, because as the, you know, standing is a necessary, this is word for word, U.S. Supreme Court case called Rames. I may not be pronouncing it right. It's spelled R-A-M-E-S versus Bird, B-R-Y-D, 521 U.S. 11. Standing is a necessary component of subject matter jurisdiction. Then we go to another case. The requirement of standing, however, has a core component derived directly from the Constitution. A plaintiff must allege personal injury fairly traceable to the defendant's allegedly unlawful conduct. Okay, and likely to be redressed by the requested relief. That's another U.S. Supreme Court case, Allen versus Wright, 468 U.S. reports, pages 737 and 751, decided in 1984. So again, that's, you know, personal injury is required by the plaintiff. There's no injured party, meaning charges will to be dismissed, all of them, because all these three charges, nothing needs to be wasting the time to go to a jury for. All these charges, this cop wrote up board, it's undisputed that just by the nature of the charges allegation, that there's no injured party. No injured party, the plaintiff has no standing, and therefore they all must be dismissed, and that also further supports why my private property should be returned to me. And in addition to, like I said, my due process right. And I can't think of nothing else to say now. I reserve anything else to say, though, if anyone else has something to say. If there's any dispute that it's not my private property, I'd like to hear that. Yeah, and that's it for now.
All right, Mr. Greco.
Yes, addressing each of the requests here, which I believe are a motion to dismiss the charges and the return of property or wrongfully impounded moped. Your Honor, the defendant has been charged with driving while license suspended, revoked, or denied upon information and belief. And looking at the record, it looks like it's revoked. He was operating a moped June 11th, 2023 in the city of Taylor. When he was pulled over by the officer, he was unable to produce a license or if you are under a certain age, but up to a certain age, I believe it's 15 or above, you can get, if you don't have a driver's license, a special moped driving permit, but the charge is appropriate and therefore the motion to dismiss with respect to the charge should be denied. Number two, with respect to the impound, here we have a driver who's not able to operate what is classified as a motor vehicle under the motor vehicle code, this moped, and it's on the side of the road. We can't keep it there. He can't take it. He can't drive it. For safekeeping more than anything else, it gets impounded. At that point in time, Mr. Martin is able to go get the moped if he wants. Yes, he has to pay for it because it has to get taken into custody because we can't just leave it on the side of the road. There is an appropriate action that is not this motion to challenge the impound fees of the contracted towing agency for the police agency. This court has seen those many times before with respect to whether or not the fees are appropriate or if the taking is appropriate. In this case, it looks like the motion is for the taking that's appropriate because there has been no action or motion filed with respect to area towing and the fees that it is charging or was charging at the time that he may have attempted to take it. So we request that the motions be denied in their entirety.
I have something to say in response to that.
Sure.
Okay, now, so first of all, I wasn't required to have any license, as I pointed out in my demand for dismissal of the case, because as the federal statute I've mentioned, well, first let me mention the state statute. It defines a motor vehicle as one just mechanically drawn. The Michigan state statute is unconstitutional, and the definition is not complete because as the federal statute I cited, made by Congress, 18 U.S. 31 subsection 6 and 10, makes it clear the definition of motor vehicle by the federal statute is one mechanically drawn and used to passenger property for profit, which I was not doing. They do not have evidence that I was doing that. Article 6 of the U.S. Constitution is clear that federal statute that is named off is supreme law of the land, okay, right along with the Constitution, and also mentions treaties of the United States, is supreme law of the land. Therefore, it overrides their state law statute that they're relying on. Therefore, the state statute is unconstitutional. It's not a complete definition of it. And also mentioned the U.S. Supreme Court case that I cited also supports this definition of motor vehicle, something we need a license for or not. Because as the U.S. Supreme Court said in the cases I cited, that the people have a right to travel. This is a long recognized right. Constitutional under the Due Process Clause, the right to life, liberty, or property. That's one of the liberties we are entitled to. A right, not a privilege we need to request the DMV for as a public lawsuit to make because of this. So cops are relying on this and people start being harassed exercising our right to travel. But anyway, it's the right to travel. And they said specifically in the right to travel is as long as you're not doing it for profit, okay, carrying passenger property for profit, we do not need a license, registration, or insurance. The U.S. Supreme Court cases I cited, and there's many more that and there's many more exist out. Say the same thing. Don't need a license. The state statute is unconstitutional. And as far as paying a fee, I'm going to cite off a case right here. No state shall convert a liberty into a privilege, license it, and charge a fee therefore. Murdoch versus Pennsylvania, I relied on this case also. It's volume 319, United States Reports, page U.S. Supreme Court. You don't pay no money for the exercise of the right. You cannot be charged a fee, and you cannot convert a liberty into a privilege. But this is what's going on with the state statute. See, they're assuming everyone's driving a motor vehicle or not. See, there's a difference between a motor vehicle, which is just one used commercially for profit, such as a DoorDash driver, a taxi driver. That's when you're technically driving a motor vehicle.
No! No!
When you're not doing it for profit, which is what I was doing, going to Walmart or Joyride, whatever I want to do, go to work, that's not for profit. That is what's called traveling. And this is terminology from the U.S. Supreme Court themselves, along with other law I mentioned. It's called traveling in my private property. There's a difference, it says there's a difference how it's used. That's one of the legalese tricks. Whoever excuse my terminology, whoever the scumbags was that made this stuff, because I think it was intentional. It's an intentional evil plan with this legalese that's being used. So the average person don't know what's going on. It's a shame. And they're trying to use this legalese trickery terminology to violate people's rights and trying to convert them into privileges by using words people don't know what they mean. Yeah, but so basically, once again, sum it up, I'm all within my right to travel. It's stealing my personal property. The state statute cannot justify stealing my private property, which is why RECO should be representing criminal charges against the cop. Which I made to file the charges on the cop for this, and he refused. So it's like he's also shown his discrimination in wants to prosecute non-cops, but you don't prosecute cops. And also, finally, he did not, Greco did not, respond, and therefore waived his response to my no injured party, defense. So therefore we waived it, and I'm on that argument. And that'll be it now. I reserve my right to respond back to anything he may say that I haven't said already.
I've heard from both parties. Mr. Greco, was there anything further?
No.
So, Mr. Martin, through your oral argument and written briefs, you've raised a couple of issues. So let me address those seemingly in the order in which you raised them. So first off, let's talk about jurisdiction. Now, you argue that this court lacks jurisdiction over you.
Yeah.
Now, the question of whether a court has personal jurisdiction over a party is a question of law. And that can be stated in Poindexter versus Poindexter, and that's 234 Mishap 316, 1999. Typically, a plaintiff bears the burden of establishing jurisdiction over a defendant. However, a plaintiff, here the prosecution, only needs to make a prima facie showing of jurisdiction in order to defeat any motion to dismiss based on a motion to dismiss for lack of jurisdiction. That can be found in Jeffrey versus Rapid American 448, Mish 178, 1995. Before a court can obligate a party to comply with its orders or proceed to trial or do any of these proceedings, the court must have personal jurisdiction over a party. I think we all agree that that's true. Jurisdiction over a person may be established by a couple of ways: by way of general personal jurisdiction or specific or limited personal jurisdiction. Matter of fact, Michigan has two different statutes: a general jurisdiction statute and a specific jurisdiction or limited jurisdiction statute. So exercise of general jurisdiction is possible anytime that the defendant comes in contact with the forum state or the forum city or the forum body of government in such a way that the nature and quality are to enable a court to adjudicate any action against the defendant, even when the claim at issue does not arise out of contracts with the forum. Here, and if we look at the Michigan General Jurisdiction Statute, which is MCL 600.701, basically it states that the existence of any of the following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of the state to exercise general personal jurisdiction over the individual or his representative, and to enable such courts to render personal judgments against the individual or representative. And they point to three things specifically that I want to raise. One, presence in the governmental unit or city at the time when process is served, domicile in the city, and consent. Now, in the present case, Mr. Martin was physically within the boundaries of the city of Taylor at the time of the alleged criminal activity. When he was served with the ticket, the complaint. Second, Mr. Martin is also domiciled in the city of Taylor, which means he lives in the city of Taylor. The city of Taylor has ordinances regarding basically everything that the state does, and one of those is that you have to drive with a license. So I do find that there is personal jurisdiction over you. You availed yourself of the use of the streets here in Taylor. You live in Taylor and you were served in Taylor. Therefore, you fall under the jurisdiction of the Taylor court here, which is the 23rd. As for standing, now standing is a legal term that people like to throw around, and well, you don't have standing, this. Standing is a legal term which basically determines whether the party can bring a lawsuit or has a right to do so. Standing is not about the issues. It's about who is bringing the lawsuit and whether they have a legal right to sue. So if you are suing your government, if you have no damage, if you have no harm done to you, why are you bringing a lawsuit? Here, this isn't about harm. This isn't about a civil suit. This isn't for some violation of rights. This isn't a claim for money damages because you weren't allowed to live where you want to live or marry who you want to marry or some other form of federal type of a situation that's a constitutional based or a tort based thing. This is a governmental unit doing their job under the Constitution to enforce the laws of their cities and states. The standing that they have is that they can show by a preponderance of the evidence, they can show that there is a probable cause that you committed, that there was a crime committed and that you committed the crime in the city of Taylor. That's all they need for standing. That's all they need is that, and along with personal jurisdiction. We've already established that there's personal jurisdiction. So as to your standing argument, there is no standing argument there. As for abandoning the vehicle or impounding the vehicle, under Michigan Compiled Law 257.252A about abandoned vehicles, it specifically states a person shall not abandon a vehicle in this state. So if you are arrested or you are using something as the instrumentality for committing a crime, well, you have a right to a trial, but that evidence has to be preserved, and they can't just leave vehicles laying around on the side of the road. As Mr. Greco rightfully stated, it's for the protection of the evidence, and it's also for a protection for you because, well, you can't just leave it on the side of the road because I know it's hard to steal a car, but if a moped, someone could just pull up, throw it in the back of their pickup truck, and now you're without a moped. Then you might have a lawsuit against the city for not doing their job of having it impounded and protecting your vehicle, protecting your moped. So that's why it's taken. Your moped is in safekeeping, and that's what they're supposed to do. So under the abandoned vehicle statute, they do have a right to do that when there's a crime committed. So now that brings us to our last point about the fact that you think that there's an underlying reason why this should just be dismissed outright, just a general dismissal, because you have a right to travel. You do have a right to travel. Matter of fact, the right to travel is a fundamental right. And we can freely use the roads, since why? Well, they're funded by tax dollars. However, the privilege to drive a vehicle can be conditionally granted even, based upon being licensed, based on following the laws that are set forth by the government. Driving is a privilege that a state can prohibit if they consider it. You do not have a constitutional right to drive a vehicle. You have a right, you can walk your happy self all over the state. You can Forrest Gump that thing all the way from one end of the country to the other. You can go ahead and jog your way back and then back again. You can't drive a vehicle if you don't have a license. I'm going to go to Florida. I'll give you a free, how about if I am, let's just say a hypothetical, I'm going to give you a free trip to Florida, Mr. Martin. All expense paid, and there's no air fees, because I have a private jet. But I'm the pilot. You going to fly with me? I've never even taken a class about flying a plane. Don't even have a pilot's license. But you know what? I got a right to travel. I'll fly a plane if I want to. Does that make any sense? No. Why? Because planes can crash and kill people. Planes can crash and kill people. Cars can kill people. We want to make sure people are licensed to drive vehicles. Why? Because you're interacting with other vehicles that weigh thousands of pounds that are moving at rates of speed 30 miles an hour and higher. There's literally a National Traffic Safety Administration. Why? Because it's a dangerous situation. Yes, we need it, and yes, it's necessary. But because of that, the driving privilege can be revoked. The right to drive a motor vehicle can be revoked. The right to have, trust me, I'm the most firm believer in the right to keep and bear arms. But if you're not mentally in the right state of mind, or if there's some sort of reason why everyone has agreed that, you know what, this guy should not be having any weapons. He's threatening to kill himself. You know what? For his own safety, let's get the weapons out of his hand. Now, the reason we have weapons, it isn't so we can go hunting. It's so we can protect ourselves against the usurpation by our despotic government of any of our rights. I get that. I understand that. But at the same time, I'm not going to fly in a plane with a pilot who's never even taken a class, doesn't have a license. And that's why driving is a privilege. It's based on the character and nature of the activity. Yes, you can travel. You can ride a bike. You can pedal yourself around. You can walk anywhere you want to. You don't need to show your papers when you go from Michigan down to Ohio. Your papers, please. This isn't Russia. But you can't drive if you don't have a license, if that state requires it. And so, based on all of those things, based on the oral arguments that were presented today by both sides, based on the written briefs and answers to the same, I am denying your motion to dismiss. And I am denying your motion for the return of the moped. Now, after this case gets adjudicated, if it comes back where there's a not guilty on this case, then obviously, or even after it gets adjudicated, either way, your vehicle is always at any point capable of being picked up by area towing. If there's are any fees or storage fees associated with it, well, like Mr. Greco said, excuse me, ductwork here has never been cleaned since this building's been. That's the only place my allergies really kick in. If there's any, there is procedures in place for challenging the fees associated with such storage and towing, which is a separate matter. Okay, that's a civil matter. So this case is going to be set for a pretrial. We do have it. So now, as for this goes, since we're here, we're going to do an arraignment on the underlying charge. Mr. Martin, would you like a court-appointed attorney, sir?
Will not be accepting no court-appointed attorneys, as I will not be. They can fraudulently assume under the jurisdiction of the court. I invoke my right to be acknowledged as a sovereign, one of the sovereign people, as the U.S. Supreme Court said I have a right to do. Invoke my rights under the Republican form of government, Article 4, Section 4. Yeah, so I won't be accepting no attorney. And,
okay. So you do have the right to remain silent. Anything you say can and will be used against you at trial. Like I stated, you also have the right to an attorney. And at any point, if you'd like the assistance of an attorney, please don't hesitate to ask the court, and I will grant the same. It is alleged that on July the 11th of 2023, that you violated City Ordinance 3200B, which is commonly known and referred to as driving on a license that has been revoked. That's a misdemeanor punishable by 93 days in jail and or up to $500 in fines. As to that charge, how do you plead? Guilty or not guilty?
I'm not here to plead because I do not acknowledge myself as no defendant. That's fraudulent. I'm not a legal fiction.
Then I find you to, then I recognize you as standing mute as to the charge, and I'll enter a plea of not guilty.
Okay,
and we're going to set this.
So,
Listen, we're not. Okay.
Have you entered a legal determination that I am not guilty of the charges?
Nope, I just put in a plea right now at this time of not guilty, and we'll set this for a trial. The adjudication of your constitutional right to have a trial by judge or by jury, that will determine beyond a reasonable doubt if it's proven whether you're guilty or not guilty, pursuant to the Constitution. So I'm going to set this for a settlement conference. And you'll be given the date and time and the notice for the settlement conference. That'll be by Zoom.
Okay. I still have some things to say in response to what you said today. I still have some, still have some responses in response to what you said today, such as, is it okay if I say it now?
Your response to
What you said today, after we made the argument some things. Still have some things to say in response to that.
Oh, you're
okay,
saying you would like to make a response to the ruling I made with regard to your two motions?
Yeah.
There's no response to be made to it. I mean, if you'd like to make a record, you're more than welcome to file any motions that you'd like under the court rules. But
Well,
that was merely my ruling as to the two motions that were in front of me. The motion for return of the moped and then motion to dismiss. So, Mr. Greco, if you would put that in order.
I object to it, and I have some more to say about that, and that is,
What I'm saying, sir, hang on, because and I'm not trying to cut you off. I'm trying to protect your constitutional rights. Because anything you say can and will be used against you. I just wanted you to be aware of that. Okay.
Yeah, I got
So
that.
what I'm saying is, I'm not gonna change the ruling today. If you want to file a motion for reconsideration, you can do that. You have the right to do that under the court rules. And we'll set it for a hearing.
All
right.
Now, I might not remember everything because you said a lot of different things, and it might be hard to remember everything and respond. But I still got some things memorized. I want to say now, so I want to say them. That is,
You do also, and like I said, at any time, if you'd like a court-appointed attorney, I can give you a court-appointed attorney. But you could also order a copy of the transcript, so that way you don't have to remind yourself of anything. You can just, everything that was stated is already on the transcripts.
that is, and they try to charge money again. Again, it's a big monetary thing. You know, it's trying to turn rights into privileges, charging money,
Well,
and I don't have money for that.
It's not about charging money.
Anyways, I still want to finish finish what I have to say. Let me respond to what else you said now. You mentioned we have a right to travel, but we don't have a right to drive a motor vehicle. Okay, now, on the terminology, travel by right and drive a motor vehicle is not the same. And I can be controlling my moped, okay? I can be controlling a motorcycle or car by right. It's not if I only walk. Or didn't say that. Traveling by right means as long as I am not carrying passengers or property for profit. I'm doing my private vehicle, which what I was doing. I wasn't working for DoorDash. There's no evidence. I wasn't working as a taxi driver doing nothing else. I was therefore traveling by right. If I was in a car, same thing. If I am not carrying passenger property for profit,
It's incorrect. You're incorrect. Just telling you, you're incorrect. You're incorrect. I've taught constitutional law for almost 20 years. You're incorrect. You don't have a right. You do not have a right to travel by any means you choose. So that's a place I'm going to go buy myself a helicopter. I'm going to fly to work every day. No license, helicopter, and then I'll just call myself a Uber helicopter. I'm sure everybody would like to show up at the parties in a helicopter. You can't do it. You have to have a license to drive because it's a dangerous activity. You can walk anywhere you want to. You do. I agree. You have a right to travel, but it's not by any means you choose.
Obviously, the right to travel means it doesn't matter how a human cannot dictate. You can't.
Sir, I have other cases to get to. So I'm not trying to cut you off, but if you want to file a motion for reconsideration, you're more than welcome to do so.
Well, you are coming somewhat short because I still want to talk. I have the First Amendment right to speak, and I will continue.
You do have a First Amendment. Again, there you go again. A First Amendment right. A First Amendment right to speak doesn't mean you have a First Amendment right to speak. It means that you have a First Amendment right not to have the government interfere with your right to speak. That means that if you want to go stand in someone's sidewalk and give a speech or hold a sign, you can do that. The government can't stop you from doing that. But if you want to walk around naked, the government can stop you from doing that, even if you call it free speech. Why? Because it's indecent.
Well,
there's rules to everything. Everyone says, well, I have a right to say what I want to. No, you don't. Not in a private situation. So like if you're at someone's house and you're talking about whatever, there's like, hey, stop that. And you're like, well, I have a right to say what I want to. No, you don't. Not against private citizens. So everyone just misuses and throws that word out so quick that they don't even know what they're talking about. It's kind of like right to travel. But anyway, if you have a motion for reconsideration, the court will review that and set that for a hearing. But I've made my determination today with regard to your motions. Okay.
Well, I'm also going to make, well, because you made your determination, which is unfair, unconstitutional, I'm going to make a motion to disqualify you, which I then, therefore, if you're going to deny that too, I request you send it to the State Court Administrative Office that you're supposed to do under the court rule. That you showed your bias by denying my constitutional rights, which you both uphold, such as denying my right to travel, my right to my private property by using, the state can make money off me and use their state statutes to my constitutional rights. I don't think so. That's not true. And they cannot charge money for my private property. No state law, you should know that. They cannot use that as a reason to violate my constitutional rights and charge me money for my private property. No, that is criminal stealing, larceny. It's violating my constitutional rights. You're supposed to be upholding my rights as you took also, not violating it, working, conspiring with the state, making money, and that's all it is. It's like a RICO thing going on. You prosecute, push off it.
All right, so, all right, sir, so you made the same argument several times, and I do note that for the record. Your objections are noted, but then again, so my response to that is I'm not changing my ruling with regard to the motion to dismiss or the motion for return of the moped. There are other options that you have available. If you think you need to file a motion to disqualify, please file the motion and we'll set it for a hearing. If you think you'd like to have a motion for reconsideration, again, you can get a copy of the court rules. You can just Google the court rules, you can come up right there, or you might already have a copy at the library. You can, but I make sure that everybody follows the same rules and how things go. And just because someone gets ruled against at a motion hearing, we don't just keep talking about it until the judge changes his mind. That's not how it works. There's procedures in place, and I'm just making sure that all of your constitutional rights are been afforded to you. So you have several options of how you can proceed, but right now this case has already been heard and decided, and we're going to be moving. The court's going to be moving on to other cases that need to be taken care of.
Thing is, okay, I'm going to correct you. That's not totally correct what you said. It ain't just I just keep talking and not repeating myself. When you say things, you're saying something new that I haven't had a chance to say or respond to before you say it.
There isn't a response, sir. It's my ruling. It's not a response. There's no response necessary.
That's my due process right to respond. What do you mean?
No, your due process is the fact that you had the right to come in here. Due process is affording someone both opportunity to be heard and the venue to be heard. Here we are in the court. I allowed you to come in. We're here by Zoom. You had the right to file all your paperwork. All your paperwork was handwritten. And you know what? I accepted all of it. Why? Because that's part of due process. I gave you the benefit of the doubt of being someone who's improper. That's fine. Not a problem. I heard your motion. I allowed you to make oral argument on your motion. I afforded due process to Mr. Greco, where I allowed him to make a response on the record. I asked you right in the beginning, is there anything you wanted to say for oral argument, or did you just want to stand on the brief that you filed? And you went ahead and made oral argument. That's allowing you due process. This is all everybody playing the game. This is everybody doing their part and having the opportunity to play the game. And that's what I afforded every single individual. I take offense if there's to any comment that you state that I'm trying to railroad you or any kind of thing, because you know what? The Constitution is the most important thing to me. The Constitution is what gives every one of us freedom. Constitution is when I get woke up in the middle of the night to sign a search warrant. God bless them. God bless them. Thank you for waking me up in the middle of the night to sign a search warrant. You want to know why? Because that's the Constitution breathing. That's the Constitution doing what a bunch of guys back hundreds of years ago said, you know what? This is what freedom is about. So you know what? I take offense to anything like that. So if you'd like to file a motion for disqualification or for reconsideration, please do so. But at this point, your case has been heard. A decision has been made. Thank you, Mr. Martin, and have a good day, sir.
Case of the State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger for Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I am a living man, capital E, lowercase RIC, of the capital M, lowercase ARTIN family. One of the people, sovereign, not the legal fiction corporate entity defendant with the name similar to mine, and here by special appearance, to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it
So
just
I've
standby?
already made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Yeah, that's it. Well, that's how I was going to make the motion to dismiss him if he's if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before, so I'm not going to be accepting any attorneys who's going to fraudulently assume I'm a defendant, and which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before,
Sir, you got 5 minutes to make your arguments, and you can spend them however you want to.
all right, yeah. Like I said before, I'm a living man. So, as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent, and it's also under. There's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions though for the prosecutor. That's
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not, you know. There's no standing, shouldn't move forward, but. So what's your ruling on that?
Your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't allow me to answer the questions to see whether, you know, whether you had a legit basis to make that ruling.
Your objection is noted. Next.
Okay, let's see here. They say you're going to be questioning me about the some demands that made to dismiss the case anyway, right?
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I made or sent to you already. You're going to
First of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
Okay, I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology demand is made. And that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request, and persons are not, or humans are not supposed to be requesting constitutional rights. You know, me exercising my unalienable right, human rights and constitutional rights, I'm supposed to be making demands. That's how I've been, you know, and that's backed up by law. And that's how I've been taught. And so that's what, you know, so it's all right and proper. Motions are requests, you know. And the defendant makes motions also, since I'm just.
So you're about to end of your 5 minutes.
Well, I objected 5 minutes being any time limit also. That violates
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say, other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean to, none circular. I didn't finish the first time. All right, well, that's it. As to that,
Is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
Yes, I'm trying to make.
well, the police, I want to question the police officer who wrote the ticket. I have a relevant question to him as the self-incrimination move to dismiss the case based on that because he made me give, my ID. But my memory was it's a little, I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which was under threat and duress. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want to be able to review that now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination right, that I'm being made to give my supposed name, government name anyways, which ain't really my name, but a government name has been given. Violates self-incrimination. And then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So. Oh, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I'll get that out.
As to your motion to recuse, that is denied.
Based on what reasons? Conflict of interest is my reason. That's why I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed. That's the grounds of my demand for dismissal.
Okie dokie.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer by, in this case, writing the tickets, and I request you prosecute them for this because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers property for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges. Okay, so because they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance. So I was all within my right under that federal statute and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. They mention there specifically, and I'm gonna mention right here, Volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. So as they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stop and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also a federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back. So, yes.
Anything else, Mr. Martin?
Well, I'm going to see if you got my, if you're going to, I would like to just reiterate my, the demands for dismissal already made, or if you want to call them motions, but like I said, I like using the word demand because I want to, I don't agree to no unlawful presumptions that, because I understand the legalese a little bit where you say one word and it means something else and it's presumed. And that's why I demand also that there be no legalese used in no stages of this case, because that's one of the fraudulent things going on in the court system. I'm going to be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand to use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, because it's putting it's a blanket on a lot of people that don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record in any public court. This is all public. The U.S. Supreme Court already said this. People have the First Amendment right to record in public anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on a screen that video, audio recordings ain't allowed.
All right, thank you, sir. Ms. McDuffie.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address the as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other 2. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to really, the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple of things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes, Penhallow versus Domes Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. I don't want to, it's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever. That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows that does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washington. So just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal or even a federal lawsuit does not insulate you from the contempt powers of that very same court should you choose to continue escalating that type of behavior. That's just the more you know from me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and titles something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case, I guess in his mind and on paper, it doesn't mean that that exist in reality. So nothing more from that. The court's rejection of an improper filing really isn't my business. So no response from opposing counsel would apply today. The last two things that were filed before the court are two demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. Two demands. One demand for default judgment and another demand for summary judgment. Both of these I would have the same reaction to. The demand for summary judgment, summary disposition concerns parties to a civil action, and defendant is referring to civil procedure, not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the U.S. Constitution. That pertains to federal courts, appointment, tenure, Supreme Court justices, federal circuit and district judges. Those are Article 3 judges. Those are the ones nominated by the president, confirmed by the U.S. Senate. So this court is not controlled by Article 3 of the U.S. Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing here. Default judgment. Now, that's not quite the way it works. I think he argued that because the prosecutor in court did not respond to the request to return his motorcycle for that first filing that I mentioned, that he should have a default judgment and he should automatically get what he's demanding because he didn't respond to it. Well, I'm responding right now, but that's not how it works either. Again, this is kind of a civil issue. There are cases where there are default judgments filed, but those are civil actions. We have traffic tickets that defendants fail to appear and get a default judgment. But if that were the case, I would have a default judgment of conviction for every criminal case where defendants fail to appear. People are on bench warrant status for 6 to 20 years at a time. I don't get automatic default convictions. So again, that's really not what's happening here. So those are the 5 things that I'm aware of. Now, finally, if it were true that, as Mr. Martin stated, that federal law trumps all state law and that all state law and state courts are unconstitutional, the state court system would not exist. And the U.S. Supreme Court would not hear cases resulting from the need to interpret state law. Mr. Martin has yet to hear, as all of us do, of state constitutions and the power of the state courts that come from those being abolished. So his reference was correct, that there are people in this system who don't know any better and don't know what they're doing. I don't think present company is excluded from that. So on that note, Mr. Martin, if you want to continue without an attorney, you can, but I wouldn't recommend it. That's all from the people.
I'm so surprised you wouldn't recommend you're a prosecutor. But, anyway, well, I think that she said so much. I took some notes, but I couldn't take notes on everything. Hard to follow along with everything else. I think it's best to, same with me too. I say one thing, allow her to respond back. She says one thing, then allow me to respond to one set of, you know what I mean? Like me saying a whole bunch, and then her saying a whole bunch, because it's hard to follow along for both of us, I think, harder. At least me, and for both, I think it's common sense, but all right, well, so I'm going to respond now to things I could follow along with, and I took some notes, but I couldn't. I'm going to need her to say again what I missed, and then I can respond one by one. Okay.
That's not how this is going to work, sir.
That's
I
not
think
how.
to understand here,
I have the right to that. What are you talking
you're
about?
not controlling this courtroom, sir. That's not how this works.
As I'm speaking about what I have a right to do, I have a right to respond back. So
You're going to get 5 minutes and I'm going to be done. So that is your opportunity. And after that, I'm going to make my rulings. You got 5 minutes. I'm actually setting a timer.
all right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say, based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You have 5 minutes. Now, please move forward.
Criminal. Yeah, I want to object to that too, though, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
As to the criminal complaints, In response to what you said about that MCR, refusal to act on my criminal complaints that I filed because of MCR 6.101. And now, first of all, it violated my due process right, obviously, because they didn't mention a subdivision, a subsection of that rule. There's many subsections. Okay. So I'm still left in the dark and what specific subdivision subsection it is. And all those apply to specific fact situations. So that was the first due process violation right there, just mentioning that too vaguely general. Number two, but assuming it was based on not paying a fee or whatever, I think like she mentioned, or getting a prosecutor's approval. Okay, if it is for that reason, those reasons are unconstitutional and therefore it's invalid. That court rule. That's why I'm going to file a class action actually on the court rule. And I'm going to get that court rule and get up out of there because it's not legit. Why it's not legit? Because as I cited in there, I'm pretty sure I cited in there. If I didn't, I have to check my paperwork. But I'm pretty sure I cited in there, or I was waiting to respond back if I didn't already. But I'm gonna say right now that it violates the court rule on, the court, not the court rule, the Michigan Constitution part that says that people have the right to prosecute their own cases. In Article 1, I forget the exact section. But I mentioned in my paper, in some future paperwork anyways, I know that if I didn't do it on this one, in the very first one, because I didn't know, what the hell subsection I was talking about. They didn't mention it, but I know I mentioned in some later ones sent to you guys. But anyway, so yeah. So it violates that right. And also the US Supreme Court case Murdoch versus Pennsylvania. And I got the volume number, page, and all that. I think I cited you guys before in the paperwork. It says that you cannot deny someone's constitutional rights by trying to make them pay money for something. A right's a right. Bringing something to the court's a right. Be heard is a right. I don't have to pay money for that, criminal or civil case. Okay, so it violates due process. So all that's legitimate. They're illegitimate. That is, their arguments are using for that. It's supposed to be acted on regardless of a prosecutor's approval or not. Okay, anyways, now as to her asking who's Mike, he's the manager at Area Towing. But we should have read it. It was in the document to explain that. So, okay, anyways, as to the Penhollow, what she said about the quote about the Penhollow case, okay? Now, first, I want to say, regardless of the Penhollow case, what she said, the Declaration of Independence of 1776 makes it clear the government has no power over the people. They derive their power from the consent of the governed anyways. That's something that's clear right in there. Okay? The consent of the governed. I never consented and never will. So, number two, now, her saying about the quote, I was just recently going to the law library. I'm going to need more time to respond to that. But I didn't have enough time to go over the Penhollow case, but if I remember it, I was just in the law school law library recently trying to verify that quote. Because a lot of these quotes that I got, that I'm citing in the court, some of them I have read and some of them I haven't. This Penhollow case, I'm not sure on that. I admit that. I have to double check myself because, a lot of these I get online, YouTube, and a lot of them have been shown up to be legit because I go to law library and I double check on them, the quotes. In the Penhollow case, if I vaguely remember, I think I did have a problem myself finding that quote, saying that exactly like that, but that's not saying it doesn't stand for that proposition. I'm sure it still does. I just got to go back to the law library and read it again. If I did read it, I kind of don't remember because, I got a lot of stuff I'm doing, but yeah, so bottom line, I gotta check up on that case. So it'd be premature to rule on it yet, as to whether that Penhollow case is illegitimate to stand for that proposition. But I know U.S. Supreme Court cases still say it because it's all based off the Declaration of Independence, you know, and, you know, so there should be no doubt on that. And U.S. Supreme Court cases exist that say that that Declaration of Independence is part of federal law, United States Supreme Court law, and it's the basis of the Constitution, so it's legit. That as of the proposition that governments have no power over a human without our consent. All right, now as to the summary judgment that she mentioned, Chapter 2 doesn't apply. That is not true because since there's not a summary judgment in Chapter 6 of the criminal rules, then I forget exactly where it mentions that, but it's in the court rules or another law. But I remember reading it, it's been a while, that they make it clear that where there's not, you know, where there's not a relevant or same, similar proceeding in, you know, Chapter 6, then Chapter 2 is used for criminal cases. So that just totally, it's not true. So the summary judgment, it does apply in criminal cases because there's nothing in Chapter 6. And regardless of that, in regards to the court rules, you got to remember court rules fall. The Constitution is the top dog anyway. That's the top law anyways. And due process right to have some considered and ruled on and denied in my case. I mean, the case dismissed because based on my constitutional rights. That's just something I have a right to anyways under the Constitution, regardless of court rules. You know, because the court rules come after the Constitution anyways, and they don't always follow the Constitution.
All right, 5 minutes are up.
All right. Well, I got more to say, but so I'm gonna move for an extension of time on that, based on my First Amendment right. I got some more to say.
I'm sorry, Mr. You wanted to move for an extension, so I just want to be. Are we selecting a jury next week or no? It sounds like he wants to talk more.
He does want to talk more, but I'm not adjourning it for that purpose. I am done with these motions. The motion in this particular case to return the motorcycle has already been addressed through the court regarding the fact that the court doesn't do that. He also filed lawsuits against individuals. Those were also rejected by this court as improper. And those, there's nothing to really address about that. It's already been decided. His motion to dismiss is denied. Despite his understanding of the law, and I'm not certain which law school he went to, summary disposition does not apply to criminal cases and is denied. And same is true for default in criminal cases. That is also denied. Jurisdiction is with this court, as I've ruled before, and I will not be addressing this issue again. The motion to dismiss is denied. There was one point that he did make with respect to due process that is going to compel where we go with this. He does not get to question officers except for in a trial. However, he is entitled to discovery in this case. And he mentioned that he did not receive a copy of the video, if there is a video, or if there's body cam, he's making a demand for that. And he is entitled to have a copy of any body cam that exists in this case and a copy of any police reports that exist in this case. So those items need to be turned over to the defendant so that he can properly prepare for any trial. And trial right now is scheduled for 1 week, so I don't think it would give him a proper opportunity to prepare. I will remove this from the trial docket for this upcoming week to give and there is one place in which criminal cases does have a demand, and that is a demand for discovery. So I think he is making that demand for discovery, and I am going to require that the prosecutor provide him with that.
Absolutely, Your Honor. I think the issue was the standby counsel and him rejecting representation. So normally this is brought up to the PD's office, but since I think it's been reaffirmed today that I'll figure it out. We'll get it done somehow.
What do you have an email, or are you just gonna, Mr. Martin, are you requesting to have the documentation sent to you via mail or email? How do you plan to receive it, sir?
First of all, I'd like to refer to me as Mr. I understand that's another one of the term Mr. is another one of the, what's the words I'm looking for? I forget, what it's called here.
All right, you can, where you would like to figure it out, to get him that documentation. And, I'm gonna give you a new date.
Legalese term, that's the word I look for. The Mr. is a legalese term that's fraudulently assuming I'm a defendant and all that, but anyway, so
Yes,
my
Your Honor, while you look for that date, I will just state on the record, if Mr. Martin, Eric Martin, living man, the individual sitting here before me today speaking, if you would like discovery, I would highly suggest that you give the court an email address or some method by which we can deliver that discovery to you, because I'm not trying to keep it from you, but if you don't help me to help you, I can't get it to you either.
I'm gonna give them my address, and I'd rather do it through my physical address here at the home. I just wanted to object to the term first. That's all. Before I forgot, or you guys keep going on. Don't let me do it. But same address I've been sending the my demands to and all that, my paperwork. Taylor City, Michigan.
Whoa. I'm talking over because this is live. You don't want everybody in the world to know your address, sir.
Well, I'm not worried about it, but okay. I mean,
okay.
Your Honor, we have the information. We can send it over to Ms. McDuffie if Mr. Martin would so allow.
But I don't have a problem with it, so you don't need to have a problem with my address. I don't care who hears my address.
All right.
Really. I have no car now, no motorcycle because they took it. So that's also a reason I'm going to move to that you should grant that they give my motorcycle back to me so I have transportation to get there. And again, now remember, you said you have no power to decide on if I remember right, that's the word you used, no power to give my motorcycle back. But you do, and not just power, but an obligation under the Constitution, because it was took in violation of my Constitution right, because it's my private property. So not only do you have the power to do it, you have the obligation because you took an oath to uphold the Constitution. They took it in violation of my Constitution right. It's my private property. Like I said, under that federal statute, 18 U.S.C. 31, subsection 6 and 10, a motor vehicle.
Sir, I'm done with that argument. I'm done with that type of argument. But Ms. McDuffie, regardless of why he's making that argument, which is not valid, why do the police still have that motorcycle? Is it being held for evidence, or why are they holding that motorcycle?
No, the vehicle was impounded as any vehicle would be when someone is pulled over for not having a valid license and or a lack of insurance. I think there was also unregistered plate or registration, which is count 3 in this case. The vehicle, his complaints refer to his desire he can go get that anytime. His complaint is that he wants it returned to him without him having to get it nor pay for it for the most part. So that's the issue.
I see. Thank you.
Mm-hmm.
That's right, because like I said, because it's my constitutional right to have my private property. I don't need to pay no money. And especially on top of that, there are excessive fees on that, as we know, towing places traditionally do, which I plan on getting a lawsuit going on that too. I'm gonna make them stop that. I get to it. They just keep running the prices up every day. It could be thousands of dollars, one thing's worth. But regardless of that, like I said, it's a constitutional right to enjoy it. They should never took it because it didn't fall under the definition of a motor vehicle under that federal statute. So they shouldn't have took it from the jump. So it wasn't required for a license, insurance. Article 6 of the U.S. Constitution makes it clear federal statutes are supreme law. The state statute is unconstitutional, not legit. It's not valid in this case.
All right. On this particular case, we are done. I will see you here on December 7th, 2023 at 11 o'clock a.m.
Marino, good morning.
Good morning, Your Honor.
All righty. This is case 231510OT. And today, date and time set for a settlement conference. Parties have an opportunity to discuss the matter.
Good morning, Your Honor. Angela Mandarin on behalf of the people. Your Honor, I did have an opportunity to hear Mr. Martin's position on the issue while we were in the breakout room. He requested that I dismiss the case. The people are unwilling to do so and would ask that the court set this for a trial.
So. We've already had the motion to dismiss. Just get the, and this is the, motion on the demand for the body cam footage. Is that correct, Mr. Martin?
Yeah. That's one of the things I recently filed among some others. Yep, go ahead.
All right, so this is there body cam footage, Ms. Manorino?
Your Honor, I believe there is, and if the court wants to enter a discovery order in this matter, I think that would allow Mr. Martin to have access to the video that he's taken.
All righty, so let me just make sure that there's cam. All right, so I will enter the order for discovery. And then Mr. Martin, you can request that from the, once you get a copy of the order, you can request that from the PD. Now, as far as the moving forward goes, because obviously Mr. Martin's going to need to watch the video to further whatever prepare for his case. So are we setting this for a jury trial, bench trial, or a settlement conference?
I'm not clear about what you said about the discovery. You just said something about I can get it from the PD after an order, so I'm not clear on what you're saying.
I can't tell you how to practice law, sir. So I can't tell you how to go about that. I'm going to enter an order for discovery.
All right.
And then you take your steps to get the discovery. All right. So
the order that I'd be given to it, if you're just going to tell me I can go to the records office and get it, that's not providing me with the information.
I'm not telling you how to do it, sir. I'm just telling you I'm entering an order whereby you'll be able to get the gather information that you need to for your case. So.
All right, we'll just see when it comes in, but like I said, you're just not being totally clear on what's that going to be or whatever, but so I can't possibly object to it now. If anything, I have to wait and see what your written order says, but okay. So,
right. So we're going to set this up for, are we setting this for a bench trial, a jury trial?
if need to, well, first I'm object to, I don't think I can get a jury trial is won by one's peers, and I don't think that's going to be able to be obtained because I doubt if I can find a jury of my peers, which would be those that who acknowledge as one of the people, sovereign people. Mostly everyone's probably, if not every jury member would say.
That's not how it works, bud. I'm just telling you, that's not how it works. You have to get back on Google and Google whatever other story you want to come up with. Peers just means anybody who's over the age of 18 who lives here in the city of Taylor. That's your peers who are also registered voters. That's where the jury pool comes from. That's what the Constitution allows for. They don't have to be, when you say like-minded, that doesn't mean that they have to subscribe to some archaic form of the Constitution that isn't how it actually reads. And I'm a pure constitutionalist myself, so I get that. But that's not what that's absolutely not what it means. Not to mention, I can't tell people, I can't exclude people from a jury pool because they have a constitutional right to serve on the jury. And that would actually be violating their constitutional rights if I asked them whether or not they subscribe to some sort of sovereign citizen theory of the Constitution and then exclude them because of their beliefs. That's literally unconstitutional to do that. So what you're asking me to do is something unconstitutional. You will have a constitutional jury of your peers, as it has been declared by the United States Supreme Court of how that works. So, are you requesting a jury trial or a bench trial? That's the simple question.
If I request a jury trial, would it be fraudulently presumed that I'm giving jurisdiction
Say again?
If I say I want a jury trial, is that going to be fraudulently assumed by you that you have jurisdiction over me?
First off, I already established that I have jurisdiction over you. You committed a crime in the city of Taylor. I have jurisdiction over you. Court does. So we already discussed that part. You can order the transcripts from that first time when we already went through jurisdiction. If you didn't understand it from there, you can always order the transcripts and reread it. But clearly I already have jurisdiction. So, and I don't fraudulently assume anything. Everything I do is done because I was elected to be the judge here. I am sworn in as the judge here. I uphold the Constitution. Matter of fact, I keep a copy of my oath right here on the bench. Why? Because it means a lot to me. So there's nothing fraudulent about anything that I do, sir. I will tell you this: you will get a fair trial. That's for sure. That's why, because that's what the Constitution requires for everybody to get. And so if you're implying anything other than that, that's not going to happen. So again, jury trial or bench trial, I need to set it for one or the other, sir.
Well, first, I object to the truth that you're asserting. I don't agree that that's true what you said there. But sure. If we're going to force the hand, like I said, it's going to be a jury.
All right, so jury trial it is.
But I'm
so I'll set that. Go ahead.
It's only through fraud and duress do I say that. So that's all I'm under here. Fraud and duress.
Okay. Well, first off, there's nobody. There is no fraud nor duress. You're sitting in your own home. You're on Zoom. There's nobody twisting your arm. No one's holding any weapon to you in order to necessitate a duress type of thing. And basically, I gave you a choice. Do you want a bench trial or a jury trial? So it is up to you to pick, and you wanted a jury trial. There's nothing wrong with that. You have a constitutional right to set jury trial, and we'll make that happen. So, again, nothing but due process and fairness happening here. So we're going to set this for a jury trial, and you'll be receiving notice in the mail when that will be.
Thank you.
I'll also be mailing out a copy of the scheduling order. Have a good day, sir. Happy New Year.
You always just talk. You don't give a respond, and then you say how something ain't threatened arrest, but you don't.
But no, when I make a ruling on something, a ruling is literally there's no response to it. That's what the ruling is. So the ruling is I'm going to set it for a jury trial. Your motion for discovery is granted. I'm going to send out an order for the discovery, and there's really no other response needed other than Happy New Year. You'll get your date in the mail for the jury trial. And you'll get a copy of the order in the mail.
You know, that's clearly obviously unfair to say there's no response. That's saying what I say is that, and that's it. There's nothing to say about it. Obviously, you don't believe in the Constitution too much because you're not giving me my due process right to say what I have to say.
Well, first off, listen. If you're just gonna needlessly jabber about things that have nothing to do with anything of the case. You've already won your motion, so I'm not really sure what more you need to make a record on. I literally said, "Hey, we're going to enter an order for discovery." You requested discovery by a motion, and I'm granting discovery. So there's really no more record to be made, other than if you want to say something like, "Yay, I won," or something like that. But there's nothing more to add to that. If it's about the facts of the case, this is not the time or the place to talk about the facts of the case. That's what the whole point of a trial is for. And then you can prove your case you don't have to prove anything. The prosecution has to prove their case. You can present things or you can remain silent. You have the right to do that. You can be a witness for yourself. You can do that if you choose. So with regard to that, that's how we're going to proceed. And then, so we're going to send out again the jury trial notice in the mail, and you'll receive it at that point. In the meantime, stay safe, have a blessed day, and a happy New Year, sir. You're back for a settlement conference on this misdemeanor matter. First thing I want to ask you, sir, is I have a court-appointed attorney available. If you would like a court-appointed attorney, I'm just double-checking again because you do have a constitutional right to a court-appointed attorney. Would you like a court-appointed attorney?
No.
I'm sorry?
No, no court-appointed attorney.
You do not want a court-appointed attorney? You're breaking up on your end, so that's why I continue asking. So if you could also indicate with your head, like in a yes or no fashion, do you want, you're indicating no. Okay, let the record reflect that. All right, so I see that today is the date and time set for the jury trial, which says clearly in person. Matter of fact, it's even color coded. The notice that was sent out is color coded, as you can see in purple. It says in person, and then it says right there Tuesday, 2nd of April, 8:30, and in person proceedings. And it even shows the address right there, 23365 Goddard Road. And I'm curious as to why you're on Zoom and you're not here in my courthouse for this jury trial.
Well, no, actually, I have the notice that says today's, and I can show you this on my phone. I have the schedule for this is considered a notice I have. For
Sir,
today
you're
on
supposed to
Zoom.
be you're supposed to be here in the courtroom,
Oh, I have,
not on
like
Zoom.
I said,
Not on Zoom.
I'll show you
So-
that here. Did you hear me?
All right. So if you'd like, I have the prosecutor, Mr. Greco. The two of you would like to speak in a breakout room for any possible resolution. I got no problem with that. But if not, I'm going to have to adjourn this matter. I'm telling you right now, the next date that you're coming is you're going to be coming in person for the trial here at the court at 23365 Goddard Road, Taylor, Michigan, 48180. All right. So would you like to speak with Mr. Greco for any potential just settlement negotiation?
Yeah, I don't have a problem talking with him. Yes.
Sure. All right.
Let me get it clear from you.
You
You
do?
said I didn't get that date.
Your audio is of poor quality, sir, and it's very hard to hear you. So you're asking me for the address? You're asking me for the address?
No, I know you guys. I live in Taylor. I'm alive. Not within the corporation.
Let the record reflect that I literally can't understand anything he's saying. Can anybody else say what
you said that he lives in Taylor, he lived in Taylor all his life.
You live in Taylor all your life and you know where the court is?
Can you hear me better now?
Yes, much better, yes.
Yeah,
And now it's going in and out. So, all right. So hopefully Mr. Greco can hear you better. I'm going to put the two of you into a breakout room. Next time you're going to be coming, if there is no resolution today, and I'm not saying that to say that you must come to some resolution today, but if there is no resolution today, this is going to be set for the jury trial that you requested, and that is here in person at the courthouse. So the next time you come in for this case, it's going to be here at the courthouse. Here's a breakout room prosecutor 1, and I'll put you and Mr. Greco in there.
But I want to make it clear, but I want to ask you though,
Hang on, go ahead and talk to the prosecutor first.
Later, in the void.
All right, Mr. Greco, Mr. Martin, this is case is 231510OT, People versus Eric Martin, case 23TA18605B, 231TA18605C, and then 231510. Okay, so that's there. All right, good. So, Mr. Greco, you had the opportunity to speak with Mr. Martin. Was there any resolution in this matter?
No, Your Honor, there was not a resolution. There was a plea offer that was made that was rejected by Mr. Martin. I then asked Mr. Martin if he wants I guess he wants a trial in the matter, and he would not, he indicated he wouldn't consent to the jurisdiction of this court, so.
Well, first off, you committed a crime in the city of Taylor. I have jurisdiction. It's literally as simple as that. It's constitutional as can be, Mr. Martin. I explained it to you before. I've explained it to you on other occasions about jurisdiction. Your reading of jurisdiction, or wherever you're getting this idea of how jurisdiction works, is woefully wrong. We have constitutional jurisdiction. You committed a crime in the jurisdiction. We have jurisdiction. We have in persona jurisdiction over you. You availed yourself of the of the jurisdiction, and you're domiciled in Taylor as well. So there's literally every single reason to have jurisdiction. Now, we're going for a jury trial. I'm going to mail out the date to set this for the jury trial.
Your Honor, if I might, Jeffrey Fianto. We were originally assigned to Mr. Martin, and I came in, you were talking to him, so I'm assuming that he has chosen to act as his own counsel.
That is correct.
Okay,
So, but since you're right here, let me just double check to see. Mr. Martin, just for confirmation, you do not want House counsel assisting you. Is that correct?
No, sure don't, because I don't waive my right to a Republican form of government, and no.
Thank you, Judge.
Okay.
Make the record.
Sure.
Attorney to
All right. So we are going to get the date and time mailed out to you. You need to appear in person. In person, that means your body corporeally in this building, not on Zoom, not by any other means or anything like that. Physically, actually present in space and time here at the courthouse.
425.
Rachel McDuffie for the people.
Mr. Eric Martin, please unmute your device, well, and state your name.
You hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the, capital M, lowercase A-R-T-I-N family. A living sovereign, one of the people.
Assistant Public Defender Davi Lebo as standby counsel.
Thank you. We're here for a pretrial today. And a bench warrant is still outstanding for Mr. Martin.
That's correct, Ron. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day, and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video, and I looked at the video, and I also filed some demands to dismiss, based on self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial schedule or anything else.
Mr. Martin, I've decided on all the motions that you brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
When you're not prepared,
I think my words were very clear.
I understand what you're saying. You're saying because I didn't file it as a motion or something? What are you saying?
I'm saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
I mean, they're denied, but you didn't rule on it. How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he had he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not, but I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
Well, I object to the third one is self-incriminating. As I pointed out and stated in my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence.
Mr. Martin, you're gonna need to speak up if you want to have a transcript of this because it's not.
I'm speaking up.
Let's see, Heather. Okay. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me show you.
I'm sorry.
Kind of a little closer now. How's that?
Can you hear me now?
Is that any better?
How's that?
Can you hear me now?
How's that one clear? Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus banking case I cited and sent a quote from the law book on it. Clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating what I say. There's no legit case here. And which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor knew to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law. I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now I got to fight one about filing fees, but when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. That's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. You know, everyone's driving a motor vehicle and need a license insurance, so no, they don't. They're not doing it for profit. They're exercising their right to travel.
So, Your Honor, since Mr. I'm sorry, Mr. Martin. Since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could. Are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
So you don't deny something, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as I indicated in my demand under the U.S. Constitution.
Sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
It's in order.
Is that the May jury selection, Your Honor? Or
no, it's not. We're going to do a July 25th July 25th final settlement conference.
Okay.
August 9th.
July 25th, 2024.
Hold on, let me write this down here.
Hold on 1 second. 1 second, please.
And I'm also going to make a demand right now for compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings in violation of my 13th Amendment right against slavery.
Huh?
All these court proceedings are against my right against slavery.
No! No!
I'm entitled to compensation for all the court proceedings I had to make in this case. Otherwise, I would have possibly been arrested. It was only under threat and duress. It wasn't by consent willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm going to tell him in just 1 second.
Mhm.
All right. The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on, July 25th, 24, right? 8 p.m. a.m. So right?
It's at 11 a.m., sir.
You know, I'm to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but you know.
Jury selection is August 9th, 2024 at 8:30 a.m.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or you said the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time. Okay, now let's do the, what's the other date now, August? What else?
August 9th
Okay.
at 8:30.
8:30, what's that considered, what's that called here?
Jury selection, sir.
Now, which is in person here now? The 7/25/24, is that something I have to be there in person for? I mean,
For the fourth time, Mr. Martin, please listen. The first event, which is in July, is on Zoom. The last event is in person.
So we got it. So you're saying a whole bunch of what, you know?
All right, we're done today. Have a good day.
388, the state of Michigan versus Eric Joseph Martin. Sir, can you tell me your name?
Oh, not the Roman Sesticate Trust, if that's what you're wondering.
Okay. Are you going to tell me your name or not, Mr. Martin?
I just want to make it clear, I'm not the legal fiction corporate entity defendant.
Okay. All right. Sir, if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please let the court know immediately. You are here today on count 1, domestic violence. There's an allegation that on June 8th of 2024 in the city of Taylor at 9 that you did make an assault or an assault and battery upon Crystal Martin, a resident or former resident of your household, contrary to MCL 750.81 parent 2. This is a misdemeanor punishable by up to 93 days in jail and or $500. A consecutive sentence may be imposed under MCL 750506A if the assault was committed in a place of confinement. Those are the charges against you. You've been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty, not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered and you may plead no contest with the permission of the court. You have the right to a trial by a jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, meaning you cannot afford to pay for an attorney. If the offense requires a minimum jail sentence, this charge does not have a minimum jail sentence. The court determines that it might sentence you to jail, and the appointing authority, which is the court, would decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of the appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must then determine your ability to pay. Mr. Fanto, a court-appointed defense attorney, is present in the courtroom. It's my understanding he attempted to meet with you and he was advised that you did not want to speak with him. Is that correct?
Because of the unfairness of the laws that would fraudulently assume if I take a lawyer that I would be giving up my right to be one of the sovereign people and be fraudulently assumed to be a legal fiction defendant. Yes, I have refused that a lawyer fraudulently represents me.
If you have a trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require those witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind and you will give up the rights that I just listed to you. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or a finding of guilt is made by a judge or a jury, it may result in a violation of your probation or parole. The court can sentence you to jail and fines plus cost. And the court must tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, and both, which I've already done. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, you can contact the court immediately and request a payment alternative. So those are your constitutional rights going forward, Mr. Martin.
I want to make it clear I have been legally arrested here by barred away, okay, because he just went by her lies saying I kicked her. As soon as he walked through my door, I'm the one that called 911 on Crystal Martin, okay?
All right, sir, you have a constitutional right to remain silent, and anything you say with respect to this case could potentially be used against you in a court of law. So I would advise you at this time to remain silent with respect to the actual facts or allegations listed in the complaint and misdemeanor complaint, which I've read to you. Sir, are you gainfully employed?
Well, I wish to finish before I answer your questions. I will answer your questions. I want to finish exercising my First Amendment right, freedom of speech, and continue what I was saying.
Okay, sir, you are to appear in court as directed. I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court. This court has jurisdiction under the Michigan Constitution and the laws of the state of Michigan. You are charged with a 93-day misdemeanor, sir. You've been advised of all of your rights. Okay, you have a First Amendment right, certainly, but you are here for an arraignment, not to lecture me on sovereign citizen beliefs, okay? I'm trying to get you through this and make sure you understand the process. You are to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with the complainant, Crystal Martin, in this case. Do you understand me?
No, I do not understand in that I do not stand under the charges, the false fraudulent charges, but I do comprehend. But as I was saying, I was illegally arrested in violation of my due process rights. There's not sufficient evidence for my arrest that I did any domestic violence. Bardaway just arrested me anyway. There's no video of me assaulting her. He did not see it. She just told a lie. I actually filed a PPO on her.
Sir, do you understand that you're not, to have no contact with Crystal Martin?
Then you need to tell her, do not come to my house. She keeps coming to my house so she can set me up with these lies because my sister keeps letting her over. I have no, I don't want to contact her, but she needs to stop coming over to my house. You know, I've been living with her 32 years.
Miss Maudlin,
Let me finish talking. I have the first minute right to talk. I have the.
Mr. Martin, it's clear to me at this point that you have no respect for the court. I believe that you're a danger. I can't get any information from you as to whether or not you have another place to reside, whether or not you understand the court's no contact provision. I need to know that you understand what I am telling you, because I am attempting to set a bond on your case. And if you want a bond on your case, you've waived your right to an attorney. And I'm trying to figure out, do you have another place to stay?
Do you have any teepee? Teepee for my bunghole?
Do you understand what no contact means? And if you're not going to express to me that you have an understanding of what I'm saying, and if we can't get on the same page about that, then I'm inclined to not give you a bond. Do you understand me? Officer, can you unmute the iPad? Do you understand me, Mr. Martin?
I comprehend you, yes.
Okay, do you understand that I said you were to have no contact with Crystal Martin?
Yes, but she needs to stop coming over to my house. I'm not trying to contact her. She's coming over to my house so she can make false allegations like this, setting up so she can have the whole house to herself, her and my sister. This is what the whole agenda is of her with my sister. Lisa Martin tried this before, even though I proved to the court before the video of my sister Lisa Martin trying to set me up with lies and try swinging at me, assaulting me. I have this on video, saying with Crystal Martin here. I have her on video swinging at me and dealing with the prior case she tried to bring me in. Okay. So I have evidence that she is aggressive towards me.
Mr. Martin, does Crystal Martin live at the home on Clifford Street?
Yes, she comes over like for a day or two, and my sister lets her come over, and she stays there for a day or two. Yes, and then here and there.
Okay, so your sister owns the home.
No, she doesn't own the home thing. So my understanding is the bank really owns it. It's always been like my parents' house. But I don't even think really my parents own it because they didn't finish paying off the mortgage or whatever. So I think technically it's the bank's house, but me and my brother and sister have been staying there for a long time. Me there for like 32 years. My parents have passed away now. So now it's like a fight with them two. They're trying to take over the whole house by coming with false allegations, by telling cops, oh, he assaulted me all the time. There's no evidence. Not true, it's a lie. There's insufficient evidence in violation of my due process rights. But Bardaway arrested me anyways, and this is just what she wants. So they can have the whole house to themselves. I even filed a case on Crystal Martin.
All right, so you're not to have contact with Crystal Martin. You're not to return to in the city of Detroit or in the city of Taylor. I'm sorry. You're allowed.
Objection in violation of my due process. You cannot deny me my right to live at my house because of an unsupported allegation by her, which is a lie at that. Like I said, the cop had no sufficient evidence. She just told a lie, and the guy didn't even, Bardaway, that is, the police officer, just came to me and arrested me right off the bat. That violates my due process rights if sufficient evidence.
Sir, you're allowed one visit to the premises to obtain personal belongings. You must be accompanied by a police officer.
And I want Bardaway. Well, hold on, I'm gonna let you finish. I'm just gonna say what I got to say so you don't cut me off. And I want Bardaway arrested for his illegal arrest. I want Bardaway arrested for illegally arresting me. I want him charged for assault and battery, for illegally arresting me, and kidnapping.
Okay.
because it was without my consent.
Mr. Martin, if you are not allowed at the address, where will you be staying?
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You
Well,
ordered
these
that,
other
it's illegal. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes, okay.
And he's not
That
to
violates my right to a
return.
personal bond.
He's
I have a
not
constitutional right, and
to
you said
appear
you can
at
be
night.
innocent without guilty.
He cannot come to or be in contact with Crystal Martin.
Good morning, Your Honor. This is Eric Martin, camera one.
All right.
I'm the defendant, Eric Martin. I'm the living.
This is case.
That's Eric Martin.
This is case 231510. People of the City of Taylor versus Eric Martin.
And Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel?
Yes, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. I know due to canon law being, unfair, it's gonna, you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right, that's all right. So looks like this is ready to be set for a jury trial. Is that right?
Yeah, but I wanted jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So I won't begin to jury my peers if I don't get.
Well, as the individual who determines questions of law, that's me. I will make sure that it is a jury of your peers. So, and I'll determine that. So we will have this set, and then I'll mail out the date for the jury trial.
I believe there is a date set for next Tuesday for the jury trial in this matter.
All right, I see that.
I have objections. I cannot probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I cannot probably prepare for one in here.
So you're in there for a different matter because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see it. I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date? With whatever you're doing there?
There is no out date. That's the thing. It's So is this about the moped case?
Yeah, this is driving while your license is suspended.
I wasn't sure, right? They got me legally confined right now in the domestic violence. No evidence at all. She lied, made a statement, so now
hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case, you have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. So I suggest not bringing up the other case. This case here is on the moped and the driving on a suspended license. So a revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of a domestic violence case, but you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think that the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from, the remote Zoom thing away from the door before I could read the hearer. But it sounded like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, even if it's $1. So
So, right, because they illegally denied my personal bond, this is why I'm still in here. So, but
Yeah, you're still in there because the judge gave you a $2,000 bond. You didn't hear because you wouldn't shut up.
but yeah. So
All right, so what I'll do is, I don't know when that case is next, the next day, is that, it's a state case? Ms. Van Reno, you don't have that case, right?
I
Okay,
don't
so
know
it must
anything
be a
about
state.
that.
All right, and, so that must be, it must be a state case, which means it's on a Monday. So that's probably gonna be resolved within a month. So let me go ahead and set this for, jury trial. No, there will be, no need to set it for, a settlement conference before that. But
Well,
let's
I
get
object to that. I won't catch up. I was going to object before you guys don't give me a chance to talk. I object to, like, it should be, I moved that to be stayed, this moped case, till I get out of prison. I mean, till I get out of jail here. I can prepare myself. I can't probably prepare myself.
Right, that's right. Listen.
Ask some of my legal authorities to argue nothing.
It's being set for jury trial.
Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm gonna set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, I mean, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as a date right now, I just want to put a date on the books so that we know that you have an idea. I mean, if you get out tomorrow, then you'll know and then what your date is. So I'm looking at, let's see. I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do
So
I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be, and it's only a couple of weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple of weeks to, I mean, it's a driving on a restricted license. So it's not exactly a whole lot of prep time for that. It's not a homicide case, but, so I'm looking at August 13th. Because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're going to set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's something I want to say to with the prosecutors here. Dealing with this other case that I'm here for now, I request that
not the same prosecutor. Not the same prosecutor. That's the state prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case. So that's a Wayne County Prosecutor's Office.
No, sir,
not the city attorney.
I'm talking about the case I'm in here now. I want them to notify the prosecutor that I want charges filed on Chris Lamar for bringing these falsified charges against me now, and also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
Because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence, and I do. And I should be the one suffering here in jail as a lack of evidence as a result of and the unequal protection clause.
And that's on your other case, sir. So,
it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they don't, it's going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay? Deputy, have a good rest of your day to you and your staff. Martin, case 241388SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief and support. Well, There's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that, you know, that say otherwise, and there's a lot of support what I'm saying. That's why I say what I say to, you know, for the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Mission Court Rule 6.004C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last month of June. And also, go ahead and also want to say, I ask that you give me all the time to speak, say anything I want to say, you know, instead of like shutting the court proceedings off that's happened before. Make sure I'm done with everything I have to say, but that's it for right now. But like I said, I might have to say depending on what you say in response.
All right, well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Well, I asked that question. I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing. It's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to my ruling. So
I'm just asking the reason. I'm not asking what are the reasons that the bond, for example, is denied? Okay, first of all, what reasons is it being denied?
I've already stated that last time, sir. So are we at the next question here is, do you want a bench trial or a jury trial?
Well, I have more to say in response to the
do you want a bench trial or a jury trial, sir? Stop avoiding the question.
I just want to take off a jury.
Jury trial. All right, we're going to set this for a jury trial.
But I want to make it clear, I'm not consenting to
you'll be given notice of when that will be, sir.
Okay, I'm not consenting to the jurisdiction of the court still, and
you are subject to the jurisdiction of this court, sir. You live in the state of Michigan, you live in the jurisdiction, and under the Michigan Constitution and the United States Constitution, this court does have jurisdiction over this case and over you as the alleged defendant. The warrant was signed with probable cause. The warrant had probable cause. The warrant was signed. That's all that's needed to bring a charge, and it's brought in the proper place, which is here because you live in Taylor, and this is Taylor, so this is where the case would be. So your motions were denied, and we're going to set this for a jury trial. We'll be giving you the date and time of when that jury trial will be. Let the deputy know that.
That's what I mean. See, I'm not done yet.
All right, we're here for a final settlement conference today. And where are we with this matter, please?
Your Honor, I believe that we were previously ready to proceed actually directly to jury selection, but I think that it may have been set for final settlement. Mr. Martin had some other matters and some other courts, and I don't know if he missed a date or something in there that had it set.
I'm not sure how he got put on for final settlement conference. It was supposed to go directly to jury selection, but we're here. Mr. Martin, you're still requesting a jury trial in this matter, sir?
Yep.
All right. We already have it scheduled for jury selection on August 9th at 8:30 a.m.
Get there right now. Something new I'm going to say is I'm going to demand appointment of counsel, even though I know you already had them in standby. I always was refusing them, but since it's being fraudulently assumed I'm the defendant anyways, along with all the other fraudulent presumptions, I'm going to go ahead and take the lawyer. But again, I'm not agreeing to no fraudulent presumptions that may normally attach to that, such as I'm a defendant, I'm a ward of the court, etc., etc. I can go on, but under canon law 3228, for example, and etc. But so yeah, I want to make that clear on that. And also there's some pretrial demands to dismiss I made that haven't been ruled on yet. They should, because they're, pretrial, they're matters of law, so they should be ruled on before trial. And
I'm sorry, Your Honor, I wasn't trying to interrupt, but I just wanted to thank Mr. Martin for that update and to say that his counsel, he's now requesting, if the court chooses to appoint them formally to this case, will be probably happy to assist with all those things, because we have to do jury selection, instructions, and I was going to ask how I needed to communicate about it.
Well, with respect to any pretrial matters, this court did make a ruling on the record, and I have a written, I wrote it down in my notes here as to each ruling I made on each of the issues. So that has been addressed. If you are expecting counsel to be appointed, sir, at this point in time, then I will do that. And after that point, you will no longer be able to speak on your own behalf. You understand that?
no, I do not understand. I do not agree with it. That is totally violation of my due process rights. I object to that. Regardless of what the council may say, I still have the constitutional right to say what I want to say. It's a First Amendment right. So if you're going to say I must accept counsel in order and must violate, with the condition that I must violate my own constitutional right to speak when I want to and have a right to speak, then I'm not accepting it. But
that is your choice, sir.
So what's it going to be? Are you going to tell me? Are you still going to stick with that, or what?
Very clear on what I said.
Okay, well, I'm going to forget. Then I'm going to, like I said, I'm going to change my mind on that. Then if I'm going to violate my own constitutional right to speak,
all right.
Then
as you go through the jury selection process in any of these processes, you will be held to the same standard as any other attorney in a case, because that is what the law and the court rules require. So if you're in violation of those rules, sir, then what is going to happen is you will be held in contempt of court like any other individual would if you are not, in fact, following the rules of court. Do you understand, sir?
Objection. That violates the Supreme Court case law. I can't think of the name of it right now, but I have read it before years ago that non-official attorneys are not to be held to the same standards as attorneys.
Mr. Martin, that is not the law, again, and I have told you what is going to happen. So I will see you here on August 9th at 8:30 a.m. prepared to go to trial. See you then. Have a good day.
Your Honor, I'm sorry. I do just have one quick question. He can be gone.
It's gone.
But I just need to ask the court, because we have to submit the jury instructions and et cetera. I don't have email contact information from Mr. Martin. I don't know if he uses email. So I can submit that to the court, and I guess
he has standby counsel. So submit it to his counsel.
Will do.
Fine.
All right, Mr. Martin, I just want to clarify something, because I am inclined to grant your motion for the appointment of counsel, but the problem is inside your motion for counsel, it also states that you are not consenting to the jurisdiction of the court. So if you're not consenting to the jurisdiction of the court, how is this court supposed to grant your motion for appointment of counsel? I already have jurisdiction over you. That's already been established clearly. So do you want counsel? Because if you do, I'm going to appoint counsel.
Yeah, I still want the counsel, but like I said, without the fraudulent presumptions and all that. But
sure. Hang on. If you could speak up and enunciate, because I don't know if it's maybe a connection error or if I'm just having trouble hearing what you're saying. So I just want to make sure that what you're saying is clearly stated on the record. Okay.
Okay. Let me move my phone up away from my desk. I think that's a little situation like that. But yeah, I still want counsel.
Okay, so you are consenting to the jurisdiction of the court, and I can grant you counsel. Yes.
No, I'm not consenting to the jurisdiction of the court.
I don't know what you're saying, sir.
He said he's not consenting to the jurisdiction.
You're not consenting to the jurisdiction of the court? Well, I've already found that. Then first off, I find that I do have jurisdiction over you in this matter. You came to the location, like I stated before. You came into the location and availed yourself of all of the benefits and services that you can find here, emergency services, road services, etc. You actually reside in the city of Taylor, so that alone is enough to have jurisdiction over your person in this matter that occurred in the city of Taylor. So I do find that I have jurisdiction over you. So that matter is settled. Would you like to have counsel?
Not true, so I object to that. That's not true. You never gave how you jurisdiction.
What part's not true? Do you live in the city of Taylor?
No, I'm not going to say that it's true, as in not in the sense that you mean it. No, or you're asking. It's fraudulent.
So you astral project into the city of Taylor then from somewhere else, or I don't understand. Living is, I don't know, breathing, live, reside, Clifford Street. You know what I'm saying?
Yeah, I mean, well,
keep stuff.
The thing is, if someone, stays in a house, it's fraudulent presumed that the corporation, the fiction they're living in, it's all legalese.
All right, so you're not a corporation. I do find that you have jurisdiction. I have jurisdiction over you. I will note your objection for the record, claiming that that's not true. I am going to appoint House counsel to you, because you definitely need somebody who can understand and explain the law to you and be on your side with regard to the case. So I'm going to appoint House counsel again. And I'm going to put you into the breakout room, and House counsel will be in to speak with you so you can speak privately.
All right.
2 hours later.
As a criticism, it's just the law doesn't allow me to do certain things. And Mr. Martin disagrees with the law, and that's his right. But Mr. Martin's come to the conclusion that he doesn't believe that I can effectively represent him. And after, like I say, over 2 hours of discussions with Mr. Martin, I believe I'd have to agree with him.
You are agreeing that the two of you disagree, or that you just can't represent? Because I do. No, I guess I would have to disagree with your own statement, because I think you're very confident in every case.
I appreciate that, Judge. But based on our internal disagreements in terms of how the case should proceed, what the law is, how to apply the law, I just cannot, in his mind, effectively represent him. And I can't represent him the way he wants me to.
So you believe that he believes that you?
I do, yes.
Not that you actually wouldn't be.
No, I'm in terms of this case, I'm more than able to go forward with it, but under the circumstances, after, again, this is based on a long conversations with Mr. Martin. Just don't think that he's comfortable with me proceeding.
Mr. Martin, is that correct?
That's correct. Yes, we certainly don't agree. We did talk for a long time, and but it's not simply just a disagreement. I don't think he's violating my right to effective counsel based on one. He wouldn't even do the basic photocopies, some paperwork. I told him I wanted to get photocopied, for the court and jury, such as laws. Be used for my defenses, relevant to my defenses.
Sure, but you do understand that any instruction on the law to the jury is done by the judge. You understand that?
Well, I don't understand. I don't agree with that, or.
No, sure. I literally am charged with instructing the jurors on what the law is and what the elements of the case are.
I mean, that's fine.
I'm going to instruct the jurors that any instruction that they hear from the attorneys to disregard, and you're only going to take instruction about the law and what the law is from me, because there's literally criminal jury instructions that are put out by the Michigan Supreme Court that are used in trials, and they've been vetted over the course of hundreds of years of tweaking and Supreme Court challenges and you name it and everything else. So that's literally what the jury is getting told, is they're going to get told what the law is, and that's going to be told to them by me. Do you understand that, right?
But I don't agree to that, but to that degree, but as long as you don't knock out my right, I also have the right to present jury instructions on the law of the matter. So, so long as
You have the right to present proposed jury instructions, yes. And I'll make the determination of what the jury instruction, what the instructions will be to the jury. So, but first, let's deal with this matter here. You're saying that you no longer, you wish to have the court-appointed attorney, and now you do not wish to have this court-appointed attorney. Is that correct?
But only in the sense of I moved to have another one appointed in his place since he's being ineffective based on he won't even photocopy, not just the mere disagreement, but it's the fact that he won't even photocopy. I asked him to, let me go there first to the office, photocopy, so I have enough copies for the jury because I don't have a job now. So I can't.
Photocopy what, sir? You want him to photocopy what?
I have just several things written down in the law and things that need to be copied out of the Constitution. Just several legal, legal areas to be copied out of the law and just stuff that's relevant to my defense. So he should give me no problem with photocopying. That problem. So that's really showing his ineffective, violate my right of. So
yeah, but listen, that's not photocopying is not an attorney's job. If you want something photocopied, go to the library and photocopy it yourself. The attorney's job is to talk and understand and be able to give advice about the law. He already knows the law. He doesn't need a photocopy in front of him. He already knows what the law is.
But as I just said, based on I do not have a job now to pay for the copies.
So you want them to pay for, so that's the rub. You want them to pay for photocopies that you want to make.
Right.
That's not how it works. That's not how any of this works.
Well, you're more than welcome to just have listen, your attorney doesn't need the law in front of him. He already knows what the law is. So if you want a copy of what the law is, you're more than welcome to go to the library and check out a book that has the law in it. You can just bring the book with you. And take the book back to the library afterwards, free of charge.
Again, I need paperwork photocopied that's relevant for my defense to present it to you and the jury. I have that right.
First off, listen, you're not presenting any paperwork to the jury if it's about laws. If you're going to try to place things into evidence, you can lay a foundation and you can put in proposed exhibits for evidence. And then I'll make my rulings based on the rules of evidence of whether or not those are supposed to come in and should come in, and whether they've had proper foundations laid, whether they are both reliable and accurate. That's the two things that we're really looking for. So, and if they comport with the rules of evidence, then I'll admit them as your defendant's exhibit, whatever, 1, 2, 3, or 4, whatever the exhibits that you have are. So this is a situation of driving on a license that's been revoked or restricted. So what evidence is it that what proposed evidence do you have that you would need? Because we'll make copies here of that evidence as it gets admitted. Because I'll put a true copy in the court file. I can give a copy to the witness so that they can see. So that kind of thing. But so as far as the motion to remove Mr. Fanto and the House Counsel crew that I have here, which includes Mr. Kazicki and Mr. Coots, I'll once again grant that motion. I'm not gonna request any fees or anything or costs from you because I did appoint them. Then you said you didn't want them. Then you asked for them. Then I gave them to you, and then you went back and said you don't want them now. So with regard to a different attorney, do you have another attorney that you wanted to hire? Is that what you wanted to do? Or you want me to appoint one to you?
I don't have money to hire an attorney.
Sure. So I'm going to go ahead and appoint one to you. All right. So I'm going to refer this to Miss Patton from the MIDC. And I will have an attorney here for you Tuesday for that jury trial. We'll be ready to go.
Well, that's what I wanted. Now, another attorney being appointed.
We'll see you on Tuesday, sir. I'll have a court-appointed attorney here for you.
42448, the People versus Eric Martin.
Jeffrey Fanto on behalf of Mr. Martin. Mr. Martin requests that the charges be read, and he is not entering a plea of any nature to this matter. He's asking the court dismiss this matter for lack of subject matter jurisdiction and for a violation of his due process rights.
Okay, good afternoon, Mr. Martin. The allegation against you in this misdemeanor warrant, it alleges on October 5th of 2024 at the address of Clifford Street in the city of Taylor, Michigan, that the complaining witness has filed a sworn complaint in this court stating that on the date and location described, the defendant, contrary to law, count 1, domestic violence, did make an assault or an assault and battery upon Kurt Joseph Martin, a resident or former resident of his household, contrary to MCL 750.81. Parent 2. This is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Mr. Martin, I've signed an order appointing counsel to you. Mr. Martin, did you go over your constitutional rights?
We went
All right.
in a discussion, but he would not permit me
To sign the form. All right, Mr. Martin, if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make arrangements. You have been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. You have a right to a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, without money to hire an attorney, and if the offense charged requires a minimum jail sentence. Sir, the charge against you does not have a minimum jail sentence, or the court determines that it might sentence you to jail. I have appointed an attorney for you. You have the right to a trial, and at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you choose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you will give up the rights listed in items 3 and 5 above. You have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to fines and jail plus costs. The court will tell you on the record the name of the offense, which I've done, the mandatory minimum jail, there is none, and if any, and the maximum possible penalty for the offense, which I have done. Fines and costs and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative under MCR 6.425, parent D, parent 3. An appeal to circuit court may be taken within 21 days from the date of sentence or as permitted pursuant to MCR 6.625, parent B. If the sentence includes incarceration and you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days of the date of sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. The court does have subject matter jurisdiction in this case, so that request is denied. Did I cover everything, Mr. Fanto?
Yes, sir.
And since your client is selecting, Mr. Martin is selecting to remain silent, I will enter a plea of not guilty on his behalf. His bond is to be set at, I see he has, at least the jail records are indicating he has a $25,000 hold out of Brighton.
That's actually, it's NSP Brighton, but it's, the jurisdiction is Ypsilanti. It's a driving while license suspended. I can only guess that that's a typo. There's no felony attached to it. It's not like a driving while license suspended with injury or anything of that nature. I have to believe that's a typo.
All right. Well, the jail will call MSP Brighton and they'll clear that up. But, sir, I'm going to give you a personal bond. Mr. Martin, I'm sorry.
I said that is an illegal warrant. I was at jury selection on this day when Earl Washington said.
All right, 1 second, Mr. Martin, you have a listen to me. I'm trying to protect your rights, sir. You have a constitutional right to remain silent. I don't know anything about that case, and I don't want you to make any statements on the record that might affect your rights. Because anything you say in here can be used against you.
What I got to say. I wish to exercise my First Amendment right, freedom of speech, and to self-defend myself for these charges you guys are making fraudulent presumptions of. First of all, the warrant's not legitimate. It's not legal, it's not lawful. I was there at the jury trial. If you guys look at that, you'll see it's fact. And just because I didn't say I was a legal fiction corporate entity defendant named Eric Martin, which I'm not, I'm a living man, one of the sovereign people. So because I didn't admit that fraudulent thing and commit perjury, she said, okay, I'm going to do a warrant for Eric Martin, the defendant. So that's what this is about. So it's unlawful, it's illegal.
Okay. All right. Well, Mr. Martin, I went to law school and practiced law for 20 years and it's not. So listen, on this case, I'm going to mute you so you can hear what I'm saying to you, Mr. Martin, because it's important. You have a $2,500 personal bond. You are to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You can have no contact with Kurt Martin while this case is pending. You cannot purchase or consume alcohol or illegal drugs, and you cannot possess or have access to firearms. We will send you a notice of your next court date, sir, to you in the mail. And Brighton, I don't know if they'll come and get you or not, but that's for them to decide. But I'm letting you know those are your bond conditions today.
Judge, he may need an officer assist for.
Can I see that one more time? I'm sorry. Thanks. All right. You have one time allowed to visit the premises to obtain your personal belongings accompanied by a police officer on one occasion, sir. But if the complaining witness in this case, Kurt Martin, lives at that house on Clippard, you cannot return to Clippard while this case is pending. And you do have an exception. You're allowed one visit to the premises to obtain your personal belongings but you must be accompanied by a police officer.
Thank you.
Thank you.
And now he is not here. I was separate 30. People versus Eric Martin.
Good morning, Your Honor. MIDC counsel on behalf of Eric Martin, Josh Hadley, P number 80080.
All righty. Today was the date and time set for a settlement conference. Mr. Martin had appeared and he signed out and is no longer here. He left the court, the Zoom court. There was also a motion and demand to replace his current attorney, Joshua Hadley. You would be the second or third attorney, I think I've appointed to Mr. Martin.
I can't speak to it, Your Honor, but I do believe that that's correct. I know I'm not normally one of your House counsel attorneys. I was reached out and spot appointed on this. I believe I'm successor, maybe third attorney on the case.
Right.
Judge, he is back in the waiting room now.
Oh, wait, he's back in the waiting room now. Here he is.
And Your Honor, I was not served a copy of the motion to replace me, so I will not stand obviously in opposition if that's been filed with the court.
Well, it's been filed by Mr. Martin, so it was handwritten. Mr. Martin, turn your video on, please.
All right.
Yeah, this is people of the City of Taylor versus Eric Martin. Today is the date and time set for a settlement conference in this matter. Mr. Martin, you had filed a handwritten motion to replace your attorney, Mr. Hadley. Mr. Hadley is like the second or third attorney that I appointed to you on this driving on a restricted license. And replace him, which will require another. It says that your attached motion, you'd like to fire the attorney and replace him, which will require another appointed attorney, time to get familiar with this case and your defenses. So, there's nothing wrong with this attorney. What's the problem with this attorney? He's a very highly qualified attorney who I appointed to you. This is a driving on a revoked license. I'm not sure what the issue is here with this attorney.
Pointed out in the motion and demand to get rid of him was replace him was because
Hey, Mr. Martin, hang on. I can't hear anything you're saying because the tubes behind here. All right, go ahead.
Yeah, just as I pointed out in the motion was because he told me that I can't say nothing during a trial. If he talks, I can't talk. Basically, I have to violate my own right to freedom of speech. Yeah. And what was the other reason? Let me refresh over it again.
Okay.
And there's other reasons. And plus, he kept cutting me off several times as we was talking. Not like it was a one-time thing, like normally happen. People don't intentionally, might cut off. So it happened several times ago to show he was doing it intentionally.
So you say you want to talk at trial. You have two different options as far as talking at trial. One is you have the right to testify on your own behalf if you want to. And no one's going to stop you from testifying on your own behalf. Now, if you're planning on doing that, your attorney can ask you questions, and you can also be subject to cross-examination, just letting you know. And you'll be under oath. So any sort of perjury or anything like that, you could be, subject to obviously the penalties of perjury if there was any sort of untruths that were stated by you on the record, on the witness stand. Now, the other way you would be able to speak on your own behalf is if you're representing yourself. So I think what Mr. Hadley is talking about is like if someone's asked a question and he wants to say objection because there's a legal reason to say objection. I don't need both of you to say objection. Just one person can say objection. I think that's what it's going to be confusing if you're going to try to talk over top of your own attorney when it comes to that sort of stuff. If you want to represent yourself, you're more than welcome to represent yourself, and you can talk. You can be the attorney. You can say objection and that kind of stuff. But in that situation, I would still have Mr. Hadley there as a standby so that you can ask legal questions. But there's no reason to fire Mr. Hadley. He's a very competent attorney, and this is a very straightforward case. You either had a license at the time you were driving, or you did not have a license at the time that you were driving. And all we have to have is, as far as the elements go, We have to have a witness that shows that you were operating a motor vehicle on a public street and you didn't have a license. Those are the elements of the case. So I don't know who the witnesses are. We haven't heard any testimony, so I'm not going to get into any of that stuff. But I'm pretty sure that Mr. Hadley can handle a case like this, or be the standby there sitting with you in case you have a legal question when it arises. So that's for that reason, I'm going to deny your motion because you have very competent counsel. You requested counsel, and I don't see any legitimate reason to fire this attorney and hire a new one, especially when you stated right in your motion that our attached motion and demand to fire the attorney and replace him, which will require another appointed attorney time to get familiar. I'm not kicking this case down the road again and adjourning it out again, just so that we can stall for more time. So there's literally nothing in the elements that Mr. Hadley isn't aware of. So I'm going to deny your motion. Now, if you want to represent yourself, I'll have Mr. Hadley be there as your standby attorney so that you have an attorney that you can ask questions to right in the courtroom. Or Mr. Hadley will be the one who's going to represent you. And if you want to testify, that's entirely up to you.
Your Honor, if I may briefly, as Mr. Martin's waived attorney-client as to the contents of our communication, I've never told Mr. Martin that he was not allowed to testify on his own behalf. For the record's sake, Mr. Martin has proposed that we would have dual opening arguments and dual closing arguments if there was a difference in trial strategy. I've explained to him that the court's not going to entertain tag teaming this proceeding.
You know what? Listen. If you want to say a closing and he wants to say a closing, sure, go ahead. I got no problem. I got no problem. The court is not. The court is very, 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 very astute in the law. And you know what? If you want to talk, you want to do an opening argument, you want to do a closing argument for yourself as well. Listen, I'm just going to remind Mr. Martin that you have a right to remain silent and not have any of that silence used against you. But if you want to get up and speak, I'm going to caution you right now of what you're not going to do. One, you're not going to testify until you've actually testified. You're not going to talk about things that are not in evidence. So if you're going to be like, hey, I did this or they did this in the opening statement. Now, if you're going to want to say that it's going to, like everybody else does in their opening statements, here in this trial, the evidence will reflect, or the evidence will prove X, Y, and Z, talking hypothetically. Sure, but if you plan on not testifying, then you better not testify during your opening or closing statements, because you're not subject to cross-examination at that point, and that would be unfair for the other side. If you are going to testify about your own opinions, about your own statements of fact that you think happened, you're going to do that on the stand if you want to do that, or you're not going to say it at all. You understand, Mr. Martin? Because that's not fair to the other side. That's like letting you move chess pieces and the other side doesn't get to move any chess pieces. Because there's a whole rhythm, there's a whole flow to it, there's a whole fairness to the whole process. So if you're going to testify during your opening or during your closing statements, then you're going to testify on the stand. But if you're not going to testify on the stand, which is your choice, you have the right to remain silent on that, then you're not going to bring up things that aren't in evidence, because your testimony isn't in evidence. So you're not going to sneak it in or slide it in during your opening or closing statements. Do you understand that?
Before I answer that question,
Mr. Martin, the answer is yes or no. Do you understand the statement that I just stated?
I comprehend it.
Okay, you comprehend it. Very good.
Else.
So next topic is everybody's ready to go. That is set for the trial, and we'll see everybody here for trial.
I have some objections, and I have something else to say. Now, I never said that Joshua never said testify. He wasn't talking in that because I couldn't speak. He was.
It's already been resolved. It's already been resolved. If you want to make an opening statement, you can make an opening statement. If you want to make a closing statement, you can make a closing statement. So yeah, I got no problem with both of you making your opening and closing statements. And with regard to testimony, if you want to testify, you can testify. If you want to remain silent, you have that constitutional right to do that too. So court's not stopping you from doing any of that. Okay, so the motion to remove Mr. Hadley has been decided, so there's no more need nor discussion for that. I've already made my ruling on that. So that was the point of today, was your motion was up for today. We've made a ruling on that motion, and we'll see everybody at trial. Have a good rest of your day, sir.
I have a motion to make, hold on, I have a motion to trial based on other motions that I filed to dismiss the case and they have not been ruled on yet.
So you said your motion to dismiss?
I have several motions to dismiss already filed in this case that are
Right, and I already ruled on your motion. I already ruled on your motion to dismiss. And if you're just going to refile the same thing, then it's still dismissed. You can't just keep filing the same motion to dismiss.
one of the same motions. Now I'll go over the motions I'm talking about specifically here. One based on the 11th that I August.
So we'll hear any other motions on the day of trial, sir. So be prepared because we'll hear those in person here and before the trial starts, if the trial starts. Because if your motion is successful, then we obviously won't start it. But we're not hearing those today. Those weren't scheduled up or noticed up to be heard today. Those are going to be heard on the day of trial, so we can do them here in person. And then if your motion is successful, then we won't have trial. If it is not successful, then we will. But that way everybody will be ready to go on that same day. So we're going to see everybody on the day of trial, and any other motions that you have, we will take care of at that time. Mr. Hadley.
Your Honor, one, I would like to get a working phone number for Mr. Martin. I've been unable to reach him for several weeks.
Mr. Martin, do you have, I'm going to put you into a breakout room, because I don't want to broadcast your information online.
And then second, Your Honor, I've been
Mr. Martin, hang on. Mr. Martin, hang on. Mr. Martin, hang on. Mr. Hadley, what was the second part of your?
Thank you, Your Honor. I have not received or been able to get copies of any of the pro se motions that have been filed other than the motion for a hearing to determine nature, cause of case. Would it be acceptable to reach out to your staff to get copies of these pro se motions in advance of the trial next week?
Yes.
Thank you. That's all I have, Your Honor.
All right. So Mr. Martin and Mr. Hadley, I'm going to put the two of you into a breakout room so that you can swap information as far as phone number and things like that. So there you
Thank
go.
you, Your Honor.
Yep. I still have a verbal motion to make, Joseph.
All right, so go ahead and talk with Mr. Hadley in the breakout room. You can sign out from there.
I appointed counsel on behalf of the defendant, Mr. Eric Martin. Briefly, Your Honor, I'd like to make a record. We were before this court last week, and there was a motion, a pro se motion filed by Mr. Martin to have me replaced as counsel. I was never served a copy of that. Your court graciously did send a copy. I have had a chance to review it. Your Honor, I would just again state that if Mr. Martin and I have a fundamental disagreement as to trial strategy, pursuant to People v. Charles O. Williams, 386 Mich. 565, 1972, good cause exists for a substitution of counsel. If there's a difference of opinion between the defendant and the appointed counsel with regard to a fundamental trial tactic, as well as going to People v. Bass, 88 Mich. 793, 1979, good cause can also be found when there's obstruction of communication and breakdown. Now, my recollection, Your Honor, your basis last time in denying the motion was really how late in the game the motion was. It was going to be prejudicial, essentially, and disruptive of the judicial process.
That's correct.
If I recall correctly, one of the other concerns we addressed was the concept of Mr. Martin's belief, which I think we've now clarified, that I'm not restricting him from speaking in any way, shape, or form today.
No.
Very well. Your Honor, I would also like, I believe, again, I don't want to put words into this court's mouth. My understanding is my role today, as if Mr. Martin wants to advance the defense that he has selected, I'm here to aid him with the understanding of the Michigan court rules, the Michigan rules of evidence, and all federal and state applicable law.
That's correct.
Very good, Your Honor. Okay, because of that, again, I think I just, for Mr. Martin and myself and this court and the people to be on the same page, for these reasons, I will not be making an opening statement, or I will reserve an opportunity for a closing argument.
And I will say this, I'm going to go ahead and give the ground rules to Mr. Martin so that he understands. Mr. Martin, you are lead counsel. You are your own lead counsel and you choose to be representing yourself. Is that correct?
Present myself, not to represent. I am myself, but.
Listen,
I'm not presenting myself
I'm
as
going to tell you this right now. I'm going to say it one time. I'm not going to sit here and split hairs on meanings of words. To represent oneself or present oneself means the same thing. You are speaking on your own behalf. Yes?
Right, yeah.
Right, very good. Both of them mean the same thing. So we're not going to play semantics because literally I'm a walking thesaurus. So I'm not going to do that. And I'm going to shut that down because you're just going to waste time. And I'm not here to stall and waste time. I'm here to make sure your due process and you have a fair trial. And as part of that fair trial, you're not going to try to disrupt the proceedings by either stalling, playing some antics with, well, it's present instead of represent. It literally has present in it. Represent just means to redo it again. That's all. And so every time you go up, you're just representing yourself again. You're representing is what it means. That's what represent.
Try to make it the semantics of the.
So anyway, so here's the thing. You're going to be the lead counsel, so you're going to do your opening statement, things like that. You're going to follow the court rules. You're going to follow the same rules of evidence that everybody else follows. Mr. Greco is not going to have any advantage over you. You're not going to have any advantage over him. If you have, you literally have a legal encyclopedia sitting next to you. Someone who is very confident in the laws and the court rules and the statutes and the rules of evidence. So if there's an objection or things like that, I will pause. I will pause. So that if you think that there's an objection and you think that there is something like that, I'm also going to ask you, because you have someone who is so astute at trial practice, if your co-counsel, are you giving your co-counsel permission to say objection when he sees something objectionable that you don't recognize? Because I'm just going to say you don't have a Juris Doctorate, you haven't formally studied the rules of evidence in a formalized setting. You could have done so online or anywhere else by library or by book or whatever. I don't know that you have or haven't, but I don't want to presume. But I just want to know for the flow of things, because if someone says something, they're going to keep asking questions unless somebody jumps in with an objection. If you don't recognize the objection, but he does, are you giving him permission to assist you by saying, hey, hold up, that was objectionable?
Yeah, as long as he's going by the law and not doing nothing that's going to violate my rights.
I just want to know. I mean, and I'm making sure that this is your protection. He's there for your protection. I'm asking this question because just from a flow of trial standpoint, somebody who knows what's going on would be, because I do it all the time, sometimes sitting here. Like someone will ask a question and I kind of like, I'm watching. And I would have said objection if I was the other side and they don't object. And I don't even know if they didn't pay attention or they didn't know, or I don't know. But I can't do that for you. I have somebody here who is very astute at that. Are you giving him the power? I know you want to speak for yourself, but this is the one situation where you have to respond like right now. You have to like block, you have to like do something. And if you don't recognize it, I want to make sure that you are giving him permission for him to do that. Is that okay?
I'm not gonna do it, but I also reserve my right to also make.
No, sure. I mean, and all I'm saying is I'm going to have him call the timeout. I'm going to have him tell the timeout flag by saying objection. Then you two of you can talk about why it's an objection and then speak to the court. Because if obviously you didn't see it or recognize it, he did. So there's probably a reason why, because he's not just going to throw out the word objection for every little thing. You're also not going to throw out the word objection for every little thing. Because if you say, I'll give you three. If you come up with three frivolous objections in a row because you don't know the court rules, then I'm going to turn the case over to him because he knows how to do it. You understand what I'm saying? I got no problem with you and your closing argument, your opening argument. Sure. If you want to cross-examine a witness, sure. But it better be within the rules. It better be as to the elements. And it better be as to the case, not anything and some other tangent about anything else. It has to pertain to relevance, because every single piece of evidence, I'm just going to give you a quick update on the rules of evidence. The first rule, rule 401, is that all evidence must be relevant. So if it has nothing to do with the elements of driving on a revoked license, I don't want to hear it. If it's anything to do with bias, yes. You can go into bias because that is one of the things that you can bring up under Rule 403. But under Rule 403, there's also overly repetitive evidence. So if you're going to ask the same question 20 times, just in 20 different ways, you're going to get an objection, and I'm going to sustain that objection. You understand what I'm saying?
comprehend.
Okay, very good. That's all. And I just want to make sure so that, because everybody who's here, who's going to be in a jury, they have a right to serve as jurors. And I'm not going to have them sit here for an extra hour just because you want to play semantics, because now you're violating their rights perhaps by doing that. But I want to make sure that you have full representation. I want to make sure you have full due process. I want to make sure you have access to an attorney. And again, I'm going to ask you, are you knowingly and voluntarily choosing to not take house counsel? You're going to represent yourself as lead counsel?
Again, like I said, before,
Just a yes or no. I mean, are you representing yourself as lead counsel or knowingly and voluntarily?
I reserve my right to say what I want to say and help myself with the case, but it's also okay for him to, also want him to do his duty and offer me the effective.
So that's what I'm saying. Is I don't want to leave him in a position where he doesn't know exactly what his duty is. He's either lead counsel or he's just a helper who's just going to sit there. Unless you ask him a question, he's not going to do anything. That's why I'm trying to ascertain exactly what it is you want from him. Officer Rose, good morning, sir. I'm well. I'm always well.
Okay, well, first remember, Slavin, you said yourself, you said it was okay, Judge Slavin, you said it was okay that I say what I want to say, and you say the basics. So I don't see what the questions.
The questions aren't so much for you. The questions are basically because I want to define the parameters of what your co-counsel is going to be required to do. Because I'm not going to have a situation where you're like, well, he didn't say objection on this one time and he could have had an objection and now I'm going to sue him. Because you're asking me to appoint him sort of with one hand tied behind his back. He's either going to be able to do his job to the fullest extent and represent you as a zealous advocate that he is, or he's going to be an encyclopedia of legal knowledge sitting there only waiting for you to take the book off the shelf. I did create that one situation where you could let him carte blanche. If he thinks there's an objection, say objection, which will just basically be a timeout. Then you can group or powwow, whatever you want to call it, about what that objection would be. And then we'll proceed and I'll make my ruling on it. But other than that, he's not going to jump in, chime in, any of that. Is that what because you're running the show on the representation, correct?
Well, yes, but I was going to say
there's no.
I don't want to give up my right to effective assistance of counsel.
Right. That's what I'm saying. You're either going to accept it or you're waiving it. There's no half waiving it. You understand what I'm saying? And I'm just making sure what it is because I don't mind whichever way you choose.
Based on what he just told me, I should say lead counsel based on not just because what he told me, but.
So based on, well, first,
like I said, I want to do this job. I want to say whatever I'm saying.
Hold on, because I don't want you to say, because I don't want to hear whatever private conversation you had between the two of you. Because I know you just said the words based on what he just said. I didn't want you to say whatever, because that's private. No one can make anybody testify what you two talk about. That's privileged. If you say, listen, if you say to the court, or if you say to anybody, anything he said, it removes and washes away all privilege to it. Okay, so I'm just letting you know that. So you understand. So any conversations you have with counsel, even though he's not technically counsel, but he's your assistant counsel, any conversations you have are privileged. So unless you say, well, he just told me this, well, now you just threw it. So I'm just trying to lay these ground rules so that we don't run into this during the trial anytime. So that you understand and agree. And I just want to make sure that you are knowingly and voluntarily choosing to represent yourself, knowing that I would have given you full access to an attorney. You're choosing not to take that access and you want to represent yourself. That's correct?
I'm choosing to present myself, but also I'm not waiving my right to be helped by him because I still have the right to do it. So I was still
okay. So if he sees any objections, he can do objections, but other than that, you'll just stop and ask.
And like I said, then
okay.
We can't. I ain't projecting the
just
future,
making
so
sure.
I don't know what's going to happen. You don't. But as long as he don't say something violates my rights, if he does, then I'm going to let that be known. I'm object to him, whatever.
Well, see now we're right back to. All right. So you know what? I'll just play it by ear. And if I think that you're doing anything at all that's contemptuous or just trying to stall on this, then I'll make my rulings at that point. But
I feel very comfortable with the understanding of the speaking objections, just so I'm on the same page. Everything else I will serve in a co-counsel role until directed otherwise.
Yep.
Very good, sir. Thank you.
Very good. All right. So now as to the motion. Doesn't have a motion. Oh, I just. So if they can't hear, I don't know if they can't hear. I don't know. It's not my problem. It's the public comment. I'm not sure what's going on. All right, so I see you, you filed a motion this morning. This motion is a motion and demand to dismiss or discharge this case based on equal protection clause violations. And I have read through your motion. And did you give your co-counsel the opportunity to read the motion? Just in case if he asks you any questions, or if you ask him any questions.
Your Honor, I have had an opportunity to review all of the pro se motions that have been filed in this matter. So yes,
including the one this morning.
We had a chance to review it together.
Okay.
Yes, sir.
Right. Just want to make sure in case you need to assist in that way.
I guess I'll just add, I have nothing to add.
Sure. All right, so this is your motion, Mr. Martin.
Yep.
And basically it states that you think that there's a conspiracy between the police department, Officer Borg, Mr. Greco, and myself to prosecute you and keep you from getting your moped back. So basically,
Not just it. It's no. It's not completely totally current. So okay. So the prosecutor called herself supposedly prosecuting me here on this case when I have sought to prosecute Anthony Borg for stealing my moped, which is larceny, without my consent, in violation of Declaration of Independence of 1776, along with my due process rights of the Michigan Federal Constitution. Okay, he had it towed immediately, and like I said, I filed actually state criminal charges myself with this court. They haven't been acted on. Greco here has not made no effort to prosecute it, and basically, like I said, so that violates my equal protection right. You know, if I'm being prosecuted, I have the right to prosecute when crimes being committed against me. But that hasn't been respected in violation of my crime victims' right of the Michigan Constitution. You know, in addition to the due process. So yeah, like I said, so it violates equal protection clause violation, not allowing me to prosecute also for the crimes committed against me. Therefore, the case should be dismissed based on that.
and Mr. Greco.
Yes, very briefly, Your Honor. I just had an opportunity to look at it, and this motion has no basis in fact, law, or logic. Mr. Martin is being prosecuted validly because he was operating a moped on the road with a revoked license and or no valid license. The moped was taken by area towing at the time because it cannot be left side of the road and not left in his custody when he is refusing to acknowledge that he is supposed to have a license to operate a moped on the road. There is no basis to charge anyone else criminally or conspiratorially in this matter. So it should be denied.
Judge, can I respond to that?
I'm sure.
Okay, well, first of all, state statutes cannot violate the Constitution. As we know, and the Constitution clearly says that property is not to be deprived before a due process of law, before a hearing. That was, as you just admitted, it was taken by area towed immediately. You know, before a hearing, without any due process of law. It did violate due process. And besides that, based on my right to travel, my right to own my private property, I wasn't supposed to take it anyways. So the state, even there's a state statute that seems to allow it, it's an unconstitutional state statute, and that doesn't override the Constitution. Again, the Constitution says private property is not to be deprived.
All right. So based on all the testimony that I just heard and reasoning, plus after having read through the motion, I am going to deny your motion. There is no violation of equal protection under Michigan Compilation Law 257.252A. which is the abandoned vehicle statute. Anytime that there's a situation where a vehicle has to be abandoned, obviously the driver of the vehicle was arrested for not having a driver's license. That vehicle can't just sit there on the side of the road, because why? Well, that's the city's job to protect that, and it also becomes evidence of of what was taking place. So that has to be impounded pursuant to the abandoned vehicle statute. Additionally, the due process that you say you are not going to seek, you actually will seek, because it's built into Michigan Compiled Law 257.904B, which states that when a person is convicted of an offense that's punishable by that section, the local ordinance, basically for operating a motor vehicle while their license is either suspended, revoked, or denied, the court shall order that the motor vehicle, if it is owned in whole or in part by that person, and the court shall order that the vehicle be impounded for not less than a period that the court orders, but not more than 120 days from the date of judgment. But what happens in the meantime and in between time is an actual trial that we're about to have right now. So that is the due process that the Constitution affords, because if it's found not guilty, then your moped gets put back to you. There is no cost assessed to you. The city will pay any cost for impoundment and fees. Why? Because you're found not guilty. So the fact that you're stating that you're not getting due process, well, we're about to start the due process, which is the trial. So for those reasons, your motion is denied. Now, you can put that in the file. Put that here. Denied for reasons stated on the record. Right. Now, with regard to one other supplemental thing. So the civil infractions that are in here, the no proof of insurance and the defective tires, those both stem from the same incident occurrence?
That's correct, Your Honor.
And are we setting these for a formal hearing? Are we having these as a formal hearing now with regard to these as well?
However the court wants to proceed. I mean, if we have a jury, we've got a jury. I mean, we can
Because the jury doesn't do these.
Right. I mean,
so
if you want to do
because what I'm saying is I have no problem if you're going to put in evidence and it's going to be the same witness and I got everybody here, I will make a ruling on these after and outside of the jury's decision-making and vision. So they're not going to see that, so they won't be influenced in any way by it as to, well, the judge said he's already responsible for those, he's probably guilty. They won't hear anything from that. I'm just saying I'll make that a separate ruling on this, but we're going to have the formal hearing with regard to these, because I think having a trial on this is about as formal as you can get. So, but all of the decisions and everything about these will be outside of the jury's presence, because I don't want to taint the jury to think that, you know, oh, well, the judge said he's guilty of the other things, so he's probably guilty of this. They're not going to hear any of that. Just put it in your evidence and I'll make sure of it afterwards.
Okay, fine. That's what we'll just address it during the correction process.
And Mr. Martin, with regard to that, you'll be able to cross-examine about anything like, you know, the tires. They won't understand what it has anything to do about anything, because I'm not going to instruct them that they're even thinking about that. I'm the one who'll make the decision on that, because these aren't jury trial things. It's just civil infractions. So, and that way it's not going to, they're not going to get into it or about anything or hear anything about it really, other than they're going to hear the evidence for everything. I need to hear the evidence about this. So if you have any cross-examination with regard to defective tires, if you have any cross-examination with proof of insurance, you know, I don't know, maybe it was on your phone, maybe it was in your pocket, or I don't know. I don't want to put it, I'm just saying you can ask about all those things and make sure you're doing that, because we are having the formal hearing on these as well. So they won't understand that it has anything to do with their stuff. I'll make that determination after they're gone, so that way it doesn't change their viewpoint of view. Okay. So
we're clear, Your Honor.
Okay, very good. So let's go ahead and any other supplemental matters.
I think there was one outstanding motion that at our last pre-trial hearing, Mr. Martin attempted to address with the court. I believe it was filed. I see a motion with an October 25th date. Is this the same argument?
October 25th.
Your Honor, it's a motion titled motion for demand to dismiss discharge these cases based on the attached legal arguments titled nobility. I don't know if the people were served a copy of this pro se motion. I did get a copy from your court staff.
Okay.
Let me converse real briefly with my client to make sure he wants to move forward with this argument. Okay. My apologies, Your Honor. He is ready to move forward with this argument.
All right, so the only other outstanding motion, and then the last time we were here, I said on the day of the trial that we'll clear up any outstanding motions that had not been heard. The only last motion, and obviously you filed a new one this morning that you brought with you, and we heard that, we discussed that. So you have this other motion for demand to dismiss and discharge these cases based on the attached legal arguments of title of nobility. So give me 1 second too, because I don't know if it's, did you have attachments to that? Because I see you got your handwritten.
Yeah. So
You got your hand, what I was saying, I have your loose leaf handwritten motion like I see on your normal motions, but then I see like some pages that are, I don't know, it says page 49 of 88. So there's not 88 pages to your motion.
That was in the mayor should have crossed some page. I would have been a little more professional, I guess, but you know, that's.
No, I'm not.
I'll tell you how many pages that should be here. Okay.
I'm not speaking to your professionalism. I just want to make sure that I'm not missing the other 88 pages. That's all.
Yeah, that's on the page now. 5, 6, 7, 8. I'm counting 8 here. 8 in addition to the motion of the actual legal argument. You know what I mean?
Okay, so I got 4 pages of, I got 4 photocopied pages and then 2 handwritten. So 6.
Motion to dismiss. 6. You have 6 total pages.
6 total pages.
Hold on, I think you should have 8. Let me see.
One of the pages that's in our possession is a blank page that's looks to be a photocopy of a hand, just loosely notebook.
Let the record reflect. I'll just go through what the court has. You tell me if I'm missing something. Okay. So I have dated October 25th. It seems to be your title page where it says regarding City of Taylor versus Eric Martin, and it says sincerely Eric Martin in red. This is your opening first page, and then I have the motion heading page based on the attached law that is in demand. It is demanded that to take judicial notice of. Okay. And so that's the 2 front pages. Then I have
8 pages of a legal argument. I just counted 8 more pages on each there.
Well, there's 2 handwritten, and then there's 1, 2. So I have page 49 of 88, page 51 of 88.
That should cross out maybe maybe
page
more
53 of 88.
Number of the pages.
I know. Oh, that way they're numbered, but I just want to make sure these are the numbers that I'm supposed to have. 49 of 88, 51 of 88.
Wait, where's 50? 40,
53 of 88, and 55 of 88.
Oh, you went from 49 to 51. This is skipping the page.
I don't know. I didn't file it. I didn't give it to myself.
Right. So you should have 49. Hold on. Let me look at it. Let me see. So you have 49, 50, 51, 52.
I have a working theory on this, Your Honor.
I don't have 50.
pages. I have pages that have the court stamp every other page. My suspicion is this was double-sided. Did you write that? Were these printed double-sided?
No, I didn't send them double-sided. So
may I approach the judge with
sure. If you could just take page 50, because I don't have 50. I don't have 52.
Your Honor, let the record reflect I'm approaching with the entire motion. Mr. Greco,
Judge, just looking from here, it looks like yours are double-sided.
Oh. Yeah, see, mine are double-sided. Okay, hang on a second now.
Okay. Yeah. So that's what I'm trying to get us into it. Here's your motion.
All right, so yeah, I got 50 on the back. So I guess you did print it double-sided or something, or.
Sorry for the interruption. It sort of looked like that's what happened.
Good call, good pickup, but the record reflected that also violates the Michigan court rules with regard to pleadings. But in an improper state, I'll go ahead and take it in the light most favorable to the improper defendant. So. All right, so Mr. Greco, do you have a copy of this motion?
I do.
Okay, you do. All right, so Mr. Martin, go ahead with your motion.
Yeah, so with this motion, some of basically what's already said in here is the driver's license. Okay, the U.S. Constitution started with Article 1, Section 10. The state's prohibited from granting titles of nobility. Driver's license is a title of nobility. It's a special privileges for so-called drivers, and it's prohibited.
Okay. So do drivers get the nomenclature of king, duke, duchess, governor, but what specific nobility titles are given to people who are drivers?
As it says in here, like I put in here, it's a privilege granted to a certain, right here, a title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8A, page 40, a driver's license is a privilege which is granted by the state as a corporation.
Sir, I am going to ask that you not mumble. You're going to have to speak up because it's hard to hear. I can barely hear you, and I know that Ms. Hancock is going to have a hard time trying to make a record of this.
Yep, just the title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8A, page 40. A driver's license is a privilege which is granted by the state. There's a lot of arguments to say here, but basically sum up, like I said, the driver's license title of nobility, it's a special privileges granted to so-called drivers, certain select group of people, and U.S. Constitution, Article 1, Section 10 prohibits the state from granting titles of nobility.
Mr. Greco?
Yes, very briefly, Your Honor. The argument that he's asserting with regard to this applicability to driver's licenses has no applicability whatsoever. As the court is aware, being a constitutional historian and an American, that the titles of nobility was a big deal at the time of the founding of our country with respect to nobility titles such as that you described as king, duke, things that would be granted to somebody just by either right or granted certain rights by that title that have no application whatsoever to a state issuing a driver's license for those that are able to obtain one in the state. There's no applicability whatsoever.
So I will note that the Oxford Dictionary defines nobility as the quality of being noble in character. That's one. Two, the quality of belonging to the aristocracy. So, like Mr. Greco said, that's like you're a monarchy or whatever your setup is, like in England, that kind of thing, duke, duchess, all that good stuff. So, contrary to Roger Miller and the fact that is anybody who's the king of the road, it's not true. There is no nobility that comes along with driver's license. When they use privilege to talk about privilege, that is in opposed to a right. You can either have something that's a right, or you can have something that's a privilege. And a privilege is something that can be regulated for the safety, health, safety, and welfare of all citizens. Like I said, you keep talking about a right to travel, you got a right to travel. You know what? You can walk anywhere you want to. But if you're going to use something that can hurt somebody else, that needs to be regulated, such as a plane. You can't just go and buy your own helicopter. Just, you know what? I'm tired of all the traffic jams. I'm just going to fly my helicopter from my backyard, land it on top of the courthouse, and then I'm going to just, park here. You know what? You can't do that without a pilot's license. Why? Because you could literally kill people, like if you fall out of the sky. So there's a reason cars can kill people. It's no different than why you have to have a permit for certain weapons. We have a right to, and that's the clear right to keep and bear arms. But you still have to have certain weapons. You have to have a permit for those things. And, so there's regulations that go along with that for the health, safety, and welfare. And giving a driver's license is because we want to make sure, the state wants to make sure that anybody who's driving has the basic knowledge and understanding of what it takes to drive safely, so that it's going to be for everybody, for everybody's benefit. So with regard to the violation, there's been no deprivation of your constitutional rights, and there's been no violation of the Constitution. And the fact that you need to have a driver's license is something that has been ruled upon by the Michigan Supreme Court, by the United States Supreme Court, and the right to travel does not supersede your ability to need a driver's license. You can travel all you want to, like I said once before. You can walk yourself all the way from good Forest Gump from here to across the country and all the way back. But you gotta do it by walking, maybe even riding a bike or something that doesn't require a license. But for licenses, certain things need licenses, and there's a reason for it. And all of those have been hundreds of cases that say, yeah. So for those reasons, your motion is denied. So now let's begin by bringing in the jury.
Can I object to that? I'd like to respond to something that you.
There's nothing to respond to. I've made my motion I made my ruling on your motion, and your motion is denied. If you want to appeal it, you can appeal it to the circuit court, but that's between, all right, so.
That will be
right now,
actually.
before we get into the.
All the persons will provide notice that the court will be appealing all the issues that's,
duly noted.
diverse and deny my motions and demands based on the Constitution.
Duly noted. All right, so I have,
Fraudulently assumed defendant. Like I know that might be above your guys' head because that's something more someone knows it's been studying law for 20 years, more advanced stage, but it's backed up by laws called Roman Necessity Trust, corporation or defendant. But anyways, I got some proof to prove that, some laws going to prove that. The law applies that someone, actually the words used specifically in state law, a person must have a driver's license to drive a motor vehicle, okay? So that's the first fraudulent thing that's being done here. I'm a human being that's being fraudulently assumed to be the person, and I'm going to show you a Supreme Court's case law that says a person is not one of the sovereign people, as a person is defined in statutes. This is the U.S. Supreme Court talking here, not just me. Now, this whole case started from the harassment and retaliation of Anthony Borger, the police officer. He sees me riding down the street and calls me over, hey, come over here. And he had no probable cause. Just he recognized me as one of these, I'm a prolific complaint writer on the cops' misconduct, him and his friends. I don't have all the complaints with me now. I wanted to have them, but it was, the last stage. I thought about bringing all that. I tried to, I wanted to adjourn the trial, actually, so I can get that evidence to show all the complaints I filed. So if there's going to be any dispute whether I filed a whole bunch of complaints with the police, which supports my retaliation claim, which is the whole reason why this case was brought up by him in retaliation, because, like I said, I filed a lot of complaints on his officers. Yeah, and now, besides that, as to a flat tire, we can kind of see it's kind of obvious that this is not just a case where he's enforcing law doing the right thing. You see someone with a flat tire, is that a reason to pull someone? He wrote that ticket actually on a flat tire, having a flat tire. Talk about nonsense, talk about harassment, retaliation. Like having a flat tire is something wrong in this world. When someone gets a flat tire, what is wrong with it? Nothing. But he writes a defective ticket. That just shows, like I said, his retaliation, his animosity against me. But none of this will scare me and discourage me from forcing my rights. I've been doing this 28 years. I'm going to keep doing it. I'm one of God's righteous soldiers and warriors who stand for my rights and the people's rights. I truly represent the people. These guys, on the other hand, they don't represent the people. Probably what do they represent? They represent the city, a corporation that wants to make money out of people's rights, violating people's rights. Such as this. This is all about, really, the charges about me exercising my right to travel on my moped. Okay, and I don't dispute that I was traveling by right on my moped. Now, I know the state law, well, maybe it's more for an argument, without too much detail. I'm supposed to be more briefer. But basically, it's about me traveling by right. Despite what he says, the U.S. Supreme Court says we have that right. He calls it not traveling by right. But as I'm going to show you word for word the U.S. Supreme Court case law, in the closing argument, that I was traveling by right. And I ask that you guys, like I said, do the right thing, and you guys should remember a not guilty verdict, because I'm going to show you by the law that's printed out of a law book, how one, I'm not liable under the state statute because I'm not a person, I'm a human being. It may sound in case it be a certain thing, that may sound crazy. How can a human being? Well, it goes back to the Declaration of Independence, which I also have a copy right out of the law books, that government derives just power for the consent of the governed. Meaning they must get our consent to hold us accountable. At least laws, there's no injured party, no human beings or property has been harmed, such as in this case. They don't have my consent. Move forward anyways, violating that. Violating the 13th Amendment, right against slavery. Yeah, so like I said, it wasn't a person, and it was exercising my right to travel and trying to convert this right to travel into a crime, which they're not allowed to do, by calling it driving. See, this is how most people don't know it's called legalese in the law. So this is how they get into, they're putting a blanket over people that have people that don't study law. They call it, what they're calling traveling by right is they're calling it driving a motor vehicle. But there's a federal statute I have. Surprised I couldn't find on my paper, but it's 18 U.S.C. section 31, subsection 6 and 10. That defines a motor vehicle. Remember, the state statutes just say, remember, you need a license to drive a motor vehicle. Okay, now the state code just say a motor vehicle is anything mechanically drawn, excluding electric bikes and other electric things. But federal statute 18 U.S.C. section 31, subsection 6 and 10 defines a motor vehicle as one not just mechanically drawn, but also one being used to carry passenger property for profit. And again, the reason why they made the statute Congress is because of our right to travel, which is supported by U.S. Supreme Court case law, Packard versus Banton, which I'm going to show you right out of the law book. This ain't nothing, that I made up. It says the same thing, basically. The legislator cannot regulate the use of the roads unless the people are using the roads for profit, because that is the privilege. And that's where the license is needed. And I acknowledge that. That's what I wasn't doing it at the time. As the evidence is going to show, also has no evidence that I was carrying passenger property for profit. Meaning I wasn't driving a motor vehicle. Yes, the state codes might not support me on that. I agree with that. Not on that argument right there anyways, that, but the federal statute does, in Article 6 of the U.S. Constitution makes it clear that federal statutes are supreme law of the land. They override state statutes, meaning the federal definition must be applied here and listened to of a motor vehicle, which is carrying passenger property for profit. They got no evidence of it. They can't prove a case, but I was driving without a license. Actually, I beat the case on the same thing in Southgate, which I meant to bring the order up, but I didn't. I forgot. It was one of the few things I forgot. Did you say a whole bunch?
Mr. Martin, you're not going to be able to talk about a case on Southgate.
I didn't know that.
It's not relevant to these proceedings.
Well, can I respond to why I think it is relevant? Because I'd like to do that.
No, I'm just telling you it's not relevant, and I'm not going to have you convolute the case with something from a different case from a different city. Because I don't have any clue what they're talking about with that case over there. So it has nothing to do with the relevance here.
Okay, but that's also, well, yeah, basic. Like I said, we're going to go more in depth of closing argument, but we're going to sum that up then. Pretty much said everything I want to say, but based on that, because I wasn't driving a motor vehicle, exercising my right to travel, and because I was being harassed and retaliated against from the jump, you had no probable cause to pull the case should be dismissed. Misconduct on his part. And also, one other thing, as a criminal law enforcement officer, his duty and realm is to stay within enforcing criminal laws. Okay? And under I know the statute may call it a criminal law. I realize that. But you understand, statutes violate people's constitutional rights in the common law all day long. I can point out 1,000 different things that we found class actions in getting rid of these statutes that violate people's rights. But anyway, common law says crime is only when the human or property is harmed, and that's how it should be. Because if they're holding people in jail, locking people up for not harming them, why they're doing it? They're doing it because the city can make money. Everyone can make money off of violating people's rights. It's a damn shame. And then, yeah, so anyway, so he's acting outside of his criminal law enforcement realm and acting as a civil revenue officer because everyone's getting paid. And by the way, he's getting double time on this. And these cops, they get overtime pay for coming to court, so they're encouraged to write tickets.
Mr. Martin, you're bringing in things that are not even in evidence, that are not even relevant to these proceedings.
Okay, I plan on making the other question on it. I'm gonna be questioning on that. Okay, well, so yeah, I guess that's about it. Like I said, as you guys do the right thing, do the godly thing. You know, stand for people's right, find me innocent as I am. I'm not someone who thinks I can go around, hurt people or property. This is a victimless so-called crime. I haven't harmed no one. I should be sitting in jail for it, but you see the statute, like he said, right? It's up to 93 days in jail. And a fine for doing what? Nothing wrong, haven't harmed no one. As far as a driver's license, you know, slaving, I don't know if I'm allowed to comment on this, but so I am told unless it says otherwise. But a license ain't really necessary for the safety of it. You know, I've been riding my motorcycle, you know, actually got a separate case on that, but, and this moped for a long time, years. I've been crashing on. It's not necessary for a license. All you gotta do is pay attention, common sense. What's the speed limit? Stop at a stop sign and turn the left signal. It doesn't take a GED, it doesn't take a college degree, it doesn't take a license. I admit it's better. It might be better and it's supposed to just be recommended, but it's not. Where they're violating people's rights on this to travel by saying you must have one. And then they're not even calling what's really a license to drive a motor vehicle. Truthfully, again, to repeat myself again on that. When they're exercising right to travel, they're calling it driving a motor vehicle, and they're really not. And then that's a privilege. But like I said, as I'm going to show you, the U.S. Supreme Court defines driving a motor vehicle as when you're only using roads for profit. The federal statute makes that clear. So, yeah, so you guys should find me not guilty and stand for the people's rights and don't allow this corporation, this is what this prosecutors represent. You know, Slater, he denied all my motions on this, so they're denying my constitution's left and right. It's necessary that people stand up for the people's rights, or they're going to keep violating people's rights. We shouldn't stand for that. We should stand up for the people's rights. So that's it. I ask you guys, like I said, find not guilty. Do the right thing. Thank you for your time.
I am going to, before we begin, I'm going to further instruct the jury that any law that you're going to hear and consider is going to come from me. I am the one who is going to tell you what the law is, because I am the one whose duty it is to tell you what the law is and what the instructions are. You'll hear facts from the parties, but any law that you hear from the parties, you can disregard, because that is absolutely going to come from instruction from me. So.
Objection, I object to that. You saying I can't make a legal argument?
I didn't say you couldn't make a legal argument, sir. I said that any instruction in the law, they're going to hear from me. I'm just making sure that they understand that where the law that they're going to apply and where that law comes from, and that's going to come from me. Because that's the way it works. And with regard to Mr. Martin's statements that I have, or this court has in any way, shape, or form violated its constitutional rights, I'm going to just note for the fact that this court has been nothing but patient to make sure that Mr. Martin has been able to make a record about everything he wants to make a record on. And there has been no violation of any of his constitutional rights. So I'm not going to mention any of the motions that were made, even though he mentioned them. You're going to disregard any of those because those are not evidence. That has nothing to do with the case itself. So we're going to proceed with the first witness, Mr. Greco.
Yes, thank you, Your Honor. The City of Taylor calls Officer Anthony Moore to the stand.
Officer Moore, do you solemnly swear from testimony about to give us the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please be seated, sir.
Okay, Officer Moore, please state your name for the record.
Officer Anthony Borg.
And are you currently employed?
I am.
And where are you currently employed?
The City of Taylor Police Department.
Okay. And what is your position of employment there?
I am a patrolman.
Okay. Does that include, do your job duties and responsibilities include traffic law enforcement?
Yes.
Okay. How How long have you been a member of the City of Taylor Police Department?
Approximately 5 years.
Okay. Are you assigned to a specific detail or patrol?
I'm currently assigned to the traffic bureau.
Okay, so this is what your regular job is traffic enforcement?
Correct.
In addition to general police duties?
Yes, sir.
Okay, thank you. All right, I want to take you back specifically to July 11th, 2023 at approximately 4 o'clock in the afternoon. Okay, were you working that day?
Yes.
Okay. Do you recall where you were in the city of Taylor at approximately 4 o'clock that day?
I was sitting in the entrance to Heritage Park off of North Line Road.
Okay. And what were you doing there generally?
At that time, I was monitoring the traffic at the intersection of North Line and Racco.
Okay. Do you recall encountering a person or a human by the name of Eric Martin that day?
Yes.
Okay. And is Eric Martin in the court today?
Yes.
Okay, where is he?
Sitting at that table in the collared white shirt.
Okay. For the record, Your Honor, I'd like to point out that the witness has identified Mr. Martin at defense counsel table. So noted. Okay, what were the circumstances under which you encountered Mr. Martin at that day and time?
I was watching the traffic at the intersection North Line and Racco when I observed a red moped traveling northbound on Racco Road approaching North Line. At that time, the light for the northbound traffic on Racco was red. As the moped approached the intersection, I observed what I believe to be a flat tire on the rear of the moped. While the light was still red, Mr. Martin exited off the moped in the middle of the roadway, walked to the back and was looking at the tire. While he was doing this, the light turned green. After approximately 2-3 seconds, he proceeded to get back onto his moped where he crossed over North Line Road into the entrance of Heritage Park.
And what did you do at that time?
At that time, I was waiting for, as I was parked stationary in the entrance to Heritage Park, he was traveling towards me. I was waiting for him to get to my location, and I was going to initiate a traffic stop for impeding the flow of traffic at the time.
Okay. And for the defective tire?
Yes, sir. Yes, sir.
Is it? Okay, so at that point in time, he was coming toward you?
Yes.
Okay, so what's the next thing that happened?
I initiated a traffic stop.
Okay, did you pull out behind him or did you get out and wave or what did you do?
So as he approached me, I activated the lights on my patrol car. I exited out of the driver's seat and I advised him to come over to my location.
Okay, all right, because he's on a moped and he can go right toward you?
Yes.
Okay. Now the moped is what we would consider a standard moped, like a two-wheeled vehicle, correct?
Yes.
Propelled by a motor.
Yes.
Correct? Okay. Or self-propelled by a motor. Okay. All right. So you called Mr. Martin over. At that, let's say, prior to July 11th, had you had any interaction with Mr. Martin?
I have had prior interaction with Mr. Martin.
Right. Did you recognize him that day?
As he started approaching closer to my patrol vehicle, I recognized him.
Okay. All right. So now you waved him over. He comes over to you. What's the next thing that happened?
He brings the moped over to my patrol vehicle as I exit. I told him to come on over. I asked him for his driver's license, at which point he told me that he did not need to provide one. I reiterated to him that he did need to provide a driver's license as he was driving a vehicle on the roadway. At that time, he produced me with a Michigan identification card.
Okay, so is a Michigan identification card something that's distinguishable from a driver's license?
Yes.
It's not a driver's license, correct?
Correct.
Okay. Did he indicate to you that he did not have a driver's license?
He made a comment stating that he did not have a driver's license.
Okay, so he hands you a Michigan ID card, correct?
Yes.
Okay, what is it that you do next at that time when he hands you that?
At that point, another coworker, Officer Anthony, arrived on scene. While he stood by with Mr. Martin, I went to my patrol vehicle. Using the in-car computer, I queried Mr. Martin's name information, which indicated that his driver's license was in fact revoked.
Officer Varg, I'm going to approach you with what's been marked as People's Exhibit Number 1. Just take a moment to look at that. Now, before I ask you about this, your testimony is that when you had looked up on your in-car computer, which is it linked to the Secretary of State?
Yes.
Okay. And it come up Eric Martin revoked, correct?
Yes, sir.
Okay. Now, I've handed you what's been marked as plaintiffs or people's exhibit number 1. Can you take a look at that and tell me what this is?
It is Mr. Eric Martin's driving record.
Okay. Does it indicate anything with regard to the status of his driving record?
His status is currently revoked.
Okay. Now, it looks like that this is a certified driving record, electronically certified in compliance with 257.204A as of October 23rd, 2024. So this looks like it's his current driving record, correct?
Yes.
Okay. And in looking at the driving record, does it provide prior violations or sanctions?
Yes, it does.
Okay. And up at the top, it says revoked, correct, on the upper right?
Yes.
And then with regard to the violations, I see some regarding 2020 years, 2021 and 2022. Can you see where the sanctions are for the Secretary of State and what it indicates?
Yes, it indicates revoked.
Okay. So those would be years prior to your stop on July 11th, 2023, correct?
Yes.
So it indicates that his license was revoked before that time, and it was in fact revoked as of the day that you stopped him?
Yes.
And it appears that it's still revoked today, correct?
Correct.
Your Honor, the people would move for admission of exhibit number 1.
Your Honor, after speaking with Mr. Martin as his co-counsel as to rules of evidence, I would state that this is an exception to the hearsay rule under 803.6 and MCL 257.204A, so we have no objection to this time.
I would concur, admitted as People's Exhibit 1 or A?
1, I think we marked it as 1.
People's Exhibit 1.
Thank you. Okay, after your encounter with Mr. Martin, or at least during, and after you ran his name in your computer and saw that he had a revoked license or didn't have a valid one at that time, what is the next thing that you did with respect to Mr. Martin? What did you do?
The next thing that I did was I placed Mr. Martin under arrest for driving on a revoked license. I placed him in handcuffs, placed him in the back of my patrol vehicle. At that time, I queried the registration on the moped in our in-car computer, which was registered to Mr. Eric Martin. While querying that, it also indicated that there was no insurance on the moped. It would say EIVN, which is electronic insurance verification, and the N stands for no. At that time, I issued Mr. Martin a citation for driving on a revoked license, no proof of insurance, and a defective tire for the rear flat tire. I advised Mr. Martin that he could exit my patrol vehicle. I unhandcuffed him, issued him a citation, explained him how to take care of it, and advised him that his moped was to be towed by area towing.
And why did the moped need to be towed by area towing?
Well, I couldn't just leave it in the park. Mr. Martin did not have a valid driver's license to drive it away from the scene. It had a rear flat tire and no insurance on the moped, which you're required to have insurance on a motor vehicle.
And through the department, do we have an official policy on how to inventory property and things?
Yes.
So you're not authorized to like throw it in your trunk and drive away?
Correct.
No, it needs to be properly accounted for, both for the evidence for the issue or even just the property, and also for the safety and or convenience of the parties that you may be inventorying something, correct?
Yes.
Okay. Based upon your observation and you running Mr. Martin's record, it did appear to be over the age of 19, correct?
Yes.
Born in 1973?
Yes.
And this stop, this brief investigation by you and the issuance of the citation all occurred within the city of Taylor, correct?
Yes, it did.
And you observed him operating the moped on the roadway, correct?
I did, yes.
I have no further questions, Your Honor. Thank you.
Cross-examination. Mr. Martin, will you be doing cross-examination or Mr.?
Yes, and in addition, Tim, anything additional he wants to add, of course.
Okay, so you're going to, and then anything he wants to, sure.
Yeah. Hey, Anthony Boer, we have evidence that the so-called moped goes over 30 miles an hour. Are you aware of it?
I don't have evidence of that, no.
Okay, question number 2. You have evidence that the motor, the so-called motor, as you said, is in excess exceeding a 100 cc?
No.
Okay, now you said you recognize me. Where do you recognize me from?
Your address on Clifford Street?
Right. More specific, so to be more specific?
Your address, the 9,000 block of Clifford?
All right. But I mean, do you recognize me from filing a lot of complaints on you and your officers? Or your other officers, that's not.
I don't. I recognize you from the domestic violence disputes that we called to at your residence.
Are you aware that I filed many complaints on Taylor police officers with the Taylor Police Department?
I am not. That's not a part of my job description or duties to deal with complaints or to know about people who file complaints.
So you haven't heard it from fellow police officer? He wrote complaints on us.
No, I have not.
Next question. I'm some things right now, but so you say when I was crossing Northline, my tire went flat and I stopped, and that's wait, hold on, before we go there. You said I was impeding traffic. You made that statement. Can you elaborate more on that? How was I impeding traffic? Was that on, where was that at?
You're on Racco Road, sitting at the red light at Northline.
Right.
When the light had turned green, you were off of your moped, standing at the rear of your bike, looking at your tire while there's traffic behind you, impeding their flow of traveling when the light turned green.
And how long do you allege that this happened that I impeded traffic?
Approximately 3 to 5 seconds. I'm not exactly sure. It was a short period of time.
You said the light was green then? During this 3 to 5 seconds, or was it red or what?
When you first exited the moped, the light was red, but as you exited the moped, the light had turned green.
When the light turned green, did I hurry to take off, or was I still there, or what?
When the light turned green, you were standing in the middle of the roadway at the rear of your moped.
For how long?
Like I said, approximately 3 to 5 seconds.
Do you have any video evidence to support that?
I'm not 100% sure what my dash camera picked up at the time.
Okay. So now, you have the ticket for defective type. Can you elaborate more on that? What's the problem with it? Well, you said it's defective. What do you mean by a defective tire?
The tire on the moped was flat. You were operating it on the roadway.
How long was I operating the roadway? Was it short term?
Prior to my contact with you, I'm unsure how long you were operating it on the roadway. But when I observed you, you were operating the moped with a flat tire on the roadway.
So the truth say it was short term then? You observed me? It was a flat tire, then I stopped, got off it, right?
Like I said, I observed you traveling northbound on Racco, approaching Northline, stop at the intersection, and then proceed through it, the Heritage Park entrance up.
How much longer after that? How many feet after the light? Or
I'm not sure. I didn't measure it.
Well, let's say in general, looking, going off. I know exactly. You didn't have a tape ruler, but by your visual observation, how long was I traveling with this flat tire? What seemed to be, it seemed to be a flat tire. How long did you see me traveling from Northline? Is it true to say it was a short distance?
I'm unsure of the distance. I just observed you traveling on the road of Racco.
Well, let's take a guess. What would you say? It's
I don't feel
50 feet,
comfortable making
100
a
feet? 50 feet, 100 feet?
Like I said before, I don't feel comfortable guessing on how far I watched the truck on the way.
Well, then in that case, what, do you have any diagrams to show? Do you have any evidence to show from point A to point B where I suppose you traveled on this flat tire?
I do not have any diagrams. I just recall you traveling on Racco Road on the roadway operating a moped.
You can't say whether it's short term or long term, so we want to say that, right? Generally. All right. Forget anything else here? Are you guys schooled on the right to travel law?
Could you repeat the question?
Are you guys schooled as a Taylor police officer, you specifically? Have you been schooled on the right to travel by the U.S. Supreme Court? Like what the U.S. Supreme Court says on that law, have you guys been schooled on that at all?
Schooled?
Taught, yeah, what it teaches about people's right to travel. Instead of just these statutes that you guys are always going off of. You've been trained, use the word
He's
trained.
asking a fact witness about
Yeah.
something with regard to the Supreme Court.
It's the same. Okay, well, trained, I only use the word trained. That's okay, I only use the word trained. Have you been trained on the law of right to travel? Okay, that's not. I'm aware this is not.
It's not about that. You're asking somebody who is not a law professor or an attorney, whether or not, he's already answered your question. Have you been schooled or trained? And he's saying, no.
Factualized.
Special training.
Right, okay. Well, that's the only change. What does your training consist of as to what the laws are?
There's a legal portion of the police academy and regular in-house police training provided by the police department.
As to one supposedly driving. Do they touch anything about the right to travel?
I know you need a driver's license to operate a motor vehicle on the roadway.
Right. What about they haven't mentioned nothing to about the right to travel?
As I stated, I've been trained and taught in my academy and police training that you need a driver's license to operate a motor vehicle on the roadway.
That's all the questions right now. Do I reserve my right if I think of any more? That's it for now.
Mr. Hadley, anything?
Good afternoon, Officer.
Good afternoon, sir.
Yeah, sir. I just have a couple quick questions. There's no trick questions today. You know the answers to everything I'm going to ask you, okay? You did create a police report after the stop of Mr. Martin, correct?
Yes, it is.
It's factually accurate. Your police report didn't have any photographs of the rear tire attached to it, correct?
Correct, it did not.
Okay. The day that you were out patrolling, did you have the body-worn camera?
I did.
And was it active and working that day?
Yes, it was.
Okay. And as part of the preparation for this case, did you have an opportunity to go back over your body-worn cam? I mean, I kind of remind yourself of what had happened that day.
I believe at some point during one of the court proceedings, I
got a chance to go back and just kind of see what happened that day.
Yes.
Okay. Your prior testimony was you were stationary, correct? And Mr. Martin was driving towards you?
Yes.
Okay. So you could, it sounds kind of obvious, but you couldn't see the back tire as he was driving towards you, correct?
The back tire was.
Yes, of the moped as he was driving towards you, because it was
Initially, no.
Okay. Mr. Martin didn't resist or physically prevent you from fulfilling your duties that day, did he?
He did not. At first, he did not want to provide me with his driver's license, but as I told him that he was required to by the state law, he then provided his identification card.
So now I am going to put words in your mouth a little bit. So it'd be true to say the only evidence we have of the condition of Mr. Martin's tire that day, let me back up, strike that. Can we agree that the video of your body worn cam doesn't depict maybe a very crystal clear image of that rear tire?
I'm not sure. I didn't watch the body camera today before today's court hearing.
More than happy to. The stop itself is about 4 or 5 minutes. I don't really want to belabor the process, but if it'd be helpful, would you like to, again? Or how about we do this instead? Can you tell me where your body worn cam is positioned on your uniform as to like what it would typically record as your? Tell me when to stop as far as like. So if you and I are here,
my body camera's right here. My body.
But let the record reflect that the witness took a standing position at the witness chair, and he's touching the middle right side of his chest.
would it be fair if we're staying close together that you would only see the upper half of my body? You might not see everything that's below.
I guess it just depends on how close we are while interacting with each other.
Mr. Hadley, I don't mean to interrupt, but when you step in between the podium and there, you go into a dead zone.
Can't hear me.
Yeah, it's true.
My apologies. Should have addressed that before I moved around the well.
I should have let everybody know about that, but please proceed.
Thank you, Your Honor. The officer, really don't have any further questions to go down this line. So we're in clarification. There was no picture of the rear tire, correct?
Taken from me, no. I know when area towing takes possession of a vehicle, they do photograph the vehicle on the bed of their tow truck prior to leaving the scene.
So for today's purposes, the only evidence that's being admitted would be your testimony as to what the condition of the tire was, correct?
Correct.
Okay. I have no further questions for this witness, Your Honor.
That's one questions. Yeah. Why did you, what was the reason you pulled me over? Or making me come to you?
My initial reason was because you were impeding the flow of traffic at the intersection of North Line and Racco.
It wasn't for a flat tire. Next question. Now, did I provide you my ID by consent, or was it due to your threat of saying I must provide it?
I'm going to say it's objection. It calls for speculation. He doesn't know what you're thinking.
No, I'm asking him why. Okay, I'm asking him why did you make me give you my ID? Did you make me give you?
Objection, Your Honor. Asked and answered. He's already testified about the interaction and how he ended up with Mr. Martin's ID.
Sustained.
More questions, all right?
Mr. Hadley, anything further from the side?
Absolutely not. We'd ask the court to excuse this witness if there's nothing for redirect.
Yeah. I have no further questions for this witness, Your Honor.
Officer Borg, you may step down. Thank you for your testimony, sir.
The hearing officer issue, no, you're ruling on that.
Sir, the hearing officer from the city of Livonia who denied your license one time ago has no relevance to this case.
I don't want to explain why, but
It doesn't have any relevance to this case, so I can't bring in anything that's not relevant. Any further discussion is going to try to make possibly make a mistrial, hopefully in contempt of court. So say another word.
Your Honor, after advising Mr. Martin of his Sixth Amendment rights, which I think he's now fully aware of, his knowing and voluntary decision that he would like to take the stand on his own behalf. At this time, Mr. Martin will be calling Mr. Martin to the stand. I will be asking a couple questions.
Okay, so just for the record, I'm not going to allow Mr. Martin to just testify in some sort of narrative form. He's going to be asked questions by you. Is that how it is?
Yes, sir.
Okay. And Mr. Martin, you understand that you are subject to any cross-examination by the prosecution if you take the stand. You understand that?
No, comprehend that.
All righty. And sir, you understand knowingly and voluntarily that you are choosing to take the stand, knowing that you have the right to remain silent, not have that silence used against you. You understand that?
Yes.
Okay. And counsel, as a co-counsel here, has explained all of that to you. Is that correct?
Yep.
All right. And Mr. Martin, you may take the stand, sir. I find that you're knowingly and voluntarily doing so.
Stand, sir.
Would it be easier if it just stayed in the table? Madam Recorder, I'll stay put at the podium this time for us.
Mr. Martin, do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may be seated, sir. Please use a nice outside voice close to the microphone so that we can make sure that we make a good record that everybody can hear. All right?
All right.
Please state your full name for the record.
Capital E, lowercase r-I-C, of the capital M, lowercase a-r-t-I-n family. Living private man, known as sovereignty, as the U.S. Supreme Court recognizes, not a corporation, legal fiction entity. It's being fraudulently acted on as if I am.
Where were you on July 11th of 2023 at approximately 4 p.m.?
Riding my, traveling by right on my moped, about to cross the street of North Line. And I do not remember, well, give my title, I might just stick strictly with your question. Elaborate more, or just.
Let me prompt you to say, can you tell me a little further about what happened that day?
I was traveling by right on my moped. I wasn't carrying passengers of property for hire at the time. So therefore it meets the definition of travel by right. I do not remember stopping at getting off and impeding traffic. I do not remember myself doing that.
What do you, Mr. Martin, what do you recall the condition of your rear tire being that day?
My tire did go flat on me when I remember it when I crossed North Line Street. A short distance, the tire had just went flat, and I stopped the moped. It went flat. That's it. And this one, and it was a short distance. I'm thinking roughly 50 feet, maybe 100 feet. It wasn't long, but it's like any flat tire. I stopped so don't damage my rim. But so I stopped, and but also during this is when Anthony Borg.
I'm going to ask you another follow-up question. So, why don't you tell us when you first recall seeing the officer?
Once I crossed the North Line, it was just a little bit past that. Anthony Borg was there. Was another one of his partners, and he called me over. He said, "Hey, come here." So when he said that, I figured I'm going to threaten to arrest to stop, because if I don't, he may try to arrest me or write some ticket like obstruction of justice or something. So under threat of arrest, not willingly, contractually, I stopped against my consent. And this is when the rest followed. As he said, he arrested me and he forced my identification from me, which again, I did not willingly do. I figured if I didn't give him my ID, it's going to be, a charge of obstructions. I've been seeing YouTube videos, they charge by cops sometimes is they don't give their ID. They don't self-incriminate yourself, basically. They get charged with obstruction of justice. So under that threat of arrest, I gave my ID home.
Mr. Martin, let me ask a better question. Would you like to describe any of the characteristics of the device that you were on that day? You asked some questions previously about the vehicle. Is there anything that you think is relevant for us to know about this vehicle?
Well, the burden of proof is on the prosecutor. So I'm silent on that. Burden's on them.
Understood, Mr. Martin. Factually, is there anything that you would like the jury to know about the vehicle or the moped? It's your opportunity to sort of explain any of the facts that you...
No, except for I was traveling by right, regardless of what it is. It's not important, as I was shown by the law, whether it had an electric motor or a gasoline motor, whether it's called, I don't think I'm going to prove in my argument how it was irrelevant anyways. Like I said, burden of proof is on the prosecutor, not me, so I remain silent on that issue.
Your Honor, as this is a little bit of an unusual way to have a direct examination, I would like to ask an open-ended question. I understand that we can't just go for a full narrative, but Mr. Martin.
And I object to that extra question too, because it would be self-incriminating, even if, hypothetically, if it wasn't.
Understood.
Right.
Okay, then that's why we're giving you an opportunity to clear that up right now. This is your chance, Mr. Martin. I don't have any more direct questions for you right now. Was there anything else that you would like to tell the jury at this time, factually, about what happened on July 11th of 2023 at approximately 4 p.m. thereafter, immediately after?
Well, yeah, also Anthony Borg had no legit reason for pulling me over. He seen me, he pulled me over. He was going, as his testimony said himself, he just noticed me from prior experience. Now, that is not a justified reason to pull me over. You just go by and say, okay, in fact, let's say a year or two ago, I didn't have a driver's license. That doesn't mean I don't have one now, so you can't just go pulling people over because you think, because a year or two ago, the guy didn't have a license, so let's just pull him over again, let's just see. So this is why it's harassment to me, factual-wise, it supports that, and in my mind, that's what it is. And it's retaliation for my complaints. Yeah.
Mr. Martin, before I ask opposing counsel if he has any questions for you, is there anything else you would like to tell us?
Nothing else right now.
Understood. I will have a chance when Mr. Greco's done to stand back up and do what's called redirect. So I will pass the witness at this time.
And that redirect will be only under the scope of cross-examination.
I'm sorry, and thank you for clarifying that.
Mr. Greco, cross-examination.
Mr. Martin, on the afternoon of July 11, 2023, as you've testified, you were driving your moped on North Line Road near Heritage Park, correct?
No, not correct.
You didn't just testify about that?
Yeah, I didn't say I was driving. Did I use those words? No.
Were you traveling on your moped?
Traveling by road.
No, hang on a second. Were you traveling on your moped on July 11th around 4 o'clock on North Line Road?
Don't dispute that. Traveling by road.
Okay, thank you.
Same as driving.
Okay. When you were on the moped, right? This is not a Flintstones thing. You were like moving your feet. No, you just said it was a moped during your direct exam.
No.
It has a motor,
I
correct?
did not say that. No, I did not say that. I
You
said
keep referring.
I'm going to clarify, in case you misheard me. I says, regardless whether it is or not, I remain silent on that issue because it's for the prosecutor's burden to prove. I don't, sit
After you indicated it was a
moped,
It's
electric
okay.
bike.
And you were in the city of Taylor, correct?
Well, what's your definition of in the city of Taylor? Does that mean?
Okay,
subject to the corporation?
you can answer my question. Do you know if you were in the city of Taylor that day?
Yes, I was.
Okay, thank you.
All right. I just want to understand that does not.
No, it's okay. I just answered so you would understand it. Okay, so that's clear. We're good. Okay, and you just testified that you admit that at or around the time that Officer Borg pulled you over, that your tire was in fact flat, right?
It just went flat, yes.
Okay, regardless of whether it's on his body cam, it was in fact flat, right? So we can establish that?
Yes.
Okay. And you admit that you didn't have a valid driver's license that day, correct?
Yeah, I didn't have a driver's license.
Okay, that's fine. You acknowledge that state law requires you to have a driver's license. You just disagree that it should be applicable to you, correct?
No, it's not correct. As my open statement says, I do not, no, the state law does not mandate me as a human, as I will show with my legal arguments, to have a driver's license.
No.
And you're traveling by right, which is a difference by the law.
I understand. Listen to my question again. You acknowledge that the state law says that it requires to operate a motor vehicle on the road, you need a driver's license, right?
No, it requires, it says, the specific statute uses the word person, and as I will demonstrate, the U.S. Supreme Court said persons are defined as, it's distinguished from a sovereign one of the sovereign people. There's a difference. So it's really a corporation. It's all a fraud. What's really being charged is a corporation, all capital letters, names, which is not me as a human.
Your testimony that you're not a person,
Is that I am a sovereign. One of the sovereign people has just people. So
and
people are sovereign.
right, and your testimony is that because you're not a person, that you are not required under the laws of the state of Michigan to have a driver's license to operate a motor vehicle, correct?
Right.
Okay, thank you. I have no further questions.
Any redirect under the small scope of the cross-examination?
After pulling over to inspect whatever condition your rear tire was in, you were able to still drive it off? Or were you able to still drive it off?
It went down flat, but it went flat. And I can't remember if it was, went all the way flat. Actually, I think it has had a little bit more on there, but I won't feel safe sitting on it, but I could have walked away with it. And in contrast to the testimony that the police officer said, for example, it was abandoned. That was a lie. So that's something else I want to mention too. I did not abandon my vehicle. No time. It was private property. I did not abandon it. I could have walked away with it from the scene without traveling by right on, or they want to call it driving. I didn't have to do none of that. So that's another reason why they didn't have to tow it. And regardless of the flat tire issue, I could have walked away with it anyways.
Mr. Martin, based on the questions that the prosecutor just asked you, I'm going to ask you an open-ended question because you're representing yourself today and I'm assisting you with the representation. Is there anything that you would like to state to the jury in response to the questions that Mr. Greco just asked, limited to that, nothing new, but limited to that area, as the judge is instructed?
Yeah, I'm going to say to the jury as to what the prosecutor said.
Correct. It's an open-ended question to you to, again, as you're representing yourself in this, anything else that you'd like to state on this matter? Done.
Besides what I get to say in the argument, I can't. Well, actually, I do have some questions for the prosecutor. I need to get. I haven't written down.
No.
I don't know if these are considered within the realm of direct examination. Do I have questions for the prosecutor? This has to do with a legal argument. Another one to dismiss this case, which has to do with your standing, Greco. Now, for example, one of them is.
Mr. Martin, I've already made a ruling on your motion to dismiss based on lack of standing, and I explained to you
this is totally
that
different.
I have jurisdiction and that the prosecution and the city of Taylor have standing.
This is a different argument based on standing. It's different.
Different argument based on standing.
No, but
Well, first off, if you're going to make any sort of testimony while you're sitting there as a witness, it's going to be about facts. If you have any legal argument that you want to make, you can do that after your closing argument. After the prosecution closes their argument, you can ask that the jury be excused. You can make any motion that you want to at that time. I'll make that ruling, and then we can go back on the record with the jury. But sitting in the witness chair is not the time when you make a motion, when you're not going to be asking questions of the prosecutor because he's not one of the people who you get to call as a witness.
So the questions I have to ask them are relevant to a defense I have to raise. Some people don't have to raise it now.
Like I said, we'll do that outside of the presence of the jury because we're not going to have the jury tainted by any sort of bias things you're going to be bringing up that are either frivolous or have nothing to do with the Constitution.
So let me ask a better question, perhaps, Your Honor. Mr. Martin, are there any other facts that you would like to tell the jury related to the questions that you just answered to the prosecutor?
Can't think of any. I reserve my right if I remember it later. I understand it right now.
No problem. Just want to make sure that there wasn't anything we were leaving out. Your Honor, I have no further questions for Mr. Martin or any other direct at this time.
Sure. Mr. Greco, any further cross?
Nothing, Your Honor.
Hi, Mr. Martin, you may step down. And Mr. Martin, do you have any other witnesses to call?
Well, yes, like I said, I'd like to question Greco here. Yeah, he's one of my witnesses for one of some of the relevant defenses motions.
And you can't you can't call.
Right. Others are present and whatever.
You can't call opposing counsel as a witness. So,
But I
Any
think
other-
that is
any
violating
other-
my due process.
it's not, it literally is not violating any of your due process whatsoever. So, do you have any other witnesses?
Oh, no. That's the rest of our case.
That's the rest of our case. Closing arguments. Mr. Greco?
Yes, Your Honor, very briefly, I'd like the jury to hear now, just a second, whether he is a person or a human being. I believe that the evidence showed that Eric Martin was traveling on a motor vehicle, a moped, in the city of Taylor on the late afternoon of July 11th, 2023, without a valid driver's license. In fact, the record here that you're going to be able to inspect is one. People's Exhibit number 1 shows that it was revoked. It says revoked at the top. You see the sanctions here from prior years, 2021, 2022, which pre-exist and predate the 2023, that it was in fact revoked. Regardless of this, he has admitted to you during his testimony that he did not have a valid license. He's admitted to you that the state of Michigan requires that persons are supposed to have a valid driver's license to drive on the road. He don't think that applies to him. Once you hear the jury instructions, which he's already read to you, you're going to find the defendant guilty, and you should find the defendant guilty. There's no more case clearer than this. Thank you for your time. Do appreciate it.
And Mr. Martin, your closing argument?
Yes, I have a lot, so let's see, start with. All right, and now she's showing this law to the jury here. So
First off, you're not going to show any law to the jury.
So I'm not allowed to show how I'm not
Listen,
guilty.
sir, listen, I'm going to tell you, because I've told you 5 times, when it comes to the jury, their duty is to hear the facts, and it's my duty to instruct them on what the law is. I have it right here. Sir, I teach constitutional law for 20 years. I know exactly what I'm talking about. So it is my duty to instruct them on what the law in this case is. And the law in this case is there are certain elements, 3 elements. 1, that the individual was traveling or operating a motor vehicle. 2, on a public road or access road. And 3, they didn't have a license at the time, or their license was either suspended, revoked, or denied. Those are the 3 elements. Those are the law that that's the law that I'm going to explain to them. Any other law that you are trying to show is not for the jury, not to hear from you. You're not the one who has the duty to explain it to the jury. Okay? So if you think that you have a motion to dismiss, then this case would have already been dismissed. If your law that you wanted to point to was applicable, it would have already dismissed this case and we wouldn't even be in the jury trial. So if you want to make any sort of motions outside of the jury based on the law that you have in your hand, you're welcome to do so. I'll entertain said motion. But you're not going to be instructing the jury on this law here. Closing arguments is so that you can recap the facts and put your version of the facts on display at closing arguments. So if you'd like to do your closing argument, go ahead.
Well, this is part of my closing, so if I enter this as admission, my legal arguments as exhibits, then don't I have the right to show them the law that supports that I am not guilty?
Sir, you have to follow the rules of evidence just like any other litigant has to. And all I am required to do is make sure that you have every opportunity to put on a fair trial. You had the opportunity to be cross-examined. You had the opportunity to remain silent. You chose to testify. Your own co-counsel asked you a series of questions. He even asked you a very open-ended question. Is there any other fact that you want the jury to know about the date and time of the incident in particular? And you said, nope, nothing at this time. So you had every opportunity to show any other facts that you wanted to.
So I'm okay then if you're
just saying this is the time. This is the time for your closing argument. This is where you recap the facts that were put into evidence. This is where you say things like, as the evidence showed, and then you say what your theory of the case is. This is not a legal argument. This is not a dissertation on legal philosophy. If you want to make that kind of motion, I'll do that outside of the presence of the jury so as to not taint the jury. You're literally tainting the jury right now just by attempting to do so. And if you continue, I'm gonna
Maybe very briefly, Ron, I know to the end. Oh, this is going to change that. Your Honor, after having the opportunity to consult with Mr. Martin, explain to him what a motion for directed verdict would entail, Mr. Martin would like to address this court with a motion would entail. Mr. Martin would like to address this court with a motion at this time.
I'm going to ask the jury to stand up. All rise. I'm going to ask the jury to follow Officer Rose into the hallway and have a seat in the benches out there so we can come back. All right, so the jury is out of the presence and the prosecution has rested. Are there any motions?
Your Honor, just going to make a record real quick. So Mr. Martin has been advised by co-counsel that legal precedent is not going to be put forth through direct or cross-examined testimony, that this is the proper avenue and the proper time to make his legal arguments. And so he understands that, again, these, I shouldn't say what he understands. I've advised him that that's what this motion is for. This is the proper venue, and that's where we're at. Mr. Martin?
So, Mr. Martin, you're making a motion for a directed verdict, is that correct?
Yep.
Okay.
Mr. Martin, I've advised him that his burden starts with people have not, or his argument starts with people have not met their burden, and he's now to explain to the court what legal authority he has that supports that based on what we've heard today.
Very good. Mr. Martin, a very, very sound foundation has been laid for you by co-counsel. Please proceed.
As the testimony, the board admitted he did not know whether what I was traveling went 30 miles an hour or not, up to 30 miles an hour, and does not exceed 100 cc. He admitted that he did not know that. That is both of them elements. Actually, only takes one of the elements, but he admitted to both of them elements. He didn't know whether they exist. Both of them elements are necessary to exist to meet the definition of a moped under MCL 257.32B, which makes it clear that is the definition of a moped. One, it must go at least 30 miles an hour. Two, does not exceed 100 cc. He doesn't know, as he admitted, don't have evidence. So there's no evidence that it was even a moped. Therefore, the charge must be dismissed on that alone. And I have more.
All right, so let's do this for the sake of appellate representation and argumentation. You say you have more. So let me make rulings as to each of those so that the appellate court can take one, do what they want. Because, like, for example, if they overturn me on that first one, there's no point to go and do anything with the rest. So with regard to the fact that you say that this case should be dismissed because the evidence did not show that it was a moped. The evidence clearly showed that it was a moped because, one, Officer Borg said he was driving a moped. Officer Borg is a person who I don't know any person who couldn't recognize a moped. Now you're talking about what is the legal definition of a moped that you can find in some statute. Sure, I get that. Whatever. Well, there's some statute that says things that just if you can do 30 miles an hour and you have this many cc's or whatever, we'll call it a moped. But I also just need testimony. All I need is testimony from a competent individual who has knowledge of the same, of what a moped is. He was asked, did you recognize? Yeah, it's just a common moped, as you commonly know or refer to as a moped. So for that reason, that specific motion to dismiss, a motion for directed verdict, is denied. On to your next one.
I'd like to say some response, but I don't know.
You'll have that opportunity to do so on appeal, sir.
All right, well, next.
Your Honor, if I may just address it briefly.
I'm sorry.
Was it all?
I ruled that.
Okay, fine.
It was clear testimony by Officer Borg that he recognized it as a moped.
And the statute requires that he's operating a motor vehicle. The definition for a moped only applies to whether or not you could get a restricted license.
Sure. But he's clearly not 15 to 19 years old, so it doesn't matter.
It was every vehicle that's
it was a motor vehicle, absolutely. Yeah. And there was testimony that it was on the road. It doesn't matter how short or how long it does. It's for any brief time at all. If you're operating it on operating it on a roadway, it doesn't matter if it's for a millisecond. And so for that reason, as far as the moped goes, a moped is clearly, you said you drove it off. Like you said it in your opening statement, you said it when you were testifying. So it definitely wasn't a wooden, like one of those rocking horses or something like that. It was something that actually moves when you make it try to move and you push buttons or do something and it goes. So it was obviously a motor vehicle because you weren't pedaling it, you weren't flintstoning it, and you weren't rocking. So it was motorized and it was on the road. So your motion for directed verdict with regard to the definition that you're trying to come up with about a moped is denied. Your next reason for directed verdict, sir, is?
Feel I've not met their burden because, as the U.S. Supreme Court said in Packard versus Banton, page 259, 44 Supreme Court Reporter, page 259. I have copies here to give the. I'll get one of these prosecutor. The Supreme Court, their quote, you can tell it's right out of the law book, more than I typed up on it. All right, the streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. So, as they're saying, the legislature can regulate the use of the roads when it's being used for profit. As Borg admitted, he had no evidence that I was carrying passenger property for profit. And as the Supreme Court case right here demonstrates, I have the right to use the roads as long as it's not for profit. Since I wasn't doing it, I was not driving a motor vehicle. And also, I'm not done with that argument, as an extension of part of that argument. All right, now the state statutes mention driving without a motor vehicle, use them terms, which is not a current. They don't give a real definition. I know better. Doing that 20 years. I don't know everything, but okay, where is it at? I got it over there. Okay, point, and I got copies here so you can see this right off the law book of enslaving a prosecutor. Okay, it's 18 U.S.C. section 31, subsection 6 and 10.
First off, let me make a ruling on your Packard versus Batten motion. So you, under Packard versus Batten, they make a quote and there's a citation to it. It's cited in amongst other cases as well. State versus Johnson, 243 P 1073. There's Cummings versus Holmes at 155 P 171. Packard versus Banton at 44. Supreme Court 256. There's Hadfield versus London at 98. Washington 516. All of them quote to the same quote that originally comes from Hillhouse versus the United States that says a citizen has a right to travel upon the public highways and to transport his property thereon. It doesn't say you can do it without a license. It just says that you have a right to travel, yes. But it doesn't mean, just because you have a right to travel doesn't mean that there is not a state's right under the health, safety, and welfare regulations to regulate those industries that have dangerous things. You can't drive a helicopter around. You can't drive a spaceship around. You can't, even a boat. Anything that could possibly run somebody over or kill somebody, you need to have a license. So you keep saying it. And all these people on the internet like to keep quoting to it. And it's not what it means. Read the whole case. Yes, you can have a right to travel, but the state has a right to license you. So for that reason, the Banton, sir, don't approach my bench. Don't ever approach my bench.
Excuse me, well, thought I could do it.
Listen, trust me, you can give it to me all you want. I've read this matter 100 times. I've read every single one of those cases that I just quoted to you. Why? Because I'm fascinated by it. I too am a pure constitutionalist, and I almost want you to be right, but you're not. You can't just travel any way you want to. You can't do it in certain in vehicles on public roads without a license. So for that, your Packard versus Banton, that's a misstatement of what the actual state of the law is. And yes, you do need a license. The Supreme Court of the United States has never said that you don't need a license. That federal statute has nothing to do with you driving on a road here in Michigan.
When I approach that, I show you this, you can see word for word, they say what I just said about.
I'm going to hand it to Mr. Legislator. Mr. Hadley should give it to you.
The legislator only regulates it when it's being used for profit. They said that word for nothing. They didn't say nothing about only on.
Yes, I've read this. So the streets belong to the public and are primarily for the use of the public's ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislature deems proper. You're literally proving my point. It literally says may be prohibited or conditioned as the legislature
when it's being used for gain.
No, as it means, it doesn't say that. It doesn't do it at all under the 14th Amendment. Mr. Hadley, I'm going to give you this.
Thank you, Your Honor.
That's why I read it into the record, because you're literally proving my point for me, sir.
Mr. Martin, your motion has been heard. The judge has made a legal finding on this.
Yep.
The court reporter.
Let's move on. Let's move on to the next one. Your USC.
18 USC, federal statute made by Congress defines a motor vehicle different than the state.
Hold on. This is my court recorder.
I have the copy too. I can give it to you.
My court recorder is making a recording. I want to make sure that because you start to speak a little, you get a little excited, and you start to mumble and speak fast. I want to make sure that everybody can hear you and that she can make a proper record. So you were about to tell me that 18 USC. What was the next part of the
section? 18 USC section 31, subsection 6 and 10. Both of those define a motor vehicle as one only being used to carry passengers or property, which the evidence shows, and as he admitted, I was not doing. He doesn't have no evidence to say I was doing. Therefore, I wasn't driving motor. Now, under Article 6 of the U.S. Constitution.
Can you see again? You're mumbling.
Okay, well, I'm mumbling.
So, motor vehicle. The term motor vehicle, because I'll read it right.
Go ahead. Go read the term motor vehicle.
So it says motor vehicle. The term motor vehicle. This is literally ready. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on highways in the transportation of passengers and property, or property and cargo. Okay, so
now I'm going to cut you up on add-on.
Sure.
Okay.
Now let's go down to 6. Let's go down to paragraph 10 and get the definition of used for commercial purposes.
Okay.
The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly and indirectly in connection with any business or other undertaking intended for profit. Okay. But you're talking about this section 31, and what is the whole section 31 about?
Now, well,
exactly.
You just said it's about the definition of motor vehicle. Now, Article 6 of the Constitution, point out, makes this, because Article 6 makes it clear, laws of the United States, which means federal statutes such as this, along with treaties and the U.S. Constitution, is supreme law of the land. So this definition is supreme over the state law definition, which doesn't say this. This is why I'm not guilty, because I wasn't driving a motor vehicle.
May I address that, Your Honor?
Please.
Yeah. So there is nothing that I'm aware of in the United States that I'm at least aware of that citizens of the United States or natural people or human beings can obtain a federal driver's license. The regulation of roads and driver's licenses has been left to the states with respect to the issuance of licenses and motor vehicle codes to be enforced locally and in the states. There are going to be a number of definitions for the word person, for the word corporation, for the word motor vehicle as it's applicable to any particular statute. And if you pick a federal statute that is applicable to motor carriers and it's defining motor vehicles and what's subject to those regulations, then that may be the definition. Sure. However, federal law only preempts local and state law where it takes up the space. And the federal government has not taken up a space with the issuance of driver's licenses to the citizens of the particular states. That's why you have different rules. Some you can get a permit at 15, some at 16. Sometimes you get a restricted license, sometimes all those things. It's different in every state. That's why.
Mr. Martin?
Object against
Mr. Martin.
Article 6.
Mr. Martin.
Mr.
Martin. Everything that Mr. Greco just stated is correct, and it's the reason why I'm denying your motion. Additionally, what you need to do is you need to go to section, you need to go to 18 USC, go to chapter 2 before you get to section 31. Because what it says, and actually what you need to do is you can actually go right to part 1, because let me give you the total thing so you can read the full statutory history. It's 18 USC, so that's Title 18, Part 1. Part 1 is all the crimes. These are all federal crimes. Every federal crime that you can think of, you can find in Section 18. So now we go to Chapter 2. Chapter 2 is aircrafts and motor vehicles. So every crime that you could possibly commit using an aircraft or a motor vehicle, a federal crime, is found in 18 USC Chapter 1, Part 2, and then you go to these sections. The first section is 31, and that's where you find your definition. So for everything we're about to say, for every crime we're about to talk about, here's the definition of an aircraft, here's the definition of a vehicle. And so you're going to find things like fraud involving aircrafts, violence against international airports, drive-by shootings. These are all things that the federal government has made a crime about, and they're defining just for those statutes that thing. The problem is, everybody on the internet who wants to be like, I got a right to travel, look at this, look what I found this, let's take this one statute out of context and just stand on it like it's Plymouth Rock. No, that's the definition for all the crimes that are underneath it. 31, section 31 is just a defining statute that defines all the terms that you're going to find in 31, 32, 33, and all the way down of all the crimes that federally they have, commercial vehicles that are required to stop for inspections, unsafe operation of an unmanned aircraft, aiming a laser pointer at an aircraft, all these different things that are crimes under federal law. That section 31 is only the definition for those, nothing else. It's not superseding state law. Why? Because under the 10th Amendment, anything that's not stated specifically in the Constitution reverts back to the states and its peoples. And Congress has made, like Mr. Greco said, has made no effort to say, look, we're going to create a national driver's license so you can just come and go anywhere you want. You know, you want to know why they didn't make a national driver's license? Because of Article 4, the privileges and immunities. When I go to Ohio, they can't arrest me for not having a license because I have a Michigan license. And when Ohio people come up here, we can't arrest them because they don't have a Michigan driver's license. Under the privileges and immunities, there's already a constitutional provision that allows for licensing, whether it's your license to carry a firearm, or whether it's your concealed weapons permit, or whether it's your, like hunting licenses and things like that. Sure, you gotta go right to those states. Why? Because that's their state. They still have sovereign powers. They still have their own constitutions. So your definition from 18 USC section 31, you're skipping the two parts that are in between that. And those two parts that are in between that are Part 1, Chapter 2, which tells you exactly what 31 is doing. Okay? So for that reason, it's denied. You can take it up on appeal if you'd like. Your next reason for directed verdict?
Yes, no, this is another case, Pickerton versus Berger, Michigan Supreme Court, decided in 1889. And I have the pages here to give to you, so you can show the page.
I don't need you to give me any copies of anything, sir.
584, quote unquote, they say, personal, and this is the ball in the right to travel, personal liberty, which is guaranteed to every citizen under our Constitution and laws, consists of the right of locomotion, right, not privilege, okay, to go where one pleases and when.
Sure, and you just can't do it by car, denied.
They never said it, so.
You just can't do it by car.
They did not say that.
You can walk yourself anywhere you want to, when and how you want to do it. You can walk backwards, you can skip, You can do somersaults, you can cartwheel,
Yeah,
but you can't use a car.
You can use a
So that
car,
one's
motorcycle.
denied.
They're saying
That one's
that you're-
denied. Sir, you're not gonna get argumentative with me. I've already told you that that's denied. There's no, that's not a legal argument. I admitted it. Yes, you have a right to travel. You can't do it by unlicensed driving of a vehicle.
Well, I finished reading the Michigan Supreme Court code then, how that? I was
No.
like halfway through.
Because that one's denied. For the same reasons that I've already denied the
Looks like I
same.
got other cases based on the same laws.
And it's gonna be repetitive evidence, and you're not gonna just keep coming up with a different case that says the same thing, that says you have a right to travel, because I admit, yes, you have a right to travel. You just can't do it by any sort of mechanical means that they need to license, whether it's by boat, or automobile, or helicopter, or spacecraft, or whatever the Jetsons thing would be. Any of those things, I'm sure you're gonna need a regulation. Why? Because those things can kill people if they don't do it right. Walking, I don't know of anybody who's walked into somebody else and they ended up dying because they collided. So, pretty safe with that one. Riding a bike, yeah, same thing. So those methods, sure.
That's correct.
Doesn't matter.
Right, so it's about people's burdens. I think again, if you've got something that is a new argument about what they didn't do, if it's not, you've already made your appellate record. We've got a jury, and they need to do that.
Oh, I do want to, since you've been not on. So also, based on, I want to make another motion now to, based on you denying all my motions in violation of my constitutional rights.
That's incorrect, sir.
Well, this is, okay, I'm just stating my base anyways.
I'm merely making rulings based on the law, and so I'm not violating your constitutional right. Just because you don't get your way doesn't mean that you get your violation. This isn't kindergarten court. That's not how that works. We're not gonna do temper tantrums with legal, frivolous things and stomp our legal feet with a bunch of arguments that have no relevance nor substance at all. And then you just keep making it and keep making it over and over until I get browbeaten enough to go, oh, you know what, Mr. Martin, I'm just going to dismiss the case. How about that? No, that's not going to happen. It has to be something. If you had something that was relevant, substantive, and right on point, I'd dismiss your case in a heartbeat because I've done it before with other cases. But you're not just going to keep bringing up the same, this case says I have a right to travel. True, it does. This case has a right to travel. Sure, it does. But that doesn't mean you can do it by not having a driver's license and operating any kind of motor vehicle. So do you have any other,
I got different arguments here.
Do you have any different argument that's not, I have a right to travel?
Yeah, this one, okay, I'm going to dismiss this case based on Declaration of Independence of 1776.
You already did that. That was the second motion you made when you first started making motions. Next.
Well,
I think you may have reshuffled your paperwork, so. Going back up to the top.
I'm going to move that you be disqualified from the case for denying my motions on my alleging that it was done in violation of the Constitution. Therefore, you should be recused from the case and dismissed.
Okay. Pursuant to Michigan Code Rule 2.003, any motions, I think it's C, any motions to disqualify are heard by the judge who's presiding, which is me, and I'm denying that motion.
Therefore,
I might be
request that you send it.
citation, but I think
I request, I request that you send this motion that you're denying to dismiss yourself to the state court administrator, which is supposed to be done by the court rules.
I did.
Have the state court administrator deal with the matter.
MCR 2.003, I'm thinking this is for disqualification, and it's heard by the judge that's presiding it, and I am denying that motion. You can take that up on appeal as well.
I think that's all the arguments I have.
All right, so
I think it's something I said before the paper.
Your Honor, on the civil infraction, yeah, I was gonna say real quick before I pulled up on the civil infraction, I can keep it, I can do a Reader's
let's
Digest.
do the civil infractions right now while they're already out,
Yeah.
so yeah.
So I think the testimony clearly established that he was operating with no proof of insurance. In fact, he had no insurance. So the evidence of that. With regard to the flat tire, it looks like he did have a flat tire. With regard to the...
He said it in his opening statement. He even said to the jury, come on, really? If you're not picking on me, why are you coming at me with a flat tire?
And he testified toward the end that he did not think during his sworn testimony, he indicated that he did not think he was operable toward the end because it was flat.
Yeah, so, and the report, when he ran the report on the computer, it came up that there's no insurance. So, anything you want to say about the no insurance or the,
Yeah, I'm still looking for the MCL right now. MCL
on the
clearly
insurance?
makes it clear that.
Sir, if you take one more step, I swear I'll come over this bench.
What's that?
So Mr. Greco made the argument, the closing this.
Yeah, okay, so, no insurance is required for the MCL I'm looking at right now, for a moped specifically, it's not required of a
No,
moped.
there isn't at all. But once you drive a motor vehicle, once you take it onto the road, because I also teach no-fault law at the law school. So once you take any motor vehicle onto the road, it has to be compliant with everything else is on the road. So that means you have to have insurance.
MCL.
The reason, and I can tell you the great case. The best case about it is a kid who's driving his moped on the road and he gets hit, and then his mom makes a claim with the insurance company and he gets denied. You wanna know why? Because he's an uninsured motor vehiclist. As soon as he takes that moped on the road, boom, same thing with people who take golf carts on the road. Boom, you better have insurance on your golf cart, because if you don't have insurance, like an actual, like the State Farm type motor insurance, as soon as it goes on the road, you're operating a vehicle with no insurance on the road. So
I have nothing further to
Yeah, so that's no, the MCL right here, clearly says.
sir, you can take me up on appeal, but I just gave you my ruling of why that does not apply.
Your Honor, if I may, on the other civil infraction, I'm going to make a straight preponderance argument. I would state I understand that there was.
I'm going to dismiss the tire one because I don't know what the tire looked like, and I don't know what the tire, because if the tire can move, then is it defective? If it can if I can drive on it.
That's my argument.
If I can drive on it, it's obviously not defective, because defective means it doesn't work. If I go to use my washing machine and I put clothes in it, and all of a sudden I push the button and all I hear is nothing moving, well, that's a defective washing machine. But if it washes my clothes, how defective is it? Even if it doesn't, like in a poor manner. So maybe it's a poor manner type of tire, but is it a defective tire? A defective tire won't roll. So
that's our argument.
Dismissed.
Thank you.
So it's responsible on the no proof, dismissed on the tire.
And let's get Mr. Martin, let's get the jury back in here again.
So I do find you responsible on the no proof of insurance. That's $165 in fines and costs. I'm dismissing your defective tire citation.
Your Honor, Officer Borg, I think we're done with the testimony and everything, so Officer Borg does have to leave.
Officer Borg is free to leave if he'd like to leave, yes.
Thank you, Your Honor. Thanks for your time.
Have a good day. All right, so Mr. Martin, your closing argument.
It took a lot of paperwork to find it. Okay, so one, this court doesn't have, the so-called court doesn't have jurisdiction for this matter because Article 3, Section 2 of the U.S. Constitution.
Mr. Martin, I've already made a ruling on that. If you're going to give your closing argument as to the facts that were presented, please do that. If you're going to give some sort of legal argument that you've already given before, and I've already made a ruling on, that's not.
I understand. How am I going to make a closing argument? I can't say the law. The closing argument deals with.
The closing argument is about the facts that you presented. You presented facts. You got on the witness stand to talk about your facts, not any sort of legal arguments that that have already been ruled on by me.
I don't understand.
You're more than welcome to have Mr. Hadley do your closing argument if you'd like.
I understand the defendant law 20 years is allowed to make.
My understanding is that closing arguments are about the facts that were presented at trial, and you can talk about the facts that were presented at the trial and how that plays into your theory of the case. If you want to make motions to dismiss and things like that, which you've already made, and which have been denied, you're not going to just rehash those in front of the jury because that's not.
I'm not making motions, I'm making legal argument.
You're not, it's not a legal argument. You know what, sir, sit down. Mr. Hadley, you're going to do closing argument.
Ladies and gentlemen of the jury, thank you very much for your patience today. I know when you watch these on trial, TV trials, it's a lot more exciting. There's not this weird stop starts. So thank you, sincerely. I know this has been an afternoon. Quite simply put, the people bear the burden of proof. You heard evidence today, and as the judge will instruct you, and it has instructed you, this is solely the people's burden. They must prove to you beyond a reasonable doubt, based on the actual evidence that was placed on the record today, that this individual violated the statute driving on a license revoked. Now, we can recap what we've heard today. We heard from the officer who testified more or less to his recollection of what happened. Mel make arguments that memories aren't perfect. You can speculate as to what actually happened that day. I mean, we do have the officer's testimony. He testified as to his recollection of what happened. You heard from Mr. Martin. We had our two witnesses today. He told you what had happened. Now, you heard no evidence that Mr. Martin injured, hurt anyone, ran a red light, speeded anything. It was, as he had stated on the stand, a victimless type of crime. So while Mr. Martin has, again, made some very interesting legal arguments to you today, what we really need to look at is, again, did the people meet their burden of proof? You know, was there enough evidence put before you today for you to make that decision? As co-counsel, the defendant, my position to you today is they haven't. It's a very high burden that they must hit. They have not hit that based on what they presented. So we'd ask that you return a guilty or a not guilty verdict based on what you've actually seen today. So I really, again, sincerely thank you for keeping an open mind as you go through this. Really, at the end of the day, I know that this is an individual who believes dearly in the arguments that he has made and the statements and the position that he's taken. And with that being said, this is a state that people I have nothing further. Just thank you for your time.
Mr. Griffin? Yeah, just briefly, I think the testimony of both Officer Ward and the defendant, Mr. Martin, we have met the burden that they violated the law that day. I'm not going to go through it again. We could use the officer's testimony or Mr. Martin's own admissions and testimony regarding what happened that day and how he violated the law. He just disagrees with it. But as the jury, you need to apply the law to these facts as the judge is instructed. Thank you.
This is the case of 231510, People versus Eric Martin. The jury has deliberated and is now back. Is there a foreman?
Sir.
Mr. Foreman, has the jury reached a verdict?
Yes, sir.
In the case of the people of the city of Taylor versus Eric Martin on the charge of driving on a suspended revoked license, how does the jury find?
We found the defendant guilty, sir.
All right. And juror number one, juror number one, is that your verdict?
Yes.
Juror number two, is that your verdict?
Yes.
Juror number three was dismissed. Juror number four, was that your verdict?
Yes.
Juror number five, was that your verdict?
Yes, sir.
Juror number six, was that your verdict?
Yes.
Juror number seven, was that your verdict?
Yes.
Let the record reflect, if you're polling the jurors individually, that each of them has come to the same unanimous decision of guilty as to the driving on a revoked license. I'd like to thank and dismiss the jurors. All rise. Let the record also reflect that I'm going to place exhibit 1, plaintiff's people's 1, into the court file. We're going to set this for a sentencing date with a PSI, or we're moving for immediate sentencing today.
PSIs. Gives the judge a sense.
Judge any sense of violation of the slavery or slavery. All this violation of the slavery.
Would you like to be sentenced to 5 years? I don't agree to no sentence, it's not the question.
All right, so I'll set it for a sentencing date then. And I'm gonna refer to a pre-sentence investigation report. And you'll be notified by the probation department, sir, to come in for the pre-sentence investigation report. And then you'll be able to read the report before the day of sentencing. You'll be able to go over that with Mr. Hadley. And we'll see everybody at that time.
I move to stay it based on appealing the issue. Are we appealing it?
I can't give you any legal advice, sir.
Well, that's pretty good. I'm moving to stay it. Stay it.
Sure.
I'll just say the same.
All right.
I just did. It's an
No,
oral
it's
motion.
the case of this. General motion that the file be served, closing counsel. Closing counsel has a right to be served.
I request to be appointed appointment of counsel Slavin to appeal these issues. Well, everything's been denied in this court. Is the record still on?
No, we're off the record.
Okay, let's
I
go
told
back
you
on the record.
you're gonna get a PSI.
All right,
The case isn't done
I want
yet.
to be appointed upon
The
counsel to
case,
appeal the issues.
well, there's no appeal yet, 'cause the case isn't done yet. You haven't been
No, I said
sentenced.
we're to appeal the issues that.
Well, you haven't been sentenced yet. Then after the sentencing, then the case is done, then you go to appeal.
I still have a right to interlocutory appeal the denials of my constitutional, my motions.
I can't give you any legal advice, sir. All I'm telling you is that you better show up for the PSI and for the sentencing date. Then you can do whatever you want on appeal. Versus Eric Martin.
Afternoon, James Musician, past Mr. Martin. Mark?
Yeah.
Your Honor, this matter is set for a pretrial today. We're requesting a trial by jury, also asking the court to rule on improper motions that the defendant filed.
All right, so.
Now, before you rule on that, first I want to say I am the living private man, not the legal fiction corporate entity. All capital letters names.
All right, so you're not an LLC. I get that. All right, so let's look at your first motion. Your first motion is defendant's motion and demand to dismiss and discharge this case due to this court having no original jurisdiction. Is that correct?
Yeah. Before I get to that, I want to finish saying at the start, hesitation. General jurisdiction, special.
Sir, I'm having a real hard time hearing what you're saying. You're breaking up. I don't know if it's your internet or what it is, but.
I don't know about that, but.
Okay, now, all right, go ahead.
But only by.
Yeah, so what I'm gonna do is I'm gonna set this up for in-person, for the next date here is gonna be, a settlement conference. We'll hear all the motions at that time, but we're gonna do it in person so that I can hear you, okay? 'Cause I can't hear you, if you can't argue your motion and I can't hear it, it makes it a little hard to make sure that you're getting due process. So I wanna make sure exactly what you're saying. So, we'll set this for, see, we had pre-trial today, and let's set this for in-person here, the 18th.
That's good, Your Honor.
So it's gonna be a settlement conference on the 18th, and we're also gonna hear all your motions on that day as well. And then it'll be 1:15.
The 18th of this month of this year.
The 18th of November, you're gonna be here at the courthouse at 1:15. So you can argue your motions and we'll have a settlement conference as well. All right?
All right.
All right, we'll see you then. 1:15, yep.
All right.
So we'll see you at that time. We're also gonna set this for a Martin.
And I reserve all my rights before I cross this bar.
Sure. Let the record reflect that you are a living man because dead men cannot speak. So, and I can hear you
It's fraudulent presumed anyways, though.
So, this is people of the state of Michigan versus Eric and Martin. Today's date and time set for a pretrial in this matter. Are there any issues that need to be brought or raised before the court?
Excuse me if I may at first. Mr. Martin indicated he did not want me as his attorney, so I'm asking for permission to withdraw.
All right, I had, first off, Mr. Martin, I had previously appointed Mr. Gazicki as your house counsel. Mr. Gazicki has made a statement that you do not want, you have indicated to him that you do not wish for him to be your attorney. Is that correct?
Yes, and not just him, any attorney, because I will not be allowing attorney to turn me over to the court, the jurisdictional court, which is what they do. This is why I don't set them normally.
All right. So you want to represent yourself, is what you're saying?
Not represent myself, but present myself.
Present yourself, represent yourself, same thing, sir. Again, we're not going to play semantics like you did the other day. So
the law is based on.
It's the same thing, sir. It's the same thing, literally the same thing. Look at a thesaurus, present, represent, sure. All right, so the motion's granted, you can withdraw, sir, Mr. Gazicki, and Mr. Martin, you'll be presenting and or representing yourself in this matter, because you have a constitutional right to do so, and you can. So, today's the date and time set for pretrial. So, Ms. Soap, you have not had the opportunity nor chance to speak with Mr. Martin, who is improper. Is that correct?
That's correct, Judge.
All right, so I'll allow the two of you, I will set this case over and I'll let you two discuss the matter in the hallway or in your office, and then I'll recall the case after you guys have had a chance to pre-trial the matter.
Before we get into that, Judge,
Sure.
I do want to put on the record that my victim's advocate, Ms. Delisha, has been in contact with the complaining victim in this case at great length, and there is a no contact order. The victim is the brother of the defendant in this case, and he's notified us that he is still living in the same house. So the defendant and the victim are living in the same house, even though there's a no contact order. Further, the complaining witness has indicated to us that he's being threatened by the defendant in his own home, once again violating that no contact order. The complaining victim, to my knowledge, is in the hospital at this time. He's unable to zoom in, even though he wanted to be here.
He's
in the check-in room right now. He's been attempting to, but he is in the hospital, could not be here in person. He might have audio.
I think they're in the, I don't know what this thing is. I got Kurt Martin
Yes.
in the check-in room. So if you want to zoom back in or if you jump in back in on Zoom, Kurt Martin is in the check-in room right now.
Yes, the people just wanted to bring that to the court's attention, the multiple violations of the no contact order, the living in the house and the threatening and speaking to the complaining witness.
All right, so sir, are you still living in the same house with the victim?
I object to that question as violating my right against self-incrimination, so we'll not be answering that question based on that. And also I would want to object to her what she just mentioned. First, I want to mention allegations that I'm there. That's not sufficient evidence that I actually am there. And number two,
I'll just have a bond hearing, is what I'm saying.
Well,
and then everybody will be sworn in and all that kind of stuff. Because I've already given you bond conditions. Part of those bond conditions was that there should be no contact with the victim. If you're living in the same house with the victim, you need to go somewhere else.
Well, first of all, he ain't a true victim, so something I'm objecting to. First off,
listen, I'm not even going to entertain any of your stuff. This internet, Google the internet type stuff that isn't even real or true. All right, I've already ruled on most of your motions, and I'm going to let you rule. I'm going to let you bring your motions again, and I'm going to make rulings on them. But what I'm saying is, you don't have a choice in the matter. I gave you bond conditions. They're alleging that you violated the bond conditions. So under the Constitution, I can't just say, oh, you're in violation. No, I need to have a bond violation hearing. And if you are in violation of my bond conditions, then I can hold you in contempt. If you're not, then you're not, and the case just goes forward. It's as simple as that. It's called due process. So what I'm saying is, when she says you object, when you say you object to the alleged violations that she's alleging, listen, you don't even get a chance to object to that. That's their job. That's their job to bring those. And if they're correct, they're correct. If they're not correct, you have the right to have a bond hearing. And at that bond hearing, if it gets proven by a preponderance of the evidence that it is true that you violated my bond conditions, then I will proceed accordingly. And if not, then the case will just go forward and you'll still have all of your constitutional rights. So what I'm saying is your objection is overruled because there is no objection that can be made to allegations because that's all they are is allegations.
So objection made based on the Constitution. There's no sufficient evidence if you lied. This whole case
Sure,
is
you're
based on him
testifying. You're
lying.
not going to testify. You're not going to testify. Listen, you're not going to testify. If you want to testify at your bond violation hearing, you can do so, or you have the right to remain silent. And anything you say can and will be used against you. So what I'm saying is, the only reason I'm cutting you off because I don't want you to step on your own constitutional toes. Everything you're saying could be used against you. So I don't want you to say something that you didn't mean to say, and then all of a sudden, then they get to use that against you because that's your right to remain silent. You understand that, right? You understand what I'm saying? Okay, I'll take your silence. I'll take your silence as an affirmative.
No.
So, well, you didn't say that you didn't understand. So,
No, I do not understand.
you don't understand.
I do not stand under with anything you're saying. So, but anyways, this is discussion for emotions.
From an English standpoint, you're not standing under anything. I didn't build a bridge. I didn't build
legally it's not all
I didn't
based on.
put up an umbrella. I didn't put up a canopy. I didn't put up any kind of other item that you could stand under, a ladder, you name it. So there's nothing that I've said that you can stand under. But what I am saying is you do have the right to remain silent. Anything you say can and will be used against you at trial. So that being said, I'll let you go into the hallway. You can meet with Ms. Sobe and have a pretrial in this matter, and then we'll deal with after Kurt talks with the victim advocate, and then you talk with the victim advocate. We'll decide when we're going to have the violation of the bond condition hearing.
Thank you, Judge.
So I'll remind you, this is scheduled for a motions hearing, and
So the two of you can go out and have your pretrial.
My demand.
I just told you go out and have a hallway, have a pretrial. If you don't want to talk to her, then don't talk to her. That's up to you. But what I'm saying is right now.
Talk to her. Okay, I'll talk to her. What I'm saying, but right now I have these.
Sure, you're not controlling these proceedings. I said right now is the time for you and Ms. Sobe to have a pretrial. If you're going to have a pretrial, we'll do that. I'll control when cases get called in front of my court. Thank you very much. Dismiss the case for lack of jurisdiction is denied. 1, you live in Taylor. 2, you allegedly committed a crime in Taylor. 3, the complaint was filed here in Taylor and was sworn to here in Taylor. So under that Constitution, you availed yourself of the jurisdiction. You live in Taylor. You enjoy all the protections of the police department, the fire department, garbage services, you name it. You have more than adequate minimum contacts with the jurisdiction, and I find that your motion has no merit. It is denied.
I object to that. As my argument, Article 3, Section 2 of the U.S. Constitution, that's totally irrelevant to when a state's a party. This court doesn't have original jurisdiction. Only the U.S. Supreme Court has original jurisdiction on Article 3, Section 2. And Article 3, Section 2 doesn't allow them as reasons to deny or to say that you have jurisdiction. They do not allow it.
Sure, Article 3, Section 2.
Denial.
Again, your motion is denied. Article 3, Section 2 of the United States Constitution deals with when one state sues another state. And that's like trash cases like New York versus New Jersey, things like that. But they have original jurisdiction over those cases. This is the state of Michigan versus an individual who lives here in Michigan, and that's you. And so living man, living trust, living Stewie, whatever you want to call yourself, guy, big E, little G, I don't know, whatever, all that good stuff, big M. None of that makes any sense, nor does it make any difference legally. The fact that I have little yellow tassels around the flag over here, that doesn't change anything either. This is the United States. Sure, keep on mumbling. This is the United States. This is Taylor. You live in Taylor. You committed a crime allegedly in Taylor, so the case is going to start here in Taylor. And so that's why I have jurisdiction over you for the reasons stated on the record. And just the obvious, the United States Constitution and Michigan Constitution, I have jurisdiction over this case. So that motion is denied. With regard to bond conditions, your motion to stay or set aside or dismiss the bond conditions is denied. The Michigan court rules, which are set forth by the Michigan Supreme Court, are the ones who specifically state that I can set bond conditions in order to do a couple of things. One, to make sure that you appear at court. Two, to make sure that there's a difference between the parties or allegations of violence against the parties or between the parties, that I can keep the two parties separated in the meantime. So you need to be not living in the same place as the victim in this matter. Now, at the bond hearing, I'm going to set a bond hearing for the alleged violations of that bond hearing, because one of the things I need to know is who owns the house, like legally owns the house. Because I'm a big proponent of property rights, and that was one of the biggest things that we moved over here and created a constitution, and why property rights, and you can't just take people's property and all that kind of good stuff. So somebody's going to be moving out in the meantime during the trial. I don't know if it's you or if it's a victim. Whoever actually owns, like owns the house. I'm not going to order somebody to move out of their own house and let a victim or alleged victim stay in a house that they don't even own. The victim will move. That's how that's going to work. So if you want to check with the victims and see who actually owns the house.
To my knowledge, I believe it is the mother's house,
Okay.
and they are brothers.
And the mother is still alive?
To my knowledge.
Okay.
Is she alive?
You talking about my sister, Lisa Martin? No, she always speaks Spanish. She owns it. She don't own nothing.
Who owns the home?
Well,
I'll just look up the Wayne County Register of Deeds. Council, just make sure you just do a search in the Wayne County Register of Deeds, find out who owns the home.
Well, under adverse, non-adverse possession law, because I've been living there a minimum of 15 years under that state statute.
No, you see, again,
Listen.
listen. You just have no law, I literally teach it. So just telling you, you're wrong, because you can't have adverse possession with permission. If you have permissive use of the property, you'll never, ever going to get adverse possession.
Adverse or non-adverse, okay?
Okay, there is no non-adverse, trust me. I don't remember that one ever being on the bar exam. You know what, hey, whatever bar exam you want to take, you let me know. I'll study for that one too, and I'll take that one.
But to answer your question, let me finish saying, you always want to try to cut.
No, because I want to wait till everybody's under oath. I'm just saying, I'm staying at the hearing. I want to know legally who owns the property.
Someone mentioned, no, we can do that too. I'm just saying, but it's always.
Oh, we're not ready to do that now
house,
today.
Justin, it was always my parents' right house, so to say, and I don't even think they really owned it because the mortgage wasn't paid off. So I don't think really no one totally owns
A
it.
mortgage is just a promise to pay money. It has nothing to do with actual ownership. Ownership and mortgage are two different things.
I think actually all of us at the house are possessors of law. My understanding of law is we're actually possessors because the bank really owns because the mortgage never paid off, my understanding. But it was always, so to say, our parents' house. Like I said, I don't think they really owned it.
Sure, here's what I'm going to do. I'm just going to go ahead and sua sponte, look it up in the Wayne County Register of Deeds myself because it's a matter of public knowledge. And then I'll take judicial notice of the fact who's the owner.
Well, like I said,
that's all I got to do.
Adverse and non-adverse possession, MCL statute.
What we're going to do is we're going to have a hearing date, and that hearing date is going to be on the same date as the jury trial. So in the meantime,
I have a right to be there though because I've been in there minimum 15 years.
I mean, you don't have a right to be there, so you don't own the property. You don't own the property.
Under that statute,
You don't own the property. So you need to vacate the premises because that's where the victim was. I told you no contact with the victim.
And that's an unlawful void order because of violation.
But it's not.
Because without any evidence, you can't just say, I can't be at a house.
Listen, sir, I'm going to tell you one more time. I'm not going to sit here and argue with you. If you keep arguing with me in court here, I'm going to hold you in contempt because you're just holding up everybody else who's ready to go and proceed with their cases. And you just keep bringing up the same thing that isn't anything at all to bring up. I've already agreed in my ruling on your motion. I've denied your motion. I told you that you can't live in the same house with the victim on a domestic violence case when I told you you should have no contact with the victim. And if you don't own the house, now if you own the house, like actually own the house, like show me the deed that shows that you are the Wayne County Register of Deeds, that you're the owner, I'll make the victim move. Why? Because I'm not going to kick somebody out of their own house. I'll make somebody will move, but it ain't going to be you then. But you don't own the house. Okay, so you're going to need to vacate the premises. You're going to need to vacate the premises.
Okay, and I objected, like I said, it's not just a deed whether someone owns it. Under the statute in Michigan, it mentions.
First off, what statute? Cite the statute.
Okay, I don't have it right in here because I was going to rephrase, but I'm going to give you the statute. You already know me. I cite MCLs all I know problem. So I'm going to give the MCL statute, but it deals with what's called non-adverse or adverse possession. Okay, so you live one of the basic elements. You lived at a house for 15 years, right? Remember, this is my parents' house, right? I've been there 30-something years. When you lived in a house that long, you are considered part owner of these. So, and therefore a right to be living at that house.
No.
So it ain't just whether you have a deed or not.
No.
That's, and regardless of the ownership
No.
issue, yes.
No.
No, okay.
You have a
That's the old statute
possessory,
on the site.
after 30 days, if you stay in a premises with permission, after 30 days, you become a de facto month-to-month leaser. And you become a leasee at that point, and you have a lease with the property. That's it, at best. And that means you can stay there and they can evict you, or I can give you a bond order that says you need to vacate the premises. That's a court order.
Owns it, maybe, yeah, but
You don't own it. You don't get a possessory interest, but you don't get an ownership interest. There's an absolute difference.
No one owns it.
There's an absolute difference. Listen, you're not gonna argue with me. Keep arguing with me and I'm gonna hold you in contempt. Because I'm telling you, you don't own the property. You have a possessory interest at best, because you've been there for 30 days, sure. And they can either evict you, or a bond condition can move you out. Either one. Or actually an injunction from the circuit court for if there was a case, they have the power to move you out of there as well. There's 3 different scenarios where you could be moved out of there. One of them is bond condition. Bond condition says no contact with the victim. You don't own the house, get out. In the meantime, get out until the case is done. So if I find or know that you are there, I'm just telling you, I will hold you in contempt of court. I will remind you that contempt of court is a misdemeanor punishable by 90 days in jail and or up to $1,000 in fines. And I'm just going to let you make sure that you are aware of that. Again, ask you, would you like any court-appointed attorney to help you in this case?
No.
Okay.
I have more to say now. And
Just double check.
Part of my constitutional rights.
Just double checking.
The order, first of all, the bond order violates my due process, because you can't tell me to be out of a house, my house I've been living in all my life.
It is, because it's not your house. You keep saying your house, and it's not your house. It's the place that you were allowed to stay by your mom and daddy. But now they're no longer, this is not that situation anymore. It's not that situation anymore. So you don't own the house. You're all grown up now and you don't own the house. And the person and I'm telling you, you need to vacate the premises because the victim lives there. So you're gonna vacate that premises. So your motion to set aside the bond conditions is denied, because I clearly, you can't understand simple concepts that I'm trying to tell you. So I really don't want you to have in a position where you're in the same building with the victim. Because since these allegations are ones of violent nature, I don't want that to happen allegedly to the victim again. So your motion for jurisdiction is denied. Your motion to dismiss or set aside the bond conditions is denied. Let's see what else you got. Motion, copy. You already got a copy of the complaint, so I granted that. There's your copy of the complaint, and plus check your email. Counsel did say she sent you all the paper discovery. We're going to get you a copy of the rest of the discovery as well. And then you had a motion which was basically the same motion as the other two, but just put all together into one. That says motion to dismiss because of lack of you're challenging the standing. You're challenging the standing of the people to bring the case.
Well, the corporation of the state of Michigan is the plaintiff here.
Oh, the corporation. Well, under the Michigan Corporations Act, I'm going to allow the standing. Everything's good. And for the reasons already stated for jurisdiction, it pertains to the standing as well. And the people actually have a duty to bring cases when they think that there's probable cause that crimes have been committed. And it is their obligation to bring those to the courts that have jurisdiction, hence this court. And they did that. Motion to state unlawful bond conditions, that's denied for the reasons stated in the other motion that was asked to get rid of the bond conditions. And then the third part of that other motion was get a copy of the complaint, which you already got. So denied, and partially granted, and you already have a copy. So all of your motions are been answered.
No, I still have more, but before I get to the other ones, I have.
Well, we're done for today, so you're going to be getting the date and time for the jury trial. Your motions that you filed to dismiss the case and to set aside the bond conditions have been denied. I'm going to get this jury date set, and then I'll hear any other dispositive motions on that date. I'll hear the bond violation hearing on that date. And then if there's going to be a trial, then we'll go ahead and hold the trial on that date.
So refusing to hear other demands, I have to dismiss.
Sure, I have three motions that you have in front of me. I've made my ruling on 3 motions.
So I'm saying I have more to make right now verbally. I have more based on she has no standing as the prosecutor. That's one of them I have to make. So
Okay,
if I was to make it,
you know what? You just made the motion. I'll rule on the
no,
motion.
but I didn't finish.
Motion, first
No, it's not
up,
a motion. This is the demand
Just-
because it's based on my constitutional.
demand motion, call tomato, tomato. It really doesn't matter. A motion is you're asking the court to do something. We're demanding the court to do something. Ms. Stowe, do you work for the Wayne County Prosecutor's Office?
I do.
Does Wayne County Prosecutor's Office have jurisdiction under Michigan Constitution and under statutes to prosecute cases that happen and any alleged crimes that happen in the county of Wayne?
I do.
And you work for, who is your boss?
Worthy.
Kim Worthy. And Kim Worthy is the elected Wayne County prosecutor for the county of Wayne?
Yes, Judge.
All right, motion denied.
You didn't
She
hear
has-
my argument though.
She has standing. She has standing. She's doing her job.
I have not made my argument. Based on my motion.
Sure, make your argument.
It's okay.
Make your
argument is she has no standing because she does not have a power of attorney with the so-called corporation, state of Michigan or city of Taylor. Since she has no power of attorney that she can show to the court in evidence, she has no standing. And she can't possibly have a power of attorney because a corporation is a non-living human. So she can't possibly have a power of attorney with the city of Taylor or the state of Michigan, which is the plaintiff here, the real plaintiff. Therefore, she has no standing.
All right, after hearing your argument, I'm again denying your motion.
Based on what?
Based on what? Based on everything you said is all legal mumbo jumbo. It makes no sense whatsoever. Like literally, if you want to know the action, it has no basis in constitutional law. It has no basis in statutory law. The fact that you're saying that a prosecutor can't do her job, she's literally hired by Kim Worthy, who is the elected Wayne County prosecutor, who under the Constitution and Michigan statutes, criminal statutes, the Revised Judicature Act, and the Michigan Constitution, all coming together to give this court jurisdiction to make rulings on any crimes that happen in this jurisdiction, which they have alleged that you have done. And you've got a copy of that complaint. And now they are sending their employee, okay? If you want to talk about agency, you want to talk about power of attorney, I don't need you. When I hire somebody as my employee, I send my employee and they have what's called a parent and actual authority. Could be both, could be either, doesn't matter. That means that they send that person who has such a parent authority to go and act on, wait a minute, on their behalf. And Kim Worthy isn't here right now. That's why she is an assistant prosecuting attorney. And she is here at the whim of and under the control of Kim Worthy, who is the prosecutor. Now that's a legal argument that's actually based in law. Okay? Yours was not based in any law that this court would ever recognize.
Now, could you represent humans maybe, not corporations?
I didn't know. I know you're a living man, you've said. I didn't know if you were living man, and I didn't know if man was human. I didn't know which. I didn't want to be presumptuous. I didn't say human or anything like that. But I just know that you were a living man, you said. But the court does recognize that because, again, dead people can't sit in my chairs and talk. So your motion is denied. All right? And we're going to get the court date for the jury trial in the mail, and that'll be for all the rest of the matters as well. All right, so.
Yeah, my phone's on. There's no job. I have to do the chief government phone. They give me 1 minutes, so it's all.
So while he's making a copy, I can go over your couple of motions that you filed.
But also, I'm saying though, but also Brianna is trying to direct my help people that found the keys.
About this game.
Well, I think he's getting ready to address the motions.
Okay, right.
Is my understanding.
And I have some more too, so let's not presume that I'm done because you decide one or two.
I know the other one's downstairs. You're setting it up.
Right.
You just filed it.
Yeah, just two more, and plus I have another thing to say in addition to that hasn't been filed. Another demand to dismiss based on argument that I forgot to do with the trial. Because, so many of them I already did. 5 or 10 or whatever, but I remember everything. Yeah.
All righty.
Would you like to review this together?
Yeah.
So if you want to go ahead and review that, then we can do that.
Would you like to review it with me, or do you just want to read it yourself? Because I'm happy to go over it with you.
I'll read myself and see what you say.
Record reflect, he's got a copy of the PSI, he's in the page, he's going to review it himself and ask me if he has any questions.
So noted, thank you.
But ink marked where I don't agree that
Your Honor, this is a copy he can mark up.
Yep, that's your copy, you can keep that.
to mark what's not true, and like what's one statement, for example, on for the record, can I make a statement on this right now? One thing I
Go
know.
ahead, go ahead and read it. Go ahead and read it. Make whatever notes on it you want, and then we'll just address it all at once. I don't want to piecemeal it. All right, so you had the opportunity to look through that. This is case 231510OT, people of the city of Taylor versus Eric Joseph Martin. Mr. Martin, there you have filed several motions. Did one come up? Did they send the other one up that came in today?
Bree said she was going to.
I heard the tubes go off, but I didn't know if it All right, give me a second to look at this one because it just came up and you just filed it, but I'm sure you're going to make a
Yeah, I have not seen any of these either. They're filed pro per, so I'm not really sure what he's got up today.
All right, so I've had the opportunity to review the motion that you filed today. So let's go through the several motions one at a time. Yes, sir.
I can't hear you. Can you stop talking, please? He was speaking while you started.
Sure.
Sorry. Can you
This is case 231510OT. I had reviewed the other motions that had already been filed. The new motion that Mr. Martin had filed this morning, I was just reviewing that so that he could go ahead and argue these. And we'll start with each one at a time. So the first one is the motion by Mr. Martin. It says the motion is a motion and demand to be compensated for all my time spent at trial. It states that it says I was made to attend the trial on 10/29/24 against my consent, as I only attended by threat and duress, as I could have been arrested, maybe charged if I did. Paragraph 2 states I have a right to be compensated for my time spent for attending the trial pursuant to my right against slavery of the Michigan federal constitutions. So, Mr. Martin, as to this motion, go ahead.
Enough for that. So legal authorities are they're listed there. The MCRs, MCLs that support my position are already listed on there. I have nothing further to add on that stuff. For also, as an extension of that also for the time that here today and every other court proceeding that I'm made to attend with, against my consent. So just want to include them that time also. Every other court hearing too.
All right, so your motion is denied for the following reasons. The citations that you cite, sure, there is no form of slavery. The 13th, 14th, and 15th Amendments were clearly put into place to abolish slavery, and the 14th Amendment made sure that those amendments, 13 and 15, applied to the states through incorporation doctrine. And but summoning someone to court is not an act of slavery. It's an act of due process. I can't give you due process on your case if you don't show up for your case. It's a little hard to give you a fair trial if you yourself don't even want to show up and don't show up. So you had the constitutional right to have a trial. So you have to be at your trial, because if you're not at your trial, well then the Constitution can't be applied. All your constitutional rights can't be preserved, which they were. And so for those reasons, and the only other compensation that could come from the Constitution would be under the Fifth Amendment's takings clause. This isn't any real property or any other thing that anyone has stolen from you, and the government hasn't taken it from you. So there is no just compensation, because that would be the only spot in the Constitution that I could think of where that would jump in, and this isn't that case. So that motion is denied for the reasons I just stated. Motion.
You have a response to that?
Denied. No, when I make a ruling on a motion, when I ask you if you want to make a record, that's your chance to put your whatever you're going to say. And you say that, nope, everything is just stated right there in the motion. And I said, okay. And then I make my ruling. Once I make my ruling, that's my ruling. If you want to object to it, if you want to appeal it, you're more than welcome to appeal it and take it up with the court with the next level up there on appeal. But we're done on, once I make a ruling on it.
Because that's denying.
Once I make a
my right to
ruling
say
on
what I
it,
want
we're
to say.
done. So.
And preserve the record at the lower court.
Right, but the record is, I gave you an opportunity to make the record, and you didn't have anything to add other than what your motion already states.
So when you say something, then
Listen, you're the lack.
I have something
You
to
have
say
competent
after.
counsel. There's nothing to say because I've already made my ruling. Okay? So I've already made my ruling. You can make,
some things I can't say until you say. See, there's some things like what you just said. See, I didn't know you was going to say, for example, like you just said.
Well, that's because that's not how it works. So
denying my due process right. Objection.
I'm not denying your due process
rights.
rights.
Also violating my right to First Amendment.
It's not because I asked you if you wanted to make a record and you didn't. You said no. That's the motion says it all, and those things clearly prove me right. That's what you said. So now let's go with the next one. There's a motion demand to dismiss or reverse the order of fingerprinting. It says that your fingerprints are your private property. And Slavens, I'm not sure if you're calling me Slavens, S-L-A-V-E-N-S as my proper name. My name is Slavin. My last name is Slavin. There is a Judge Slavins. And so just for clarification, the circuit court judge is Slavins. I am Slavin. If you're saying in the possessive, you would need to use an apostrophe. So the use of an apostrophe is not apparent. So I didn't know if you were just misnaming me or if you were meaning the possessive. I didn't know.
But you come up with the S on there because I put an S after your N.
Yes.
Okay, so your name is spelled right. It was just that's okay. You know, some people.
Wait, I didn't know if you were.
They say it with a
sure. I didn't know if it was possessive. I didn't know
sound.
if you were doing it in the possessive. That's all I was asking. So, so Judge Slavin's order that I allow Taylor Police Pigs to steal my fingerprints. First off, I'm going to strike the word pigs from your motion because I'm not going to allow any sort of defamatory or derogatory statements to be made. I wouldn't make it. I wouldn't let listen, that's the second time you've done it. You do it one more time and I'm going to give you contempt of court and 90 days in jail. I'm just telling you right now. I've always given you your opportunity to say, make a record and all that kind of stuff. And you're not going to interrupt me. If Mr. Greco had stood up at trial and said, this moron did, I would have said, boom, right. I would have held him in contempt of court for doing so. I'm not going to let you make any derogatory statements about the other side either. I don't run a Jerry Springer show. Okay. Everyone's going to talk with respect to one another. Anyway, so allow the police to steal from my fingerprints without my consent violates my due process rights, my right to sovereignty to be left alone, Declaration of Independence, 1776. I'm not really sure how the Declaration of Independence gives you any rights. All that was a declaration to King George, telling King George, hey, we're tired of all your crap, and we're going to go our own way, but whatever. The Contracts Clause of the Constitution, by forcing me to act against my consent. Paragraph 2, also, this case isn't about a real crime, but about my exercising my right to travel. In reality, there wasn't any probable cause, no injured plaintiff, no standing, no case, no crime. I don't know if it was no woman, no crime. Oh, no, that's the Bob Marley song. We already ruled on all those motions with regard to standing, in regard to all of that. So those are, if you're just basically reincorporating those motions that I've already ruled on, those are still denied. And the order violates my right against slavery, the 13th Amendment of the United States Constitution, which again, I just talked about a second ago, and that was denied. So you can't just say the two different motions and slip it through or something like that. So that's denied. Now with regard to these, this new part, the part about your fingerprints, they've already denied the other things. Those were already separate motions. You just basically remaking all those in paragraphs 2 and 3. Go ahead and make your record with regard to the fingerprints and why you think that the fingerprints can't be taken.
Because it's my private property and they can't be taken without my consent. I never consented to it. It was only by threat and duress, because if I don't, I'll be charged with obstruction of justice, etc. So that's why. And
In addition, I'd like to respond also to the statement to clarify. It wasn't a derogatory term. When I say pig, it means persons in government who are violating the oath of office. That's my definition of pig. That's why I use it. Since they've been violating my rights, constitutional rights, that term falls in place in my definition, and it's a true statement. It's not derogatory. But just to point that out. Didn't mean to cut you off. Like I said, you was done talking, saying something at the time, so I talked. So it was no intent to cut you off. It was just you stopped talking. I thought I could talk.
All right, so you made your record on with regard to this motion. I am going to state that it very clearly states, because I don't find your definition of what pigs really means to be what you were using it as. It literally says, my fingerprints are my private property. In Slavin's order that I allow Taylor Police pigs to steal my. So you've already designated them as Taylor Police. Taylor Police denotes that one, they work for a government agency, that being Taylor, and two, their capacity in which they work for the city of Taylor is as a police department or as a police officer. So when you say people in government, I'm not sure what the S was for.
Persons in government. Persons in government.
Then that it just becomes redundant. That's like saying the same thing twice. You just say the Taylor Police, the Taylor Police. So I found it to be more of an adjective and derogatory one at that. For the reasons that no, your fingerprints are not personal property, nor is your handwriting, nor is your voice, nor is the visual imagery of your face and body. All of those things that the United States Supreme Court has ruled on, stating that it's not your personal property. Same as your garbage. You can throw your garbage out and I can go through it. The police can go through it. Those are things that you do not have any privacy issues relating to. And they are allowed to take that anytime there is a statute that requires the fingerprints be taken in a criminal matter. I was effectuating that order pursuant to that statute. And so your motion is denied for the reasons I just stated.
I object to that.
Didn't object to it.
That's, it is my private property.
But it's not.
I'm God's creation. I'm not. Well, before I get to that, statute cannot violate the Constitution. Constitution violates the Constitution. Statute that violates the Constitution are invalid. So a statute that says that we can take your fingerprint.
These are all things that you're going to want to put in your appeal because I've already made my ruling. So, all right. Now, with regard to the next matter, let's see. Let's go with the next one. All right. So, at trial, this is your demand for a new trial based on the following. Paragraph 1, we were denied, I'm not sure who we is, but we were denied a fair trial with the unfair due process violation, guilty finding as so-called Judge Slavin. No, I am called Judge Slavin, so it's not so-called, so that's derogatory. Just saying. So I'm just trying to tell you in the future, if you file any more motions with me where you use derogatory statements against people, parties, officers, employees, anybody, I'm going to strike it because I'm telling you right now, that's not how you do your pleading. You don't put that stuff in there, right? And so refusal to allow me to show the jury the evidence, superior law that demonstrates we are not guilty as a living private. So I'm not sure if the tense is wrong or the person is wrong, because you're using we are as a living private sovereign citizen man. Man is in the singular, but yet we and are both plural tense. I'm just not really sure what you're saying there. The bullcrap state statute, again, derogatory. Paragraph 2, the prosecutor failed to prove in actuality that we as one, I don't know, it sounds almost like the Borg type of a thing going on. We as one of the sovereign people are were liable to the so-called statute, derogatory, that is, refused to prove with evidence that we were liable. Instead, he just suggested to the jury that I am liable to it just because of not having a driver's license, and the jury being uneducated in the law, idiots. Again, that's derogatory. You're literally taking somebody in the most purest form of self-governance. Literally, to me anyway, as somebody who loves the Constitution and loves the fact that hundreds of years ago, some individuals came up with a system of free governance, of self-governance, of rights and protections that still hold so valuable today, and how well done they did that. Yes, there's some minor things here and there that need to be fixed, but they're not elected people. These are people who are summoned to court, come, sit down, listen to the facts of a case, and they literally, because you don't get this kind of treatment anywhere else in the world this well, where you are basically going to be judged by a jury of your peers. They don't care if you're guilty or not guilty. They're just going to hear the facts and then make a decision. And they're not elected. They don't have any stake in the matter. They don't have a quota to meet, nothing. So for me, a jury, serving on a jury is literally the most pure form of self-governance that there is. It's just, and for you to call them idiots, not only does that just make a derogatory statement towards all those people who decided to make sure that they were exercising their constitutional right, because they have a constitutional right to serve on a jury even. And the fact that they are there to protect your constitutional right to a fair trial. And for you to call them an idiot, it literally just takes everything in my power not to just wow. The second thing is I instructed them in the law. So they weren't idiots. They knew exactly what the law was. They knew exactly what the law and what they were there to do. They were there to hear facts, and they were there to hear that and base that and judge those facts up against the litmus test of the laws that I had instructed them, which was on the driving on a suspended license law. So for you to call them idiots it's disgusting. I'm sorry. So you continue with, because of not having a driver's license and the jury being uneducated in the law, idiots, just accepted it without actual evidence to prove liability, paragraph 3, because of so many legit defenses I raised at trial. I forgot to raise at trial my defense that I am not guilty, because even if Judge Slavin, prosecutor, jury, didn't fairly believe I was not guilty based on everything I said before, I am still not guilty because I didn't have a guilty mind. Based on my reliance of prior superior law that told me I wasn't doing anything wrong by exercising my right to travel with my private property, such as the due process clause of the Michigan federal constitutions, among my other cited legal authorities, I cited in my written and oral. Okay. Paragraph 4, a guilty mind, mens rea, is required in crimes. It's more set in the United States, and also a House bill signed by Governor Rick Snyder and passed unanimously. Also fairness, fundamental fairness, due process, Michigan constitutions, federal constitution. All right, so you're claiming that, I don't know, you're claiming that you should have not been, I just want to clarify exactly. 1, because the jury was stupid. 2, because you had already, because I didn't grant your motions that you made at trial. And 3, because of mens rea. You didn't really say what you meant about mens rea, but just that you needed to have mens rea in order to be found guilty. But there was, so go ahead and make your record.
Well, first let me clarify about mens rea. As I stated, okay, because I'm relying on U.S. Supreme Court case law that says I have the right to travel, and driving a motor vehicle is not driving a motor vehicle unless one's using those for profit, as I heard before. But regardless of you agreeing with me or not, and deny my demands to dismiss, what you did, regardless of that, but the fact that I'm relying on these laws, in my mind, I'm not doing nothing wrong because I'm using U.S. Supreme Court case law and the federal statute, 18 U.S.C. section.
So let me ask you one
section
question
6.
before you go on, because I need to know for clarification purposes. When you say, because you referred to it in the motion, you referred to it verbally just now. When you say, when I acted, I didn't think I was doing anything wrong because of the different things you stated, okay? What is it that you did? Like what action did you take that you relied on these laws? That's it wasn't in the motion.
They call it driving.
Okay.
Okay, my moped. In fact, I was traveling by right, because the traveling by right term means when you're not using the roads for profit, as the case clearly says that Packer versus Banton, the U.S. Supreme Court case, the quote, it clearly says the legislator cannot regulate the use of the roads unless you're doing it for
No, sure, absolutely. Listen, you have a right to travel. I've said it 100 times. You can't travel by plane either. You have to have a pilot's license. So there's licensing requirements. So we've already gotten to that. So skip to the part where the mens rea kicks in that you say we don't have.
This is supports what I'm saying. But anyway, so
many times.
Yeah, so it supports this thing. Without a guilty, you need guilty mind in all crimes. Okay, anyway, something back to you, Slade. So because I'm relying on, like I said, the Packer versus Banton case, which says the legislator cannot regulate the use of the roads if it's such as the driver's license, you need insurance and need registration if you're not using the roads for profit. And plus, I'm relying on that legal authority, 18 U.S.C. section 31, subsection 6 and 10, federal statute made by Congress, which makes it clear that a motor vehicle is not a motor vehicle unless it's being used for profit. Same thing as U.S. Supreme Court. Article 6 of the U.S. Constitution makes it clear that federal statute I just named off is supreme law of the land. So, because I'm relying on this higher supreme legal authority, in my mind, I'm not doing nothing wrong, and I'm not guilty. In fact, that in addition to these cases I just cited, Morissette versus United States, U.S. Supreme Court supports a guilty mind is needed. Plus, as you just mentioned, the House bills signed by Governor Rick Snyder, and it all supports mens rea, guilty mind is required for all crimes, and that's how it should be. That's what's fair, and that's what's right for the people. So
you made your record?
Yeah.
Okay. So first off, you're correct. You do need a mens rea. There's a mens rea, guilty mind, actus reus. Okay, that's your actual acts and stuff like that. Also, as I instructed the jury, you can have direct evidence, you can have circumstantial evidence. But there's also the maximum of the law that says ignorance of the law is not an excuse. Obviously, this is clear in your case because ignorance of the law is just explicitly obvious here. So, the law states that no person who has a license that's been suspended, revoked, or denied shall not operate a motor vehicle on a roadway. Plain and simple. So you even stated that you were operating a motor vehicle on a roadway. Now your definition of what you think the definition is, which is not the definition, because we actually pulled up the federal statute when I denied your motion last time, and I actually read from the federal statute and stated what the definition of motor vehicle is. And your interpretation of a motor vehicle is not the right interpretation. So the fact is, you knew or had reason to know, because let's talk about mens rea. Mens rea is guilty mind, but there's different forms of mens rea. There's negligent types, there's reckless types, there's knowingly types, there's purposeful types. Yours in the statute that you have would be knowingly, like no one should knowingly, like I know my license is not suspended, or I know I don't have a license. And everybody knows, like it's almost like common knowledge that you can't drive without a license. Everybody knows that. And even if you didn't, ignorance of the law is not an excuse. So the law clearly states that you shall not drive. But yet you went ahead, and so what does knowingly mean? Knowingly means that an actor or the person who's doing things is almost practically certain, like they know that their conduct could possibly lead to a result or they're aware of a high probability that their conduct is prohibited in nature. Now, I'm going to point to the fact that you have a 2022 operating while license suspended, revoked, or denied guilty plea. You were found guilty in 2022. So you know that driving on a suspended license is a crime that's going to be prohibited. Why? Because you've already found guilty of it. You already had a case for it. I don't know if you went to trial. I don't know if you took a plea. I don't know what you did, but you knew that, hey, you got to have a license to drive. Now that was in Dearborn. And you know what? Dearborn, Taylor, it doesn't matter. You need a license. State of Michigan. That's why the license comes from the state of Michigan. It doesn't come from Taylor. It doesn't come from whatever city you're from. It's a Michigan driver's license. And you already know that getting on your moped and scooting around on the streets is a prohibited conduct. You've already been told that. You've already even pled guilty to it or were found guilty of it. So you know. So the fact that the jury found, because all they have to do is prove, because by circumstantial evidence, I don't think God or any other alien or any other person or any other under duress or anything like that or under threat of violence, get on that moped right now or I'm going to beat you. Like nobody threatened you to get on that moped and drive it around. So all they had to do is prove that you were just driving it around. Circumstantially, we can infer that you chose to get on said moped because you call it your personal property and you chose to drive it. So that's the mens rea. That proves your mens rea. People are thinking about the way they're acting. You're driving down the road on your moped. That's all you had to do to prove mens rea. So mens rea was proved. It was proved. Because for example, if I have, let's take a person and I can say, here's a guy, Turd Ferguson, we'll call him. And he goes into a bar and he starts chirping at some guy and he gets up and punches this guy in the face. If I see and witnesses see him walk over and he's already been chirping at him and he walks over and Turd Ferguson punches the guy in the face, you can infer his intent by his actions. Because most people don't walk around saying, I'm going to take a drink of my drink. I'm going to punch Turd Ferguson in the face. They don't walk around saying, now some people do. You're like, dude, keep that in your head, like your own thoughts, you know. That little baby is ugly. You know, nobody says that. You don't say, shh. All right. So most people don't. But what we do, and this is why they allow circumstantial evidence, because you can infer people's intent by their actions. So your intent, your mens rea, your guilty mind, was already inferred from the fact that you know that it's a prohibited activity. You know that you've already been found guilty of it once before. You literally you chose to get on your moped and go scooting around the streets of Taylor. Your mens rea is shown and proved from that. So for that reason, this motion is denied.
Object to that. So it's okay if I talk without being threatened with contempt and all that? Or?
I've never threatened you with contempt at all. I told you if you interrupt me again, I'll hold you in contempt.
Yeah, so again, you're talking about violating the state statute that's unconstitutional, therefore you can't.
Again, that's all for your appeal.
Right. So
you've already made your record. That's what I've asked you if you wanted to make a record. So the one you filed today, let's look at that one. Enclosed for filing is the demand to dismiss or discharge all these cases based on 28 USC 1604, immunity of a foreign state from jurisdiction. Demand to dismiss these cases based on lack of presence of plaintiff at trial. Okay, so first off, this is basically, I guess, two different reasons why you think that the trial and what happened should be dismissed. So first off, let's look at 28 USC 1604. And yes, that does state that, and I'll read right from it. I'll read it right from it for you. Immunity of a foreign state from jurisdiction, subject to existing international agreements to which the United States is a party at the time of the enactment of this act. A foreign state shall be immune from the jurisdiction of the courts of the United States and of the states except as provided in sections 1605 to 1607 of this chapter. All right. So this is interesting. Either you are an international man of mystery who makes agreements as a separate foreign corporation or state, or wait a minute, there's a definition for foreign state. Section 1603, if you had read that section first, it clearly states, for the purposes of this chapter, a foreign state, except as used in section 1608, includes a political subdivision of a foreign state or an agency or instrumentality of a foreign state as defined in section B. So let's look at section B. An agency or instrumentality of a foreign state means any entity, one, which is a separate legal person, corporate or otherwise, and two, which is an organ of a foreign state or political subdivision thereof, or a majority of whose shares or ownership interest is owned by a foreign state. And three, here's the important one, which is neither a citizen of the United States, as defined in section 13322, and nor under the laws of any third country. You're a citizen of the United States. You can't be a foreign person because you have a citizen. So right now, what you're saying is you could be deported? You can be deported because you're not a citizen of the United States. Because in order to be a state, so just curious. So and the reason I'm kind of already going with that first is that way you can make a record and you know what I'm saying. You know what I'm going to say. You already, because I haven't made my ruling yet, but you can see why you're not a foreign state. You're not France. You're not Poland. So go ahead, make your record.
Well, if I was gonna say no, I'm not a U.S. citizen. That's false. A U.S. citizen is slave. It's not one of the sovereign people. And actually, U.S. citizen doesn't really exist. I mean, when they college, they try to, people ignorantly call themselves U.S. citizens. They don't even know what that term really means. It really means a corporation. So that's why they're really not. But anyways, yes, I am a foreign state. Like as I pointed out in there, and as that volume mentions, foreign state is a synonymous term with one of the sovereign people, and it's also goes within the synonymous with the term states of the union, which also means one of the sovereign people. And so, and if you don't know that, if you look more in the Black's Law Dictionary, look more in the term of states, it doesn't just mean a corporation always. It does mean, you know, one of the sovereign people.
The statute says so. It says it could be a person, could be corporate, could be part of an agency.
Well, I'm not a person also as
right
now, I'm not a person.
But you're a citizen of the United States. You're a citizen of the United States.
No, I'm not a citizen of the United States. I'm one of the sovereign people, which the U.S. Supreme Court said.
Okay, then so the bridge card, I'm going to call the bridge card place and tell them to stop sending that to you because you're not a citizen.
No need. Well, I can't just.
It's funny how as a citizen, because you kind of want to take advantage of the rights and the benefits of being a citizen, but you don't want to claim as a citizen when it comes to criminal stuff. I guess is that how it is.
I understand the law actually.
So are you waiving any? Just asking you a question. Are you going to waive any and all Social Security payments that you should ever receive? Because you're not a citizen, so I mean, I'm just curious.
I received SSI payments and all that, but anyway, I'm saying my comprehension of the law is you're not allowed to be denied human and constitutional rights because you may accept benefits from there's law on that too. Actually, I can point that out. I haven't written down somewhere, but.
I do find that you are
just because you take a benefit of something, or what's called to be a benefit, you're not allowed to be denied your constitutional or inalienable rights just because you get what's called a benefit or whatever.
You're saying a bridge card is an inalienable right?
I think the right to live, but you're not starving to death. You're not starving to death. Yes.
No, it's not. It's called get a job. It's called go back to the country.
I do my best. Evidence supports it. I've been applying for a job over and over and over. Haven't had the luck, that's all.
They haven't, none of them have hired you.
Well, I'll tell you what, if you have a job, you let me know. I bet I'll be willing to start today to prove I'm willing to work always. I'm not a loser. I'm not someone who's always looking for handouts.
So basically, based on the actual statute, 28 USC 1603, which defines what foreign state is, I find that you're not a foreign state. So section 1604 does not apply to you. And so for that reason, your motion is denied.
And you said it doesn't apply because of why? I'm not clear why.
Because you're not a foreign state. Simple as that.
Did you read the section I put that Corbett for a second on that says that the states of the union.
True.
stand for each
Listen,
other, the relationship
you
between
can,
themselves.
you can cite to that, and that's not legal precedent. I'm gonna look at statutes, I'm gonna look at case law.
Well, I know
Do you even know
there's
what, do
more.
you even know what corpus juris secundum is?
Yeah, I realize it's not, I was gonna
It's
say
not-
binding,
it's
it's
not
not the US Supreme
Right,
Court.
it's not binding, it's not right, so exactly, so I'm not
But-
looking at anything that's not binding.
But I wanna elaborate.
What I am gonna look at is the statute defines foreign state, and that ain't you, under the definition, so.
But.
Because I find that you are a citizen of the United States.
When you're elaborating, but I wanna say there is binding, or does verify that and say the same thing, I just don't have it right now. But it is.
Well, right now, it's when we're doing the motion is denied, so. All right, so those were the motions, the four motions that were in front of me. I've made my ruling on those motions. You're more than welcome to take those up on appeal. Now,
One more.
There's one more motion that
Yeah.
you filed or didn't?
Yeah, it was the same time as the one for the foreign sovereign, or this is demand to dismiss, all these cases based on the lack of presence of the plaintiff at trial.
I already ruled on that, because you talked about, I ruled on it during the trial, because you made the motion during the trial. That
I
they,
don't remember if I did, right,
well, you're more than welcome to order the transcript. I've already made a ruling on that. You basically stated that, that it's a corporation, et cetera, that they, and so I made a ruling on that during the trial, so.
could you refresh my memory? I don't remember what you said on that, and what did you say on that?
I don't need to refresh your recollection. You can order a copy of the transcript if you like. If you're making an appeal, you're gonna need a copy of the transcript anyway. So.
Look, we just go over it now anyways, I like to go over it now and refresh my memory and say what I got to say, and.
I've already denied your motion because it's one that's already been denied. And the same, basically you're bringing up standing and all that, saying that the city of Taylor is not a proper plaintiff to bring a case. And
right,
you did that during trial, so before the trial, actually.
This is a little different than standing. This one I interjected.
I'm saying it was part of all the other motions that you made before we began the trial. So the motion is denied. You can, if I'm wrong, then they'll grant your appeal, so. They probably will not. So, all right. Now, today is the date and time set for sentencing in this matter. And there's a pre-sentence investigation report. Are there any additions, corrections, deletions to be made?
He's asking me if there's any additions, deletions, or corrections that need to be made to your pre-sentence.
Yeah.
So we're going to do it by sections so that we can follow along. Your prior criminal record. I see 1, 2, 3, 4, 5, 6, 7, 8. 8 different things. Is there anything in the 8 different matters? Is there any of those that need to be corrected?
Well, first I want to say they never, they don't refer to me as a living man.
Listen, here's, I'm going to make a ruling right now, once and for all, on this whole living man thing. You literally, I get that you are a living man. You're obviously speaking and talking and breathing. So dead people don't breathe, talk, and do that kind of stuff. So I've already told you that once before. And so giving yourself some sort of new nomenclature, some sort of like, all right, I am the Rasha Bambata of Zimbabwe. But I'll just make stuff up too. All right. Listen, you're Eric Martin. You're sitting here in my courtroom. I know who you are. I'm asking you to tell me, are all of these on the criminal record? Is there anything that's like missing? Is there anything that's added that shouldn't be there? Is there any additions, corrections, or deletions to be made to this section? Simple as that. Answer the question.
Right. Well, actually, that was part of me saying it's not right because
first off, I'm not hearing this whole living man thing. All right. So I just told you that. So go ahead and let me know.
But yes, okay. Well, I'll answer as far as what I say is besides that, it's not factually occurring. Besides that.
So he's asking about these first ones and the convictions that you're challenging.
Well, one, they shouldn't be even mentioned because already been punished for them.
It's a sentencing. This is a sentencing, and I need to know.
Under the double jeopardy clause, they shouldn't even be considered or looked at because already been sentenced and punished for them, so they shouldn't even have no relevance even looking at them really. So.
All right. So, are there any additions, corrections, or deletions? I didn't ask about any actual articulation about it or any opinion about it. Just ask you: Are those past crimes that you had? Are there any missing? Are there any that shouldn't be there because they're not true? That wasn't there. You didn't actually. And I don't want to hear, oh, well, I really wasn't guilty. It was, some sort of, you were found guilty of these things. So by trial or by plea. So
That's the only position I have on as far as I'm not being rated as.
okay, so moving on. The pending court matters. You currently have 3 pending court matters for driving on a suspended license. There's a warrant. You have a warrant, open warrant on that one? Is there an open warrant on that one? Did you fail to appear or something?
No, this thing, this situation. I was.
I don't need, because first off, I'm going to let you know you have a constitutional right to remain silent. I don't want you to speak or anything on an open or pending case. I'm just saying, are you aware that you have a warrant out of Ypsilanti?
Yeah, I heard of it. I mean, but it's not for me. But the thing is, yes,
okay, that's all. Because anything, because I'm.
Let me elaborate on what's going on.
Listen, I don't need you to elaborate because everything in here is being recorded, and they can use any of the facts that you state on the record here.
I'm criminate myself anyways. I just want to say the situation, how it's really illegal because I was there.
I don't have jurisdiction over your Ypsilanti, and I don't know what happened in Ypsilanti, and I don't want to know. I'm just asking, is there any other court cases? You have a Ypsilanti driving on a suspended license, and then there's 2 domestic violence cases out of Taylor here. So are there any other pending court cases that you have that aren't listed here? Is that correct? Is there any additional provisions?
Correctly, yeah.
Okay. Age 51? Is that correct?
That's what I'm saying, but I'm going to say it's,
there was a date when you were living, you had a landlord tenant thing going with your mom inside your mom, and then all of a sudden you were outside your mom.
That's what I've been told, but I was too young to know how old it was when I was born, actually.
Okay,
so it's really hearsay evidence as to my date of birth, because I was born by what someone else said.
All right, so sure. So, but for the best, so basically you don't know whether or not you're 51 or not 51, but it could be possible, but it might not be possible.
Yeah, well, like I said, I was too young to remember.
Sure. How about sex? Do you know your sex?
When I was born.
Sex, male?
So it's really hearsay evidence as to my date of birth.
Okay, I'm moving on from the date of birth then.
Right. Okay.
Sex, male, is that correct?
Yep.
Single?
Yeah.
Children, none?
Right.
All right. So now employment basically states that you're not currently employed. You have been employed in the past, but you're not currently employed. Is that correct?
Well, like it's
just a yes or no question. Are you employed right now, or yes or no? You just stated a couple minutes ago that you don't have a job.
Well, it's the thing. It's not so simple like yes or no.
But it is. It is. I'm either awake right now or I'm sleeping right now. Wait a minute, I'm talking, so I guess I'm awake. So do you have a job right now, or do you not have a job right now?
Just doing Uber on a bicycle sometimes.
Okay, so once in a while doing that. Okay, sure. Education level, it says that, I don't know, you went through the 6th grade, that's what it says, or you got your GED in 2013, is that right?
Yeah, something like that. I couldn't remember. I told him what it is. All right. That was my best guess.
Are you currently residing with your sister and brother? Well, you're not, because you were told not to be in the same residence. So you're living somewhere else?
No answer to that, because that's probably self-incrimination, even if.
Well, because there's a bond condition not to have any contact with the.
Which is illegal, right? Because
it's not. I already ruled on that motion. That motion was denied. So, all right. So, with regard to your summary,
yes. Okay. Now, yeah, I object to the part, calling me a defendant, because, like I said before, one of the summer people, so I just
listen. Here's the thing. I'm just going to say right now, they're just all it is just a word. It's just a word referring to you, because you have to use a pronoun or a proper noun in order to refer to things. Like, I don't know, Turd Ferguson is a tall man with a mustache. I don't know. That's just adjectives. Or I can say that guy is tall and has a mustache. That guy is, so defendant, we're just using it right here to refer to you. They're talking about you. I want to know. And so what about the facts? What about the substance of this? Not into the whole defendant, don't call me this, don't call me late for dinner. So that's what all that is. Just get to the substance of it, like the actual nuts and bolts here. Okay. So is there any additions, corrections, or deletions to make to the substance of it?
Yeah, so, okay, and then, like I said, besides that, where the statement is mentioned, he says, I say I'm a master witch and magician in training. Okay, I did say that.
Okay,
And
so you are a master, so these are
I'm
all
not a
correct
master
statements.
yet in the training, yeah, in the process of becoming.
You're training to be a master magician or witch, or is that the same thing, or?
Well, it's slightly, the witch is one who practices witchcraft, the religion of witchcraft, and magician is strict magical practitioner, but, I'm both, but anyway, so his statement that it's leading to questions about his mental stability, just because I state that, that doesn't mean someone's mentally unstable, so that was totally foolish for him to say that and irrational. So.
Well, they're not making any conclusions. They're just stating, hey, judge, these are some of the things you might want to like just look into. But this is just, the only reason they're doing this report is just to kind of give me a general heads up, just a general feel of what they saw. They're not asking for anything in particular until they get to the actual recommendation part. But the rest of it is just like a report, you know, just as kind of like meet with you, kind of like, you know, that kind of thing. So they're not actually inferring that you are mentally unstable.
Well, he did state, well, the statement's right here. I'm referring to the statement why I say that, because it says leading to questions about his mental stability. Like that leads to the question. That doesn't lead to a rational question whether someone's mentally stable because they're a witch and a magician. That's just total nonsense from even say that it leads to one that even questions someone's mental stability.
Duly noted. What's the next issue?
Yeah, so and then I denied the next thing, that I had a difficult time staying on topic. I deny that statement he put in.
Okay.
So, I mean, me talking about the law, yeah, I was doing some talking about the law, but then like, I couldn't help myself or something, what he's trying to suggest, that's just a bunch of false. That's false, but anyways, what's next?
Okay, what about the being uncooperative with the interview process? Were you being cooperative?
Yeah, I don't know, you know, that's not true, right? And I bet you don't have a record that supports that. Point that out, so these statements are not supported by sufficient evidence.
Okay.
I think maybe I made it said that because I was talking about somebody tried to cut me off maybe, or I just wanted to elaborate more maybe, but I'll eventually answer all his questions eventually, you know.
Oh, I see.
So all I had to do is, I don't know, be a little more patient maybe and my best guess. And,
sure.
But I know for sure I didn't refuse him to answer anything you want to ask me.
What about the felony convictions that you stated that you had never been convicted of any felonies when they asked you?
Well, like I said, I say that based on my knowledge of the law that humans are not really convicted to legal fiction corporate entities that are, that's based on my knowledge of law.
Do you realize that most things are fictions, right? Like what color is your shirt?
No.
What color is your shirt?
It's a greenish blue and black.
Greenish blue. I would have went with greenish blue as well. I would maybe a teal, greenish. It's greenish blue and black. Or it's snarg and flarg. Because greenish blue, even the word blue. You know, words are all fictions. It's just something that we decide to just collectively use so that we can communicate. But it's a fiction. Blue doesn't exist. Like the essence of, like blue is just a word. It's just a description. It doesn't exist. There is no blue. Blue is just nothing more than light waves.
Energy.
See, that's what happens is light hits your shirt and it absorbs every color except blue. Blue bounces off of that material, or at least the frequency, the wavelength frequency of blue light bounces off of it. So now we perceive that color, we perceive that look, but it's not real. It's just wavelengths of light. We call it blue. We call it defendant. We call it a felony. We call it a conviction. We call things because that's the only way to communicate. You got to come up with like an agreed upon word, hence the dictionary, because you always like to refer to the dictionary. That's why we have dictionaries, so that everybody can be like on the same page when we use fictions, because it's all make believe. So when you make those arguments, it doesn't really help. You know what I'm saying? So why would you tell them? So basically, you're not disagreeing that you had felony convictions. You're just saying that in the way you believe the law should be read, is that as a human, I was never actually convicted of anything because I can't be convicted. All right.
I was fraudulently
just making fraudulently. Okay. So either way, but all right. But you can understand how somebody who would think that you're just not answering the question. I mean, you see what I'm saying?
Maybe he doesn't know the law, maybe, but I explained that to him too, though. That's the thing. As he mentions in there, I was talking about the law, so I was explaining things to him to understand where I was coming from. I'm not just saying things that don't have no basis and all this, whatever.
All right. So how about anything else? So that and I see you went and talked about the traveling part and things. Well, anything else in here needs to be corrected, changed, looked at?
Okay, yeah, no, so, well, you know, anyway, so, in response to this question, he said that I don't need a license to drive. I never said I don't need a license to drive. I understand the real legal definition of driving means, and that means, like I said, commercially. As I said before, the federal statute's definition, the U.S. Supreme Court's definition, Hacker versus Banton, says that, not just me. So that's why I denied his statement on that. I never said I was driving, don't need a license to drive. I don't need a license to travel by right, which is done commercially, so, which is doing it non-commercial. So anyway, so I deny that statement. But anyways, in addition, the statement that I blame others for my employment, financial, and family issues, that's not factually occurrent. I don't remember blaming others for it. So that's not a true statement. So it seems like he's trying to make me look bad or something, like making these false allegations.
Okay.
But
any other corrections, additions, or deletions with regard to the report?
No, and I don't know. Now, I was going to say, as far as now the fines, this is more of a legal thing, I guess, but I don't agree. Of course, all these fines that me as one of the sovereign, I am subject liable to it, especially when there's no victim to here. And I got other legal arguments on that. That's more of a legal thing, but fact-wise, that'll be it. But I have some legal arguments as to these fine recommendations based on Supreme law. Finding authority, you want to say, Supreme over this state statutes that
okay.
And that is, are you ready for that?
Yeah.
Okay, so
When you say Supreme law, you're talking about the Constitution, right? Because it's
Constitution, yeah, or
Supreme law of the land, Marbury versus Madison, yeah.
Yeah, and federal statutes that override state statutes, you know, the Supreme. All right, so first, as any fines, 12 USC section 411, federal statute made by Congress, makes it clear the obligation of all Federal Reserve notes belongs to the United States.
Sure.
Therefore,
now, let me go ahead and clarify that for you.
Okay.
That basically just means that when the federal government issues $1, that means it's worth $1 and you can use it for $1, and they're guaranteeing that.
Okay, well, I deny. He was talking.
That's what it says.
Did you say repeat again?
Sure. No, you just said that all Federal Reserve notes are guaranteed by the government. That just means that if I go to pay for something and somebody says, "Well, I can't take this; it's not worth $1," and I'm like, "Yeah, it is," and the government will back it up. They're guaranteeing that it is worth $1. That's what that means. That means that you can use it, because if you didn't have that statement, if you didn't have that statute, you wouldn't be able to use money as currency. It would be useless. It would be like no one would trust it. So if you don't have the government actually backing it up and saying like that's why it says this is a Federal Reserve note. That statute says we guarantee that IOU, that we will pay somebody $1. Somebody will get $1 worth of things. They're like guaranteeing it. Because if they didn't, it would just be paper and it wouldn't mean anything. Who cares? That's why we would need gold then. Because that gold actually has value that you can track. That's all that statute means. But go ahead.
Well, yeah, no, that's still of the position, because word for word, as written down on the site, it still supports my position. I'm not subject to pay no fine, because as it says, the obligation of all Federal Reserve notes is by
right. The obligation means that the bearer. It says
that's
the bearer.
The discharge of the U.S. government. So I'm saying I'm discharging it.
Okay.
Any fine you try to impose, I discharge it and put the bill to the U.S. government.
Okay.
Then also, okay, House Joint Resolution -192 also supports my position on that because there's no real money in circulation. Federal Reserve notes are not real money. The U.S. Supreme Court said that. Because all the gold and silver have been taken away.
Which is why they have to have that statute that guarantees everything, so it makes it real money. So, okay.
But I just want to point that out, so if you frequently find, House Joint Resolution Section 192, the statute is named off.
Sure.
This to be discharged, to the federal government,
Okay.
and also would fall under the Declaration of Independence of 1776 that governments derive their just powers from the consent of the government. So I never consented to pay money, nor do I. And
You realize that that's not a statute, right?
it's part of the Constitution. It's better than a statute. The Declaration of Independence.
The Declaration of Independence is not part of the Constitution.
It's based on the U.S. Constitution, based on that, and I read.
It's not part of the Constitution. It was a letter written to King George. Basically saying, yeah, we're too bad, so sad, we're out of here. And you guys can, you're not gonna tell us what to do anymore. That's what that was.
Isn't the U.S. Constitution based on the
It's not a statute, so you can't cite to it. But go ahead.
Isn't it true that the U.S. Constitution is based on the Declaration of Independence of 1776?
Move on to the next one.
And also, now any action, complaint, transaction initiated by the state, federal agents, or commercial in nature in light of the fact that they impose a quasi-monetary fine in violation of Article 1, Section 10, Article 11, Section 1 of the U.S. bankruptcy. No person shall be imprisoned for debt. I also want to point that out as to any consideration or thought that I should be in jail or prison. Article 1, I'm gonna let you talk. Let's finish my train of thought here first. I'm gonna let you say what I'm gonna say. No person shall be imprisoned for debt. That's Article 1, Section 21 of the Michigan Constitution. So, certainly should be imprisoned for debt. And first I want to say, this so-called crime is really commercial in nature. All crimes are commercial in nature. And what supports that is Code of Federal Regulations 72.11. And if you have any dispute that the so-called crime is not civil in nature, not all about money, then I ask you to dispute it in reference to evidence and law that says otherwise. So since it's civil in nature, you can't be imprisoned for it, and the other reasons I can't be fined for it, none of this should be taking place. Can't be jailed, can't be fined for it under higher supreme law.
Is that it? Counsel, do you have anything to add?
If I just have one moment.
Sure.
And, oh yeah, I want to give him the chance to say anything.
Do you want me to make any actual statutory arguments under Michigan law?
Let me see what you got.
It's a statute.
Do you want me to read it?
No,
Never know.
it's.
As long as it doesn't deny my.
Never mind,
position.
You want my help or not?
Is it going to help my position? Sure, go ahead, let me see what you say. I'll just object to it if I don't agree. Go ahead, say what you say.
Yeah, I have no further argument then. Again, if he'd like a moment to speak with me, I'm happy to explain to him basically the rebuttable presumption under 769.5 for non-serious misdemeanors to a non-jail, non-probationary sentence, which I understand under subsection 3 is the starting point. Subsection 4 allows the court obviously to rebut that presumption and order probation or jail if there's factors that are met. I was trying to advise my client simply what that argument would or would not be, where he can now make the arguments to this court under 769.5 as to why he feels the sentence that he's asking for will be appropriate. I think I know where he's going with this. I'm just trying to move him to the right statute to make said argument, and then allow this court to hear that argument, and then you can make your decision, obviously, with full discretion of what you think is appropriate. So, real quickly, what I'm trying to say, 769.5, subparagraph 3, states that a non-serious misdemeanor is non-jail, non-probation, but the court can rebut that presumption under this other section if they find the basis to do so. Do you understand that?
I do not understand. I do not stand under the state statutes.
Your Honor, my client's indicated he doesn't believe the state statute's applicable to him, so I'll withdraw the argument and just, again, rely on whatever Mr. Martin
Unless,
feels.
well, there's an unless.
This is a tag team. If you want me to make the argument or not under the statute, that's what you're asking for. Then
Well, I haven't read the statute yet. If you did have your thing, I could read it, maybe the statute. Then
I just read it to you.
informed decision on it.
If the court can read it to you verbatim, word for word, if you'd like, I
Sure.
imagine he has it too.
Actually, you know what? I want to pull it up and print it out for you. That way you can look at it. That way you can look
We're
at
talking
it.
about inability to pay. There's a whole different issue. No one has jailed you for inability to pay yet. So
No, I'm just saying,
there's a hearing
just
process.
making the kind of statement now, in case somebody can give them a chance
And I, as your co-counsel, are trying to kind of keep you on the rails for what you legally would be the right way to make that argument. An inability to pay hearing is different than saying you can't give me fines. The whole debtor's prison, what you're talking about, you're kind of on the right track, but you're not arguing correctly. If that makes sense. Okay.
How's it not correct when it is correct? Constitution.
What I'm trying to tell you is it's legal to impose fines. Your argument about whether you can pay them or not would be a different argument. So these are the applicable subsections 3, 4. And Your Honor, we're still waiting for real guidance from the Court of Appeals on what some of those factors that are in that rebuttable presumption. I've appealed, I don't know, half a dozen.
I think the whole statute personally is unconstitutional because it usurps power from the judiciary as the ability to. There's a statute that the legislature can pass. They can put the fines and costs. They can put what the parameters of punishment are. 93 days, 90 days, 100 days, 5 years, put whatever you want on it. And then it becomes my job to decide what it should be. I still think I think it's unconstitutional.
And I feel like the only reason it facially even passed was that that subparagraph bounces it back to you guys without any real guidance. As to what that exactly.
Again, I'm not even sure that they should give guidance in that because that's still the prerogative of things. So
it feels, I guess, best like a poor attempt at mimicking the sentencing guidelines. Maybe I don't know where they're going with it, but I know that in district court we've been getting a lot of appeals out of this exact statute. So you and I don't stand alone in our feelings about it.
I am going to call people of the city of Taylor versus Aaron Drake while you're reading that.
Thank you, Your Honor.
So there is no real money in circulation anyways, as said by the US Supreme Court, so I couldn't really pay it anyways. Technically like that. So it should be discharged, again, I repeat myself on this one, but be discharged under House Joint Resolution -192, any so-called debts. And 12 USC Section 411, it should be discharged. And that's what I have to say on that matter.
All right. Counsel, was there anything you wanted to?
Just very briefly, Your Honor, I'd like to point out that this is a non-violent offense, that this individual has availed himself to the court, albeit a little bit late. He made the effort to get on the bike and get up here. Those are the positive factors I'd like to point out to the court before sentencing.
All right. So having taken everything into consideration, here is my sentence. I am going to sentence you to 12 days in jail. And here's why. First off, I want to waive the fines and costs. I'm not even going to bother with the fines and costs. You're unemployed right now. You're looking for employment, so I'm not going to put an extra burden on you when you're already trying to feed yourself and whatnot. So I could, but I don't think it's necessary. I am going to sentence you to 12 days in jail, and here's the reason why. First off, I think 12 days is more than reasonable. This is a penalty that could be up to 93 days in jail, and this is 12 days of jail. There's a couple of reasons why I'm going to give jail time. So I'm going to state these on the record to satisfy the statute. First off, I look at things like mitigating factors. I look at aggravating factors. You have a conviction for operating on a suspended license in 2022. You have a pending one, and I'm not worried about that one, but there's something called malum prohibitum. Basically, it's just acts that we as a people put into a statute to say that we can't do certain things. And you just don't recognize common decency and societal norms when it comes to that stuff. There's also ones that say, hey, you can't go around slapping people. So we don't. I'm glad that you don't do any of those because you're like, well, you know what? I'm a sovereign guy. I'll slap whoever I want to. I mean, I'm glad that the worst of it is you drive on a suspended license. But we need to have that kind of recognized common decency with one another, because what's the whole point of electing representatives to service in the legislature? What's the point of having an executive branch who's there to keep the peace and to keep things flowing, to keep everyone safe? If we don't have rules, especially rules of the road, if everybody could just blow a red light because you don't feel like waiting. I'm a living man and I won't wait for a red light. That'd be the last time I wait for anything. I don't think so. Everything would just devolve into just chaos, especially on the road, for God's sakes. The fact that you have no, zero remorse, zero acknowledgement of responsibility for your actions, where you literally come up with any sort of, let me Google whatever, blah, 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 and I'll just try to throw people off, and maybe they'll just get so tired of hearing this jibber jabber of legal arguments that are none of which stand correct, that maybe they'll just get tired of it and just be like, you know what, just dismiss the case. I'm tired of dealing with this. I'm never tired of dealing with this. Why? Because that's literally a breakdown of our society if I do. And to anybody out there who would just dismiss it because they're just like, oh, I can't stand even listening to this. That's not doing their job, and I do my job. That's what I do. I swore an oath to the Constitution, and man, I'm going to keep it. Because that's my contractual obligation as somebody who reaps the benefits of living in a free society, that you give up a little bit of control to a group that we all agree to, the legislature. Hey, make some rules for us so we can all travel and do things. Make some rules for us so we can have commerce and pay for things with checks and credit cards or cash. And they have all these rules that we're just going to recognize, and you don't recognize any of them. I don't know where sovereign citizen land is, and if they have an amusement park, I don't know. But man, they sure have a carnival. I know that, because they serve Kool-Aid, and this Kool-Aid is dangerous because everybody drinking this Kool-Aid is just hurting themselves and others. Because what happens if you get out there and you're driving on a suspended license and you end up killing somebody? And if you had just followed the law, you wouldn't even be on the road. You'd be looking at a very serious natured felony. And so this is just a continual, I don't care what you say type of an attitude. And trust me, I am all for logical arguments. I am all for the people watching their government. What form of government did you give us, sir? Franklin says. A republic, ma'am, if you can keep it. If you can keep it means you got to pay attention. And I'm all for you pay attention to the government. Put eyes on them. What are you doing? Hey, officer, what are you doing over here? Hey, senator, what are you doing over here? Hey, mayor, what are you doing over here? I'm all for it. Because you'll lose that. We'll lose our freedoms if we don't. And human nature is, man, you give somebody a pen and control and a piece of paper, man, they'll write themselves just like Animal Farm. The pigs will be living in the house, playing cards and drinking whiskey. So you got to watch. I get that. I respect it. But I'm also not going to let a farce. I'm not going to let some sort of just absolute farce of a legal show happen. And by legal farce, I'm talking about the fact that you literally think that this is all a joke, that there's no laws apply to you. I'm just interested, what happens if you go to a meeting of all your sovereign citizen buddies, right? Let's say there's a bunch of living men and we're all living up in here and we're having a meeting and we're going to play some cards or whatever, bingo, I don't know, whatever you want to play. And you got them all around the room there. I mean, they're all there. Mr. Martin, you're there. You get this one goes over here. Turd Ferguson's over here. He's coming in. He's a sovereign citizen. What happens when one sovereign citizen guy besmirches the other? Like, let's say you're arguing about what's the best color. I say teal is the best color. Blue green's the best color. They're like, no, red's the best color. Someone gets slapped. What do you do then? Because if you guys with all these, we don't answer to any laws. So what happens? Then the other guy just sits to kill the other guy, or you just fight it out to see who's stronger. And well, he was weak. He had to die. I mean, like, if there's no rules, if nobody has any acknowledged participation with one another, then what is the point? What's the point of living anywhere near anybody? I'm going to move as far up into the UP as I can and build a treehouse on like 1,000 acres. And anybody comes anywhere near, I'm going to put signs up that just say, don't come any closer, like 1,000 yards. You're just going to, like, you're going to put mines and stuff so that you don't ever have to deal with people. It doesn't make any sense. We want to live together as a free society, but society means people all coming together, doing things. And I'm all for exercising your rights. Man, you have all your rights and you should exercise them. But when your right stops, that imaginary wall for me is where my rights start over here. As soon as you start moving into someone else's territory, it's it, done. That's where it stops. And so for you, I get it. You say no harm, no foul. Do I agree? Yeah. Do I think that the driving on a suspended license statute is anything but an ATM? Absolutely. But I didn't make it. I'm not the legislature. I didn't write the law. I didn't write the law. I follow the law that's given to me to use. Do I think that it's just there so that the government can keep track of everybody and take a picture of you every 3 years and follow you and make sure they know what you look like, where you're at, where you're living, what are you doing? Absolutely. Do I magically forget how to drive the day after my birthday if I didn't run over to the Secretary of State and wait an hour in line to get that renewed? No, still know how to drive. They just need that license money. Sure. But also, I need my roads fixed. I need Michigan State police officers. I need a place to go and vote. I need all the other services that the state of Michigan gives to me that I like. So in exchange for that, as much as I'm like, really, seriously, I'm a great driver. Well, who cares if I have my driver's license? It's because we need to, one, make sure that you're still good to drive. Check your eyes. I didn't always have to check the box where I need these to drive until I did. But we don't want people who can't see. If I'm squinting, I can barely see if you're coming. I don't want you on the road. We need those rules. It's mandatory that we have those rules in order to have a free society so that it doesn't become chaotic. And that's what you do. That's your ante. That's your small blind, big blind right there that you put in to say, you know what, I want to play this game. I want to be part of this society. I want to have all the benefits that come to me. But you know what, if there's a small, price to pay that I got to go get a license and that they're going to charge me for that, or I'm going to pay some taxes when I go and buy this, or whatever the case may be, because somebody has to pay for that. Somebody has to come pick up the garbage. I need police officers that keep me safe. I need all these services. It doesn't just happen. It doesn't just like, hey, there's 100,000 people who are saying, I'll just volunteer. You don't have to pay me. I'll be a police officer. Yeah, I'll go around picking up trash. It doesn't happen like that. And we want that. We need that. We need those protections. Or it's all going to just become chaos. And you just refuse to it's not even to refuse to participate. You refuse to even recognize that it exists. When someone tries to help you have counsel here, trying to show you something that was literally the one thing, the biggest, most powerful thing for you today was that statute. As far as not, hey, judge, just saying there's a statute kind of says, if it's one of those misdemeanors that are like, did you do that? Yeah, sure. You're not going to lose your job. Nobody cares. Nobody's going to be like, you criminal, you're evil. No one's going to call you the Joker. No one's going to do any of that. one of these small time little misdemeanor type things. There's a statute for that they say has a presumption. Presumption doesn't mean it's going to happen, but a presumption that, you know what, we really shouldn't waste the jail time space for these kind of guys. He's literally trying to point that out to you. You're so concerned about, you won't tell me anything. No one will tell me anything. Well, I'm telling you something. You're getting some jail time. So while you're in there, maybe think about how this process for you that you keep using doesn't work, and it keeps not working. All right? And I'm not going to get into Einstein and what he said the definition of insanity is, but keep doing the same thing over and over and expecting a different result, but you're not. It's not gonna. So, Officer Kemp.
Sir.
All right, this is 242448 SM, the People versus Eric Martin. Mr. Martin, can you tell me your name?
I'm a Roman cystic that's what you're wondering.
Okay, I recognize Mr. Martin. Mr. Martin, it's my understanding that Mr. Coots, an attorney, a defense attorney, attempted to meet with you to go over your rights and that you did not want to meet with him. Is that correct? Yes or no?
Well, at first I did, and then I kind of changed my mind. I'm still in the sense of not giving you guys the fraudulent presumption that you got jurisdiction over me when you don't. That's why I don't want to take it, but
so no.
I get kind of friends too, because
I'm going to mute you so I can tell you your rights, Mr. Martin. I need you to listen. So here are your rights. You've been brought to court on an allegation of a bond violation. Specifically, you currently have a domestic violence case pending at this court in front of Judge Slavin. And on that case, the complainant is Kirk Martin. There was a no contact provision. And that was one of the conditions of bond. And there is an allegation that on December 14th, so just this weekend, that someone called from the residence of Kirk Martin and indicated you were in the home. And the officers alleged that you were, that they checked and that you had bond conditions out of this court saying you weren't to be near him. And that you were taken into custody for violating your bond conditions of no contact with Kirk Martin. These are allegations at this time, but they're serious allegations in violation and no contact provision. So do you want me to enter a plea, or do you just want to ramble about jurisdiction? I'm going to ask you to unmute so you can answer my question. Officer Ziegler, I'm sorry, can you unmute? Mr. Martin, you have options, so you understand that's what you're here on. You can plead guilty, not guilty, or you can say nothing and I'll enter a not guilty plea on your behalf. So to the allegations that you violated the conditions of your bond for purposes of arraignment, how do you plead?
first I want to notify crimes. Before I get to that, I want to notify crimes committed against me in the jail here since I've been here, such as criminal harassment.
Okay, I'm going to enter a not guilty plea on your behalf.
I'm not going to talk.
But your answer is non-responsive.
Violating my First Amendment right, freedom of speech. And this whole bond order condition, it violates my due process right to be free at my house, which is based on an unsupported lying allegation by my brother. Therefore, this is all a violation of my due process rights. The bond order should have never been done. This is all unconstitutional. The case should be dismissed, and I demand to be dismissed. Now.
All right, so sir, you have a right to a hearing on this matter. You have a right to receive written notice of the violation. You have a right to plead guilty, not guilty, or stand mute. I've entered a not guilty plea on your behalf since your response was non-responsive. You also have a right to contest the charges at a hearing. You do have the right to the assistance of an attorney at all subsequent court proceedings, and you can change your mind at any time, Mr. Martin. You have the right to have that a lawyer appointed at public expense if you are unable to afford an attorney, and it's always possible that if the court determines you were able to pay, that you would be required to contribute to that cost. If you continue to proceed without an attorney, you would give up your right to a lawyer's assistance. We will set the hearing. I'm required to set that hearing on that violation. If you are in custody, we must hold it within 14 days of the arraignment, which is 14 days from today, or the court must order you released pending that hearing. If the alleged violation is based on a new criminal offense, that is basis for separate criminal prosecution, I don't have any knowledge that that's the case here. The court could postpone the hearing for the outcome of that prosecution. You have a right to contest the allegations against you. You would have a right to have the evidence against you disclosed. You'd have the right to present at the hearing, or to be present to present evidence, to examine and cross-examine witnesses. The court would only consider evidence that's relevant to the violation, but it need not apply the rules of evidence except those pertaining to privilege. The prosecuting attorney would have the burden of proving the violation by a preponderance of the evidence. If you pled guilty, you'd be giving up your right to a contested hearing. And while this case is pending, you could be, the most severe violation is you could be held pending the hearing, and if found guilty of this violation, you could be held while this case is waiting for jury trial. So those are your rights, Mr. Martin. Mr. Martin, I understand your sovereign arguments. I mean, it's fine. You can make them. I've heard them before. Everyone at this court has heard them. But here's the thing. I can't have you, if there is a no contact order and you continue to violate the no contact order, I can't let you out. Because you're not listening, and I know you don't think you have, because you don't. Okay, well, you do. This is in accordance with the Constitution, and okay.
And deprive him of the liberty right to be home because of an unsupported lying allegation. I'm telling you right now, he told a lie, and I told the prosecutor my brother assaulted me in actuality. First and foremost, he assaulted me. But I have no evidence of it. I don't have him on video evidence. He doesn't have me on video evidence to assault him. So we have my brother saying this, me saying this. We don't know what happened in reality. So the dumb cop should never arrest me. Prosecutors should not be moving forward on this. They're moving forward with it. It's already a malicious prosecution on the prosecutor's part. There's no probable cause because there's no evidence here. Bottom line, we don't know what happened. This is violating my due process rights. I'm being deprived of my freedom to be at the house I've been living at for 32 years. The bond order was legally should have never been ordered because it's based on, once again, unsupported lying allegations. It has no video evidence, no real evidence to support it. The bond order must be dismissed. I'm supposed to be allowed to go back home where I have a right to be. Doesn't matter how many lies you're told.
Let me tell you your bond conditions, Mr. Martin. You're to appear in court as directed. All right, I'll mute you and read them. Whether you like them or not, these are your conditions, sir. So I'll just read them into the record and you can choose to listen or not listen. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Whether you like it or not, You don't have to have any contact with Kirk Martin or the residence where he resides and where this original allegation occurred, which is in the city of Taylor. Sir, you cannot purchase or consume alcohol or illegal drugs. You can't possess or have access to firearms. And you have a $2,000 cash bond. I've noted on the file that you're entitled to this hearing forthwith. So the clerks will give you a date forthwith. And we're all set.